All right, the jurors.
Thank you, Deputy Gordon. Good morning, ladies and gentlemen. Oh, hold on. There's two problems. All right. There is someone on the Zoom call. It says Inga Pup 4017.
That would be me.
Who said me? Oh, you. Okay. You can call it what you welcome to stay on there. I just didn't want. I recently had a bad experience where someone joined the Zoom and then started saying things that people shouldn't hear. As in like kids shouldn't hear, not that the jury shouldn't hear. Then we had to throw them out. So we make sure, not this case. Okay. You can later explain to the jury what Inga Pup is. That's a little interesting. Yeah. They're a patient group. All right. You can take a seat. You were sworn in yesterday. You remain under oath from yesterday. But before we resume Mr. Pye's cross-examination of Mr. Ibezim, first, thank you for the smart food. Second, we have a new technician here from Veritex, Mr. Casanias, playing the same role that Mr. Alston was, but you may notice there's someone different with headphones on. Third, I need to talk about something that happened yesterday. You may recall when I was chatting with you Tuesday morning about how trials flow. Every once in a while, I might have to tell you to disregard something you heard. I'm going to do that now. There was a brief exchange that you may recall when Mr. Ibezim mentioned that he had more recent videos. And Mr. Stewart started to say something about, yeah, but these videos, I need you to disregard anything about more recent videos. This case was brought in 2019, and the three sides have had years to put together the evidence they're going to use. And no one gets to drop evidence in at the last minute that hasn't been exchanged amongst the parties. So the videos that you've seen come from 2018. Those are the videos. There are no more recent videos for you to consider. You shouldn't assume that they were videos that would show Niagara Falls in the backyard, or it's simply a faucet going drip, drip, drip. Don't think about what was in those videos because they don't exist for purposes of this trial. Mr. Ibezim wasn't doing anything wrong. It just, that shouldn't have come up. And there will be no more discussion about whether there are more recent videos. The videos you've got are the videos you've got. And those are the ones that plaintiff has elected to use in this trial, for which they've been litigating for 4 years now. Those are the ones. And we'll move forward with that. Mr. Pye.
Good morning.
Good morning.
I believe yesterday we left talking about the fence. And I believe perhaps your final comment was that you kept the fence gate unlocked at all times.
Unlocked, correct.
Mr. Ibezim, do you mind removing your mask?
I'm sorry.
No, it's not. Don't apologize. As long as you're comfortable with it, we can hear you a lot better.
All right.
Thank you.
All right, so it remains unlocked.
Unlocked, correct.
And that means that the homeowners association has access to the patio and backyard area for maintenance, correct?
They always had access, correct.
Okay. All right. Now, we've talked about the fact that you filed a warranty claim, which included the water claims through the builder's warranty.
Correct.
And that the result of that was the builder was willing to do some things, but not anything dealing with the water. And you were advised that you had the right to appeal that. And you determined that you did not wish to appeal the warranty claim against what the builder had done, correct?
Correct.
Okay. So that's, I'll say, matter number one. Matter number two is you and your wife actually filed a lawsuit in the Superior Court of Gwinnett County concerning the water issue, did you know?
Correct.
And I will show you exhibit 32 and 33.
Yes. Yep. Keep going, Mr. Pye.
All right.
Just ignore Vanna White there between you and the witness.
John, I said I was Mr. Cloud's bag carrier. For these purposes, he's my bag carrier. Okay, you have before you Defendant's Exhibit 32 and 33.
I have 32
32.
and I have 36.
And this was a lawsuit that you and your wife filed pro se, so to speak. You did not have a lawyer. And it concerned the water issue. But you did not sue the builder in Gwinnett County, did you?
No, I did not.
Okay. You sued Mike Tolley and Sean Smith.
Correct.
Now, Mike Tolley is connected with the backyard, the maintenance company for the HOA.
Tally management, correct. Yes, same.
And Sean Smith, we know, we've heard his testimony, he's the president of the HOA.
Correct.
You did not sue the HOA, you sued the president of the HOA. And you did not sue Backyard Realty Group, you sued Mr. Tolley, the principal of Backyard.
That's not correct.
You say it's not correct?
It was revised. This wasn't the only.
All right. I should say you initially sued Mr. Tolley, but then you amended your complaint, and that's D33, to say Tolley Community Manager.
And Sean Smith, HOA.
All right. And you amended to show Mill Creek Lakes Unlimited Association.
Correct.
So you figured out that from your standpoint, it'd be better to sue the entities, the businesses, rather than the principals of those businesses.
No, I didn't have no legal standing. I didn't know. I just wanted to get it out there, let people know what's going on.
And as you said, this was a suit, and we'll just say against the HOA for the water issue. And you later withdrew that suit.
Correct.
You went to a lawyer, and I don't want to ask, don't want you to tell me anything the lawyer said, but after you consulted with the lawyer, you withdrew the suit against the HOA, and you filed this suit against the builder, right?
And that's not what happened, how that happens.
Well, let's take it one step at a time.
Okay.
Filed a warranty claim against the builder's action.
Yes.
You did not appeal the results of that. You filed a suit in Gwinnett County against the HOA and withdrew that suit. And then you filed this suit against the builder. WEG, Mill Creek, and Water's Edge Group. Right?
Okay. Yes.
Okay. All right. And so this is your, shall we say, third bite at the apple?
Third bite, I don't understand, but I don't, what do you mean by third
Well,
bite?
I mean, this is your third attempt to deal with the water issue that you think you need to deal.
This is only my first attempt legally.
You don't consider the warranty claim and the suit county attempts.
No, I was just trying to get out there because I didn't know else way to do it. I called prosecutors, I called the GBI, nobody had no jurisdiction over builders.
I understand you did not.
Mhm.
But what you did do was make 3 attempts. This is the third attempt.
Mhm.
And here we are 4 years later for resolution of the third attempt.
By not my doing, or it's not by my doing. I wanted to get in fast as I could, but COVID happened, delays happened, court dates got changed.
I understand that since you filed this suit, Fulton County is the busiest county in the state, although Gwinnet's pretty busy.
Not as busy.
Sure.
I said, not as busy.
But it's being handled exceedingly efficient in Fulton County. But we had COVID, and you can't have jury trials during COVID with everybody shoulder to shoulder. So I understand the delay. I'm simply saying that you had an opportunity to deal with the issue by appealing the warranty decision or by continuing in Gwinnett County. But you chose not to do those. You chose to bring this lawsuit.
That's not true.
Okay. And you found a lawyer who was willing to take your case without getting paid current.
Didn't find them, I was recommended.
Okay. And so your agreement with your lawyer, there's a so-called contingency fee.
Correct.
And you don't even have to pay currently the expenses, the filing fee, the expert fees, et cetera. He pays it.
To my knowledge, yes, correct.
So you have not paid any legal expenses, lawyer fees, or other expenses in connection with this case.
I have a lot of expenses that I paid out, indirectly.
You have not paid the legal expenses in this case to date, have you?
Out of my pocket, no.
You may be obligated for them with your lawyer,
Mhm.
but you haven't paid them.
Correct.
And I believe the explanation was the 40% contract that you entered into meant if you lost the case, you didn't have to pay.
To my knowledge, correct.
Your lawyers.
Correct, to my knowledge.
All right. The previous rulings of the court, we have identified defendants 32 and 33, but as I understand it, they are admitted for the record, but not for the jury.
Correct. So 32 and 33 are admitted, made part of the record, won't be going back with the jury. Those being, as I understand it, both from your evidence list and what you said, the original complaint that the Ibezims brought in Gwinnett and their amended pro se complaint.
That's correct.
Okay.
Now, at about the time that the lawsuit was pending in Gwinnett County, that was a fairly short period of time. About that time, the homeowners association did some work on your property.
No, at that time, I don't think I even filed. I was threatening to file. I didn't file yet.
I don't mean to say file the suit was pending or I'm saying around that time, maybe before, maybe during, maybe after, but during that time in 2019, in the summer of 2019, the HOA did some work on your property. didn't it?
Correct, yes.
Okay. And that work included putting a pipe from the drain from your gutters down, leading the water from the gutters out to the underground water system.
Correct.
Okay. And you've heard the testimony, you don't dispute that that cost the homeowners association about $6,000.
I think it was introduced to evidence yesterday. I seen I think it was $6,000,
Yes.
but that wasn't a correct invoice. Huh?
You do not dispute.
I do dispute it.
You dispute how much they paid?
I don't
for that
just,
work?
I'm not sure. That's hearsay because I don't know how much the check was. I don't have the checks in front of me.
That's why I said you don't dispute it. You don't agree to it, but you don't dispute it.
Correct.
All right. Now, during this period of time before well, let me ask you a more general question. You are aware that several investigations and reports about the condition at your house have been made by various contractors or experts, aren't you?
No, I was not aware. I was not
You're
aware.
aware now.
Yes.
Okay. You say you were not aware then.
No.
Were you aware that the homeowners association considered reports from experts and proposed to adopt some of those remedies?
I hear testifying, people testifying now, everything's coming out, so I hear everything now last couple of days.
All right. And by that time, you were not concerned with the builder responsibility because the builder warranty had expired. Is that right?
That's not true.
Okay. All right. Let me ask you some questions about some communications between the parties.
Okay.
In no particular order.
What exhibit are you looking at?
You have exhibit 36. It's an email from you to L. Stewart,
Do you even read it? Because this looked like it's redacted.
D36.
I don't want you to read anything.
Oh.
He'll ask you what to do with it. He wants to know if you've got it in front of you.
Yes, yes.
Okay. This is an email from you to L. Stewart. Who is L. Stewart?
That is my lawyer.
Okay. And you produced this during discovery, correct?
And my lawyer did, yes.
Offer of the defendant's exhibit 36.
Any objection, Mr. Stewart, to 36?
I apologize. I thought that amended complaint was 36. Is that
That was 33.
That was 33.
a minute? Okay. Remember, I had 36. No objection, but I think he needs to read what he. All right, no objection, Your Honor.
Okay. Mr. Dorsey, any objection to defense 36? Admitted.
All right, looking at the September 17 paragraph, which is approximately the middle, it says September 17, 2020, says 2.5 years ago. Fence, the flow slowed down somewhat because of drainage. Can't be problem was supposedly inspected by HOA structure committee. You are saying that your fence slowed down the water flow that was coming through the swale?
As it stated here, I do not recall this email as it's listed, because this is not my July. Can I talk about this? Oh, no.
He's asking you about.
All right, so this is redacted. This is synopsis of every email I had, because I didn't put these dates, September.
Can we put it up on the screen?
Please.
Ah, look at that.
Yes, I did not put those dates there, so this is not my email.
But it's on your email address, Chris.
Can I have the whole email, my original email,
Yeah, and
not just the heading?
that's here.
Yes, and you could tell by the line that's copied and pasted and added on.
So you need to not interrupt them, let him
Okay.
finish his question, and then you can talk about people modifying your emails.
Right. So their responses to your initial email, correct?
Correct.
And the response underneath the July 18 date is the erosion is severe, and then the next paragraph, that's your response in the back and forth, right?
In this paper, yes.
Sir?
In this paper, yes.
Okay. And so you are saying that the fence slowed down, the water flow slowed down because of the fence.
Which one are you looking at now?
Well, read the whole thing if you like.
Okay, I mean, it's
Let's
all over.
read the whole thing.
Okay, please.
Fence, the flow slowed down somewhat because of drainage. Can't be problem was supposedly inspected by HOA structural committee. To approve ACC request for fence, they said as long as I keep a 1 inch from ground. I built fence to protect us from the raging river water from upstream.
Correct.
So no more questions yet. Did you write that, or are you saying that's someone else's words?
If it's here and it's probably a context of it, I pretty did write it, because I did use that raging water. That is my saying, raging water. Correct.
Okay.
Now, what we have here,
So you can't testify. If you want to make an objection, you can make an objection. You could redirect, but it's not your witness right now. Do you have an objection?
I object that this is not a document that was produced and it's been modified.
That's a pretty heavy claim. Do we need to send the jury out? Or do you have if you want to respond to that, Mr. McLeod, I trust you weren't modifying emails that were sent.
No, Your Honor, that came directly from plaintiff's discovery.
Okay, so what are you saying, Mr. Stewart?
Can I approach the bench? So that way we won't. say
Do we
something.
send the jury out? Are you saying that what's on the screen is something that's been edited? You produce something different and it's been modified?
There were several texts produced, and these are different texts that they put together apparently and listed out. These were not sent to them in this form. I'm not doubting that the wordings are from the plaintiff himself.
How did you provide the text to the defense?
Actual copies of the text. Where there's screenshots from the text. Now they've taken them and they put that and they line them up, pick and choose the ones they like or want to use. That is not how they were produced in my office.
So you're saying it may have been reformatted, but it's also incomplete in the sense, I'm making this one up, but there may have been a September 16th, 2020 text, and we don't see it on this screen.
Yes, there's probably 80 to 100 texts that went back and forth.
Okay, Mr. McLeod, response?
I don't know what to say, Your Honor. We haven't altered anything. This is the form of the document that was produced to us. If we need to go back. In fact.
Can I have the exhibit for a minute? Because it may have, if there's a bait stamp on it.
There's not a bait stamp on it, but Your Honor, I do have, I believe, I think I've got the original zip drive that Mr. Stewart sent to me that contains this document.
Okay,
I mean, if we need to go all the way back to the beginning to see where and how it was produced, I'm happy to do that.
here's my thought. Mr. Stewart, I'm going to let Mr. Pye continue to ask questions about this. If we find during a break that this is what you produced, you're going to explain to the jury that you were wrong in saying it that way. If it's not what you produced, then Mr. McLeod, you'll explain to the jury that not that you changed the words, but you have selectively put together some of the text exchanges. But I'm not hearing Mr. Stewart say, these aren't Mr. Ibezims' words. So on redirect, he'll have a chance if there are texts somewhere else that everyone has. Well, what about this one? Okay, rather than pausing.
Now, I think what Mr. Stewart said is that he produced the email chain, which would have lots of communication. We are not required to put in order to prove one communication, put 100 in.
I agree. He said texts and not emails. I thought that meant texts when he said the word text. I appreciate that this is an email and not a text, but I have to rely on what Mr. Stewart's saying, and he said texts. More importantly, this is a hard copy document. And so all I want to know is that something that Mr. Stewart produced in this format? If he gave you 30 pages and you're only putting up one page, Mr. Stewart should sit back down. But if he gave you something electronic and you all have rearranged it, you just need to identify it as such, because that would explain Mr. Ibezims' confusion that he wouldn't have seen something that looks like this. But if this is how it was when Mr. Stewart gave it to you, he'll explain to the jury that he made a mistake in saying you all have modified the discovery. Okay?
Thanks. Yeah, just for your.
Yes.
My understanding of this document is that it was an email from Mr. Ibezims to his lawyer. He could check his email if that's possible to see if he has the.
It's sure what it looks like. So there are a lot of ways we can cross-check this. I'd like us to press on with the examination.
Well, pressing on. Raging river water from upstream. At least at this point, you consider the swale behind your house as a raging river. Well, perhaps when there was a heavy rain.
All right, I gotta think about this now. So
Those are your words, aren't they?
yes. Yeah, that's my word.
And one of the reasons you requested and put a fence in your backyard was to protect your yard from the raging river. Right?
Correct.
And in fact, you installed your fence building. Put the fence partially in the swale where the raging river was. Right?
Not correct.
Do you dispute that your fence is partially in the swale area, the common area?
I had no control where I could put my fence at.
I'm asking you about control. I'm asking you if you will not admit to this jury that the part of that fence is in the swale.
Now, after the evidence, after the testimony, yes, I know where the swell is. It's in the swell. Yes, the fence is in the swell.
Part of the reason to construct the fence was to block the water from the raging river.
I gave testimony on that yesterday. It wasn't from the water river, it was from the breeze, the branches, everything you've seen from the pictures, everything that was coming up from upstream. I never said anything about the water.
Well, you didn't say it yesterday, but is that not what it says right here?
Yes, it does say that.
Okay.
Yes. But I don't know what context it was in. It looks like snippets, sir. That's what I'm saying. I didn't put September 16th, September 17th. So I know it's snippets, but I didn't have emails. I never emailed this. I have text messages. If you look at the exhibits, you'll see every text message that it is. They're picking and choosing, just like I did with the warranty.
Okay.
Well,
But those are your words, not someone else's. I built fence to protect us from the raging river water from upstream.
Yes,
Okay,
yes.
thank you. Hold on one second, Mr. Dorsey.
I can resolve this issue. I can go ahead.
I will, if so we can get closure on who sent what to whom.
Mr. Wilson just pulled up plaintiff's responses to our written discovery. As you recall, you reopened limited discovery. There is a no November base number, by the way. So you asked about base number earlier. There were 180 pages of PDF documents produced. Page 135 of the PDF, and may I approach just to show your honor?
You can show Mr. Stewart. You don't need to show me.
Page 135 of the documents produced are exactly what's on the screen.
That came from me directly.
That came from you and your discovery responses, exactly like that in that form. Would Your Honor like to review it?
Mr. Stewart, you've reviewed it. Is that something you produced?
I might have produced it, but I didn't make it. Well, may-
So
may I
did you have the
explain?
defense make it and then you gave it to the third party defendants?
Well, the defense were asked to produce all the documents too. They said all these documents, they took our, only thing I ever gave them were text. They lined it out and they said, produce all documents for part, and I sent the document. Apparently I sent what the defense had prepared or whatever, because
But
I
the
never prepared these
document
documents.
has, it's an email to you from your client.
But that, not the whole thing, just the top part was for my client. The rest that was added to it, and I did not do that. It
Okay.
was that way when I sent it to, maybe it went to their way. All I did is took everything they gave me. They said, what document you have? There's over 2,000 documents in this case. And so what the defense gave me, I sent to them, but I never modified his text. You can take his text and they'll match this exactly what it says there.
To kind of wrap this up, there was no written discovery conducted prior to my involvement. I was
Oh,
the
no.
only and first person to conduct written discovery. This was a response directly from plaintiff's counsel in the exact form because it was produced electronically on a CD. This did come from them and it was not altered or created by anyone, at least at my table. I can assure you of that.
Okay.
And there was no discovery conducted prior to this, so I don't know how it would have got to him.
Because the defendants had produced documents to us. We had things before lawsuit.
All right, Mr. Stewart, I'm unpersuaded, but we're gonna press on.
I believe I offered to finish 36 years.
You had, and it's in.
All right. And your words in this document refer to a 1 inch from the ground space.
Correct.
You testified yesterday that 2 inches was required.
It was required, correct.
Did you do 1 inch or 2 inches?
I did 2 inches. I didn't make the schematics. The builder did it.
Why did you say 1 inch?
I probably misspoke. I'm not a professional. I probably misspoke.
Defendant's exhibit 18. And is this an email and or text, copy of the text, dated September 9, 2018,
Correct.
and it's from you to Ibezims family 8. What is that?
It's to me, to my wife.
Your wife, okay. And then it looks like it's attaching at the top an email from you to Mike Tolley and others. You are attaching your email to your wife and sending it to Mike Tolley.
It looks like a chain email, so this is not all of it.
So all you can do is talk about what's in there. I mean, I want to be clear. You can talk about whatever you want.
Yes. Yes.
We're limited to whatever's in there. You
All right,
are
let me
free
read
to
it.
highlight
Let me
to
read it.
the
Okay.
lawyer and the jury,
Okay.
hey, there's something missing. And then that's something that could be explored. But
All right.
whether it's a chain or not, we're limited to whatever
All right.
that
You're right.
particular
All right.
exhibit is. And then they may need to show you more.
Yes.
So I offer a defense exhibit 18.
Mr. Stewart, any objection to defense 18?
No, Your Honor, and I would like him to read who he's always sent to. There are several people on this exhibit 18.
So he doesn't have to do anything he doesn't want with it. It will be published likely, and then you'll be able to redirect. So again, you control your questioning. Mr. Pye controls his questioning. Any objection, Mr. Dorsey, to 18?
No objection, Your Honor.
All right, 18 is admitted. If you want to publish it, you can publish it.
Top of the document. It's an email from you to my colleagues and others. And you send pictures and videos and you say what you have said. And then you address something directly to Sean, who is HOA president, correct?
Correct.
Do the right thing. After smoking gun, you were informed, and on new repair list, none of phase 2 is being addressed, big cover.
Correct.
You believe that the homeowner association was engaged in a cover-up
Both of y'all was based on cover up.
and the builder as well?
Correct.
Everybody's covering up.
Correct.
Okay.
Mr. Ibezim, this email actually says from Tia Ibezim. You explained yesterday, sometimes you used her email
Correct.
address.
Correct. Yes.
Are you the author of that initial paragraph that was sent to Mr. Tolley and all the other people we see on the screen that included with it an email? It looks like you kind of wrote to yourself. You sent to your wife's email
To
address.
have a backup copy, yes, but I don't remember the first paragraph. It was attached to something else. I just got to see, like I said, it's a chain of emails. I'm not sure where that paragraph is referenced to, but that is part of my paragraph. That is my verbiage. Yes.
Okay, so starting with check pictures and
Mhm.
videos, more cover up, down
Yeah.
to is being addressed, big cover up. All those words, those are your words.
Yes,
Not your wife's words.
these are my words.
Got it.
Correct.
Thank you.
And at the bottom of the bottom paragraph, you say, then my wife explained you approved it. Then he said, how did it do fast? This wasn't fast at all. We've been asking about fence and concerned about flooding, so we wanted the fence to protect us. So again, you wanted the fence to block the water in the swale that you thought was a raging river doing you harm.
That's not correct. I didn't know where the swell was.
That's not what this means. Right, correct?
I didn't know where the swell was.
But they are your words.
That's my words.
You have in front of you Defendant's Exhibit 28,
No,
email from Tia to Ron Smith and Mike Tolley.
no. Can I have that, sir? Oh, yes, I have this right here.
Right. This is an email, again, you're using your wife's email address, but this is from you. This communication's from you.
I can't really see. Can you put it up there?
Do you not have it in front of you?
I can't. Yes, I have it right now.
Okay, but it may not be legible. I just want to make sure you have a copy.
Yeah, I have. it.
Okay.
It's supposedly signed by your wife, but it was either you produced this communication or it was communication on behalf of your wife.
This is, if you told everything, have told my husband or both, giving flying F what's going on with his own. This is my wife. Yes, correct.
But you were aware of this and approved.
I wasn't aware when my wife wrote this day, but anything she does, I will approve.
Offer defendants 28.
No objection.
No objection from plaintiffs. Mr. Dorsey,
No objection, Your Honor.
28 is admitted.
And again, this is addressed to Sean Smith and Mike Tolley, the principals of the HOA and of the backyard realty, correct?
Correct.
And the next to the last, well, the fourth line down, you say, "We are out of warranty. So please, 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 don't mention the builder anymore. They cannot help us." That was your understanding, that you're out of warranty, you're not appealing the warranty decision, that the builder couldn't help you and you were looking at to the HOA.
Correct.
And you believe that the HOA was responsible.
I did not believe that, no.
You didn't?
I believe both of them were responsible.
Oh. You have in front of you defendant's exhibit 30.
Is that the black part that's blacked out right here on tip there?
Should be a different piece of paper altogether that has a 30 and a little box on it.
No, I don't have 30.
Can you help out, Mr. McLeod?
Okay. Show you my copy.
Thank you.
And again, this is. This is an email from Donna, your wife, to the HOA parties. But again, it was something that you approve of. Perhaps it may have been written by you.
Excuse me, I'm sorry.
That document,
Do you recognize the document?
I recognize the document, but can I talk, Your Honor? I
Yes.
recognize the document. You can tell by the different font. This is from different places. This is the different font in each one. Can you post it so you can see it?
Well, it's not in evidence
All
yet,
right.
so. Did you write it or did your wife write it or you
I
don't know?
can't
who
tell
wrote it?
because it's all over the place, Your Honor.
Okay. You need to keep asking questions. This may not be the right witness for this exhibit.
may I document.
Put it up there.
No, if you've not authenticated, if you are willing to tell the court that that the contents of this letter were your feelings about it and the communication to the HOA was in effect your communications as well as your wife. Can you give us that?
Did you just hand him 30? Is that? what
Yes,
you-
yes.
Okay, okay.
It's the same copy.
Yeah, it just shouldn't have the highlighting. I mean,
Okay,
He's
okay.
marked it up for his own questioning,
Okay.
but that should hopefully be the same document.
Okay. Yes,
So you approved this letter either at the time it was, and I would say, letter, communication at the time, or now you say it represents your position.
just, can you repeat that? You said it was from who and to who?
Well, it says it is Tia Beslin.
It's to
To a
Tia?
host of thousands.
This is from Tia Banda, which would be me. I sent this out to everybody in the community, let everybody know what's going on.
All right, well.
It wasn't sent to the developer.
Address
Okay,
they look like there were perhaps 50 people. who
yes,
received this
yes,
email,
yes,
and those are other homeowners in the
correct,
community?
correct.
And so you and your wife are communicating to the community. at
I
large.
was,
You are, okay, so this actually is your communication, even though it's on your license.
yes,
All
yes.
right, okay. Now, defendant's 30, Your Honor.
No objection.
No objection from plaintiff. Mr. Dorsey,
No objection.
30 is admitted.
All right, this was dated June 10, 2019. Stood up. And all of those folks in the 2 category are other homeowners, and at the end, you include Mike Tolley and others. Correct.
Correct.
Okay, first sentence is, our board has failed in its fiduciary duty on multiple accounts. And then it says, if you're the target of a breach of fiduciary suit, the association may not be able to protect you entirely from personal harm. Are you telling the officers of the association that they are at risk of personal harm?
This was copy and pasted off of the Google, because I told you at that time I was doing my law stuff. So this is all copy and pasted. This is not personal harm. It says this on, I didn't paraphrase, I didn't cite it, but this is not my language. You know my language already. You can tell by my other emails.
I realize you perhaps got it from another source, which is nothing wrong with that. But you use that language to communicate to these people.
I let them know what's going on, correct?
Okay. And then 3 paragraphs down, you say the most common reason for buying a condo unit is the lack of maintenance. And you say that's your
Correct,
understanding,
correct, yes.
And that's one of the reasons you bought a condominium unit, because you could rely on HOA maintenance.
That's not correct. I told you in the testimony yesterday, I didn't know what HOA was.
I had no idea about that at the time.
No,
But you think the other homeowners in the area might have bought because of lack of maintenance.
that's not true, no.
All right, you just put it in there. And then down toward the very bottom. The bold letters. Is this something else you got off of Google? Developers of new condominium units?
Correct, correct.
And you were just passing that information on.
Yes,
And then finally, you conclude the association now, quote, owns and has legal responsibility for the building as a whole.
called the condo decks, correct.
Number 8 is what you said?
Yes. Let me show you. Defendant's Exhibit 8. They're looking for a clean copy.
Yes.
Of course, the fence guidelines for the association.
Correct.
When you applied for permission to put a fence up, do you have a copy of those guidelines or told about?
We got sent the guidelines and who to use. Thank you.
Any objection to 8, Mr. Stewart?
Oh, yeah.
Mr. Dorsey?
No objection, Your Honor.
Admitted.
And among the guidelines are under the category of drainage, new fence construction should not interfere with or change water drainage around the unit as designed by the builder. Well, in fact, your fence did change the water drainage, didn't it?
No,
You have said it blocked the raging river.
left the razor ring. Yes, I did say that. Yes, I did.
So the fence that you installed violated the new fence guidelines of the association.
Association built it. I didn't build it. It gave me the guidelines, so it didn't violate. No.
Well, Guidelines say you won't block the water with a fence. And that's what your fence does, doesn't it?
Not to my opinion, no.
So your comments about protecting you from the raging river,
Yes, I didn't say the raging water, I said the raging river.
but we only talk about the drainage swale, aren't we?
We talk about the pine
You're not
straw.
talking about the Chattahoochee River.
The Chinese River has stuff in it. It has fish, it has sticks, it has bricks, it has stuff.
I apologize. When you said raging river, you were referring to the water flowing through the swale, which behind your door.
Was part of it, yes, correct.
And then the guidelines say maintenance of the fence and all elements inside the fence, including grass, is the sole responsibility of the homeowner.
Correct,
It's you.
correct.
You understood that when you built the fence.
They say if it's locked, correct.
I'm not sure you gave the exact figure, but you told us that you had spent about $2,000 replacing the carpet with a laminate or wooden floor.
Correct.
Yeah, let's get oriented. What room is at the back of the house looking out onto the patio?
My living room,
Living room?
correct.
Okay. And that's the room that you replaced the carpet with, was it laminate or wood? Or
Yes, laminate, correct.
laminate, okay. And you did that when?
I don't remember the exact date. Can I see what date it was? Can I have? I don't remember the date. You say a year later, or was it happen to be a year later? I'm not sure.
It's as best you remember. If he wants to refresh your recollection, he's free to do that. Otherwise, he's asking you to give your best recollection.
I can't remember right now.
Well, let's see if we put it in context. You bought the property when?
2018.
And was it, how long after you bought the property did you replace the car?
So you say yesterday about a year, probably a year,
Year,
yes.
okay. And so that's been 4 years ago, 3 or 4 years ago?
Correct.
Okay. Have you continued to use the living room ever since?
I live, yes. You use
Sit
the
in the
living room.
living room, got a big screen?
I got a TV on the wall. Yes, correct. Yes.
You and I have something in common.
Okay.
You have a recliner?
No.
Okay, so you and your family sit in the living room, enjoy television, and every day since you replaced the carpet, you enjoyed the living room.
Not correct.
Not correct.
Not correct.
When did you stop enjoying the living room?
When they pulled off the baseboards.
Sorry.
When Trevor pulled off the baseboards. When Trevor pulled off the baseboards from my living room,
All right, and when was that?
the day that he came. Can't remember the day he made his alterations. I can't remember that date.
So have you not sat in the living room, watched television since then?
Be honest, my dogs enjoy my living room now. My dogs.
The dogs?
Yes, because they can't go outside.
Where do you and your wife and sons?
We have a loft area upstairs also. It's a 3-bedroom, 2-bedroom.
But since that, you have not done any repair work or incurred any expense for the living room.
No,
So that area of your house just become an area for the dogs.
right now, correct. Until I got it fixed.
But it has not resulted in any out-of-pocket expense.
Not that I know of, no.
That's the ones to-
I just thought say it's correct.
All
All right. Would you agree that my clients, Water Edge, and WG, were entitled to rely on the builder's warranty that they bought and paid for and gave to you when you bought the house?
Objection, that's a legal collision that he's not able or required to make.
I asked you if you agree they were entitled to
That,
rely on the warranty that was given to you in connection with the purchase.
right, how is that?
I'm dead, mate.
Well, my question is, your response, I understand what your question was. The objection is asking this witness to make a legal conclusion. Who's entitled to what based on the terms of the warranty, et cetera. What is your response to the concern about the question?
That it's not a legal conclusion. It's simply a question as to whether there was any reason that they could not, should not rely on the warranty that was a part of the contract.
So you're asking Mr. Ibezim if he felt, his family felt they were entitled to rely on the warranty.
The builder was entitled.
Okay, that's what I thought you asked.
Yes.
So that's not a proper question for this witness. Whether he, Mr. Ibezim, thought he was entitled to rely on the warranty, that's his opinion about how the warranty affected him, but how it may have affected the builder, you need to ask a different question of this witness. Sustained.
Mr. Besson, Water's Edge did not do anything to interfere with your filing of the warranty claim.
No,
And Water's Edge, WG, had nothing to do with your decision not to appeal the result of the warranty.
can you repeat the question?
Neither
Yes.
Water's Edge or WG
Yes,
had anything to do with your decision not to appeal the warranty claims decision.
I believe they did have, I believe they interfered.
But wasn't it Sean Smith who told you and your wife that you should not appeal and that the 30 days expired?
He did tell me, he said, wait till the end of the year. He kept on telling me to wait till the end of the year, wait till the year is up, and he's gonna take care of me.
That was Mr. Smith.
That was Mr. Smith.
That was not the builder.
That was not the builder.
So the builder had nothing to do with your decision not to appeal the warranty decision.
I'm not too sure because I discussed a lot with Sean Smith. So I don't know the relationship between Sean Smith, Mike Tolley, and the builder.
You cannot tell this jury that Water's Edge, WEG, had anything to do with your decision not to appeal.
It did. I believe so.
What did they do to persuade you not to appeal?
Ian sent me an email saying that we're not the cause. You need to go after the HOA. We're not the cause. You need to go after the HOA. So it was like this all the time. Go after here, go after here. This is like the scarecrow going this way. They had me run around in circles.
You could have done both, couldn't you?
I did do both.
Well, no, you didn't appeal, but you sued the association and not the builder.
Correct.
Oh, God. No more questions at this time.
Mr. Dorsey, do you have questions for Mr. Ibezim?
I do, Your Honor. Would it be appropriate to take our morning break right now and then proceed with those questions so that we can address something?
It's a little early for that, but if you're not able to get through your questioning without us working through this, then we'll have an early break.
Fast track things.
I like fast tracking. So, ladies and gentlemen, we're going to take an early break. That doesn't mean a shorter break. Be about 10 minutes. Please don't talk about the case. If you run out of smart food, I've got an extra bag up here, but only one. And we'll see you back in here a little before 10:30. Thank you. We're still on the record. Don't shut down. Thanks. That's all right. Mr. Alston would do that too quickly. I'll let you know. All right, you all can be seated. Mr. Dorsey, what's on your mind?
Mr. Brendan needs to check on something, Your Honor. We'd like to go ahead and address this apportionment issue as it can govern our trial.
Okay.
And I think we might be on agreement as to Your Honor's proposal, so I just want to make sure that it's clarified before we proceed.
Great, let's do that. So I've been looking at some apportionment stuff. I'm not related to your concern, but more towards Mr. Stewart's, and can plaintiffs be an apportioned group / party in non-negligent settings? I think the answer is yes. I'm looking at a products liability case, and the Supreme Court just 2 years ago said, yes, it's not limited to negligence claims only, but not ruling on that yet. I'm looking forward to seeing I haven't read that Court of Appeals case yet. So tell me what you want to now talk more about apportionment and your clients.
It's really just kind of a discussion that we need to have.
Well, that the two of you need to have. Oh, so you needed the break, not for me, for you two.
Well,
Go talk.
I think we may be able to come to an agreement on that front.
Okay.
But given the dynamic of the case proceeding there forward,
Yeah.
We may be able to circumvent a lot of things.
Great.
And to further complicate matters, it might depend on Your Honor's ruling on the issue about claims. My understanding under the statute is 50% rule. So we would like some clarification on that.
Well, two different things. One is there apportionment? And then two, for plaintiffs, is there apportionment for plaintiffs? And then two, because it's, and I hadn't gotten all the way through this Johns versus Suzuki Motor of America, but they're starting to get to contributory negligence, that concept. But of course, that doesn't apply in products liability, but they were clearly holding that there could be apportionment in a products liability case, and that it is wrong to read into 51-12-33 some limitation to negligence claims only. Supreme Court 2 years ago, very clear. So we're looking to see what kind of instances of nuisance and apportionment there have happened, and assuming that's out there, then we'll see. But my inclination now is what I shared this morning, which is it's a two-tier analysis. Are there damages owed? If so, how are they apportioned amongst the non-parties you've identified in that filing, your clients, Mr. Dorsey's clients, and plaintiffs? I think that's the correct legal answer, but I am developing a level of confidence in that is informed by things I'm looking at now and input that I'm getting from the three sides.
And to be very clear, I have two quick questions on that while we're making our decision. In that regard, it would still stand that plaintiffs have no right of recoverability against us. We are there merely.
Just like portrait homes. I think that's not even an analogy, it's an equivalence. That the apportionment would be because you are a non-party to the liability claims between plaintiffs and Mr. McLeod's clients.
Correct.
You are just like portrait homes.
Hard to that. Well, that answers both questions.
Okay,
Thank you, Ron.
Mr. Stewart.
They're not like portrait homes in any way. Portrait Home is a 90-day ahead of time, and if you don't bring them in, we're gonna put them on the verdict form. And I'm gonna file a motion to have them eliminated too, because this case law, you gotta prove they did something wrong, can't just stick the names on there. They third-party them in. We didn't sue them, and to put them on there as if we sued them violates the 90-day apportionment, the statute where you must give notice 90 days ahead of time. These defendants are going to also be on the verdict form. Instead, they chose to third-party men to claim they had a right. And now to reposition like Portrait Homes is not proper. There was never a pleading filed, no 90-day notice that they were going to put these third-party defendants as people to be apportioned among.
I wouldn't count 3 of the third-party plaintiff's complaint constitute that notice. Count 3 is apportionment.
Count 3 of what? My complaint?
No, third-party plaintiff's complaint, count 3, apportionment. Why would that not satisfy the
Defendants
notice?
count 3? I'm
Third-party plaintiffs,
third-party plaintiffs, yeah.
so that would be Mr. McLeod's clients. They have sued Mr. Dorsey's clients.
Correct.
Contribution, indemnification, count 3, apportionment. So count 3 is apportionment. So my question to you is, how does count 3 not constitute notice that would satisfy the requirements that you are saying weren't met?
My understanding why you were saying you're gonna put third-party defendants in the same position as like, excuse me, Geo Sam and the defendants.
Yeah.
It should be, our claim is only against Waters Edge and WEG, WG. And then they have to second for like and the jury must find, do you proportion damage between these two? But all our claims against them, we don't have a claim against them. To put them on the same level as the defendant is doing what the law says. If you give 9 days ahead of time and they don't bring them in, we have the option to bring them in if we wanted to or not bring in under the statute. But they didn't do that. They just third-party them in and say, we got the claim against you. To put them on the verdict form, make them equal to the defendants, is like we sued them. We didn't sue them. They chose not to bring them in.
I may have a fundamental misunderstanding of how apportionment works, and I'll look at that. But the notice that was provided was giving you notice that that Portrait Homes would be included in the apportionment, and you didn't object to that.
That's correct, because they gave the 90-day notice. But there is case law said just because you gave notice, they got to have evidence to prove that they should be a defendant. Now, that's why I'll address that.
Okay, but that's more directed verdict. It's not a defect in the notice. And so you're hoping, fingers crossed, that I would find that there's no evidence in the record that Portrait Homes ought to be included as an apportionable group. They're a non-party. Certainly, there is evidence that HOA and Backyard Realty ought to be included as an apportionable group. So the only issue
that's the one I had the problem with.
You don't know what evidence has been heard that would be a basis for the jury to decide that the homeowners association is somewhat responsible for the nuisance?
Absolutely, I saw lots of evidence of that, but I know no legal proceeding filed that allows them to be given to the jury.
Why is count 3 in the third party complaint not the functional equivalent of what Mr. McLeod filed vis-a-vis Portrait Homes?
He filed a complaint against them to bring him in. Count 3 says, come in and help us. We're suing you and you're suing your back. Nowhere did he say, plaintiff, the law statute says, send notice to the plaintiff. Plaintiffs, you need to bring these people in the lawsuit. And if you don't, we're going to put them on the verdict form, even though you can't collect from them because they're going to be awarded against it. That was not the third party complaint. Third party claim said, if we have to pay, you got to pay us back. They never said, we're going to bring you in and you're going to be another defendant. But third party plaintiffs don't allow them to do that. That's exactly why they passed the statute to allow given notice that you should bring him in to avoid the hassles of a third party complaint.
How do you interpret count 3? What is the legal impact of count 3 of the third party complaint?
Well, I hadn't read third party, but what you're saying, it says the legal impact.
That may be the problem, that you haven't even read the third party complaint.
Well, not since you brought it up today. I've read it when it came out.
Okay.
Count 3, if it's saying that third party plaintiff, we're suing you, third party defendant, and third-party defendants, you got to pay us back if we have to pay the plaintiffs. That's what count 3 should say.
Well, it
That's-
shouldn't if in fact count 3 is the functional equivalent of apportionment notice, which is how I'm reading it. I'm asking you, maybe sometime soon, because you're going to need to defend your claim here, how count 3 of the third-party complaint does not meet the requirements of the statute for notifying you that the defendants are going to be bringing in another group to be included in the apportionment. That's how
Okay.
I read count 3.
All right, because he said the heading is, this is a third-party complaint that we have against you. The statute says you must send a written notice to the plaintiff and say, plaintiffs, you must bring them in. If you don't bring them in, because implying we're not gonna bring them in, then you got the jeopardy of the jury awarding money against them, because we're gonna put them on the verdict form.
Did you not get a copy of the third-party complaint when it was filed? I assume you're in with e-filing, so you were served with the third-party.
Yes, I
complaint.
got it, because I read the complaint. The heading is defendants are now third-party plaintiffs, and we're suing them. It didn't say that plaintiffs, we want you to sue them. That's what the statute requires, that we sue them, and they give notice that you should sue them.
Okay, you may be a little over-focused on the heading as opposed to the content of the document, but let's both read count 3 of the third-party complaint before we continue that discussion. Our break is over, but I want to give you guys a chance to talk, so our break's going to continue a little longer. We'll go off the record.
Thank you, Rob. You're good.
John, I'm asked that down.
Yes, sir. I'm sorry. You didn't
No,
need to
I'm
be there
sorry.
the whole time. You should have known. Say, hey, why am I still up here?
Sorry, I'm
Go
sorry.
take your break. No,
I'm
no, no.
sorry.
I'm sorry. You take your break.
See a lot of conversations.
Oh, my.
It's ridiculous.
Yeah, you picked the wrong day to not wear your jacket.
Rainwater falling off the roof, and going into the system, down the pipe. Yeah. This is actually the technician's chair.
Oh, okay. So I don't think I know how to use it.
You're gonna do that one?
Yeah, when Brandon's up,
Oh,
he
Brand.
asked me to step in.
Okay.
So I'll see what I can
I tell you about the first time I had technology.
do.
Took my laptop, I had my thumb drive,
Mhm.
and I was struggling a little bit. It's a non-jury trial. Finally, the judge, who I'd known for 40 years, Mr. Pye, would you like me to help you with your exhibits? I said, absolutely. So I gave him the thumb drive. And he could pull up.
Okay, that's how.
Now, that's the last time that'll ever happen.
Right. My first experience with that. It's kind of good when I was a kid. I did all of us electrocuted us.
Both our sons are IT guys. So when we have a computer or television program, problem, we call for family IT support. And they're very good.
Except I'm the support, so now I get a bit sick of it. My son.
I expect my granddaughter could probably support as well.
One thing, you've got a problem with social media. Go to the kids.
I don't do social media.
No,
I don't care what you had for breakfast yesterday. There is a website next door. Are you familiar with it? And I'm connected to it. And I get about 10 emails a day. And there are people out there that apparently just don't have anything to do. Anybody know about where the police were going when they were speeding down Asheville? Come on.
I don't use it next to a ring. A man walked by my house.
My wife wants us to get a Ring doorbell. And we're gonna do that. I mean, she's there alone. They're just people who, now, some of the delivery services, including my wife. If you're tired of cooking, they will send you an email when they deliver with a picture of the package at your front door.
Are they about done?
Near the door.
Ms. Wilson, are they about done talking?
Yes, I believe so. It may just be a couple more minutes, Your Honor.
Okay. The goal was to streamline, so hopefully this conversation makes other things shorter.
I mean, I don't know why we're here, we're waiting. I got third party complaints. I'm reading through it. Count three, what count three you're talking about? I don't see what's in count two.
Their amended complaint, which was filed at the same time as their notices, not to you, of course, but to Portrait Homes and Wells Fargo and GeoSam. So it's May.
Okay, I'll pull that up.
Great. Let's make sure we've got everyone we need. We do. Let's go back on the record, Mr. Casañas. Excellent. Mr. Dorsey, did you have the time you needed to speak with Mr. McLeod?
Yes, Your Honor.
Are you ready to proceed with your cross-examination of Mr. Ibezim?
I would just like to clarify that for the discussion we've had with Your Honor, it's our agreement to proceed in that manner outside of the contribution of indemnity. And I don't need to speak in this place, but outside of contribution of indemnity off the table, proceed to enforcement as Your Honor has suggested.
Okay. I know that Mr. Stewart has an objection to that, but Mr. McLeod, you don't have an objection to that.
Yeah, as long as that's how we're doing it.
Okay, well, so we're clear, if Mr. Stewart convinces me that it would be legal error, then that's not how we're going forward. But in looking at your third-party complaint, the statute, the notices you provided to other non-parties, I think that Mr. Dorsey's clients were on notice in the same way that Portrait Homes and GeoSams and Wells Fargo were on notice. And more important to Mr. Stewart's concern, plaintiffs were on notice that one form of relief you were seeking was apportionment. In other words, having Mr. Dorsey's clients included in an apportionment calculation should one be appropriate in this case.
Yes, Your Honor. And I think the way Your Honor is setting it up would effectively work that way. The contribution and I guess more particularly indemnity claim gets into this, I don't know if you're familiar with the City of College Park case.
I'm not,
Okay.
and I'm okay that I'm not, because I don't think we get there. I think that the appropriate way to be thinking about Mr. Dorsey's clients is apportionment.
Follow that.
Okay. All right.
I've just called the court's attention to OCGA section 51-12-33C, which I think supports the ruling that you made.
No, I appreciate that. It happens to be on my screen, and I didn't hear Mr. Stewart saying apportionment under no circumstances would ever have been appropriate for your client, Mr. Dorsey's clients. What I heard his concern being was, where was the notice to plaintiffs that they better bring them into the litigation if they didn't want it to be, in some ways, I'll call it a hollow apportionment, because you don't recover if it's a non-party. I believe, and until I'm shown case law to the contrary, that plaintiffs were on notice. I'll make clear this happened when we were off the record, and it was an exchange that was appropriate. I think Mr. Stewart was asking me, where is this count 3? There is no count 3 for apportionment. He was looking at the wrong complaint. He was looking at the original complaint that third-party plaintiffs brought against third-party defendants. But in the amended complaint, count 3 apportionment, it's all the language that one would see in a notice. It was served upon the party that would be apportioned, if you will, i.e. Mr. Dorsey's client. It was also brought to plaintiff's attention because it was part of a third-party complaint that was made part of the litigation here. So I don't find that anyone was lacking notice, and I'm not particularly hung up on form over substance. I think for due process, notice, and substance, everyone who needed to know that there was a possibility that apportionment might occur with Backyard Realty and the Mill Creek Lake Homeowners Association was properly on notice with adequate time. All right, let's bring the jury in.
All right, the jury. I'll do the president.
Thank you, Deputy Gordon. You all can be seated. Welcome back, ladies and gentlemen. Mr. Dorsey, your examination of Mr. Ibezims, please.
Mr. Ibezims, I want to make sure I'm saying the name right. It's Ibezims.
Correct.
I spelled Kevin with a A-N, so I always want to be
Correct.
You might guess. I want to talk a little bit about the damages, okay? I'm going to start inside the house and then work outside the house. And I just want to walk through to make sure everyone's clear on really kind of what we talked about over the course of the last 2 days. I believe you said that the termite company came, and then after that, you noticed some discoloration behind the couch, correct?
Correct.
And that discoloration was, let's use this as the living room, okay? And this is the back wall right here. And then if I was to walk out this back wall and then patio area, is that fair? I mean, I know it's not round.
No,
but I'm
no, okay,
saying
no,
from
okay,
perspective,
yes,
is that fair?
correct, okay.
And this discoloration was concentrated in the right-hand corner of your living Is that accurate?
In the corner where I showed the video yesterday, correct? Mhm.
Okay, and then that's the video we saw was the right-hand corner, if we're orienting your house this way, right?
Right hand corner to mid wall.
Okay,
Mhm.
all right, then you got a couch in that area?
Couch, yes, in front of the, yes.
Okay. Perfect. And I believe you said that at the time, before the baseboards were replaced, that discoloration spanned about 3 to 4 feet, which is pretty consistent with the amount of baseboards we saw removed in pictures. Is that fair?
Correct.
And at that time, you were applying touch-up paint every few weeks or so to touch up maybe the sheetrock, baseboards, things like that. Is that right?
Just the sheetrock, the baseboards, no.
Okay, so but applying touch-up paint on the sheetrock every few weeks at that time before they were replaced.
Before they were replaced? No,
Yes.
no, I didn't say before they was replaced.
So you weren't touching up the wall
Nope.
beforehand?
Mhm. Nope. Oh,
Okay. Since the boards have been replaced, that area you said is still getting some discoloration, right?
after the board's been replaced,
Yes,
the corner of that, yes.
right. And you and I have had the opportunity to
Mhm,
speak, right? You remember that? We were there, it was there, all that good stuff. And we explained that the baseboards are, I mean, kind of think of like this, it's a little ledge, right? You know, they stick out from the wall a little
Okay,
bit.
okay,
that
yes,
fair?
yes, correct.
And I think at that time you told me that the discoloration was kind of occurring on that top part of the
Mhm,
ledge,
mhm, mhm.
right? Not on the
Yes.
face.
Now on the face of it,
Okay,
yes.
just right there. And I believe, and no one's written on this one, you told us that that discoloration after the boards were replaced only spanned about 4 to 6 inches, right?
Well, picture, yeah, I would say, okay,
Okay, so a spot about that big just on top of the baseboards of discoloration, right?
okay, yes,
That's fair?
okay,
Yeah, you agree with that? then?
okay, okay, no problem.
Okay. I just want to make sure we're clear.
Okay,
That's the extent of discoloration since Water's Edge Group did that, replaced the baseboards and did that.
correct, yes.
And at the time of your deposition, you told me that with that discoloration and on the walls, you were no longer having to apply touch-up paint.
I told you on the corner, yes, I have to apply touch-up paint. I don't put touch-up paint on top of the baseboard, which is in that corner.
But at the time of your deposition, you said you were no longer applying touch-up paint, correct?
We went through a couple cans. I told you we went through a couple cans, we still apply touch-up paint, correct? Yes, I do. To the sheetrock part, not the baseboard part.
Okay, so your testimony now is that you do apply touch-up paint to the sheetrock.
Once Dr. Spell said yesterday sheetrock, I don't know the terminology of sheetrock, but it's on the wall. I said the wall in testimony, the wall. I didn't say baseboards. Just one note before I make, just one note. With these baseboards, the special baseboards I told you about, the only reason why I seen that discoloration, because I told you pest ban came out. The chemical that pest ban used didn't react right with the baseboards. That's why they turned discoloration at first. So that on the baseboards, I would have never found out until pest ban came. So when pest ban came and sprayed the application in the wall, like I said yesterday, that's when the problem occurred. It started bringing out the ghost. So the ghost came out after the pest ban. So whatever's in that chemical they use inside that special baseboard, it reacted with the pest ban. That's how the cat got out of the bag.
So you noticed the discoloration.
Right, I said it right in my testimony, right after they left, 2 days after they left, after they dried out.
And I think we've clarified that to date, you've purchased maybe a gallon or two of paint and then replaced the flooring, correct?
Correct.
I want to move it outside. So now this door, we're going to walk outside,
Mhm.
looking at your patio, okay? You with me?
Correct.
You saw some videos yesterday, or your attorney presented some videos on the screen that showed the water and all those things flowing around, correct?
Correct.
And you agree with me that those were taken in 2018, correct? That's what you testified to yesterday.
Yes, okay, yes.
You agree with me that, albeit I know you don't like the work that was done, but would you agree with me in the simplest terms that in 2019, the association did indeed hire a contractor to come out there?
I was there, correct.
But they did do the work, right? Or they did some work.
They did a bad job.
Can we agree though? Just yes or no? Did they do work?
It did work.
Now, yesterday, you told ladies and gentlemen of this jury that that work didn't help and made things worse. Is that fair?
Correct.
But in fact, since that work was done, you no longer have noticed water coming into your house, have you?
That's not correct.
Mr. Ibezims, I asked you earlier if you remember giving your deposition.
Correct, yes.
Remember your attorney was there?
Yes.
I was there. We were in an office.
So, Mr. Ibezims, it's important when you're answering, if your answer is yes, instead of saying, if you could say yes
Yes.
or no.
Yes.
Because the recording
I'm
isn't
sorry.
going to be able to discern the nonverbal answers. Thank you.
You remember that you swore to tell the truth and nothing but the truth? You were under
Correct,
oath,
correct, yes.
Your Honor, permission to open the original.
Any party has permission to open these original depositions.
I'm gonna hand you this. This is original deposition. This is a legal lesson for the day. And the court reporter types it up. We get it in this nice little package so we can make sure. It doesn't tamper. I'll hand you that. You will flip to page 32. Line 22. I want you to read along to make sure that I'm reading this correctly.
So 32 line 22?
Yes, sir.
All right.
And let's go back to the question starting on line 17. When was the last time you emailed, filled out any kind or notified anyone of an issue with water going in the house? Or was the last time you actually noticed water coming into the house? And your answer, like I told you, I don't notice the water coming into the house.
Correct.
And then you go on to say, I just remember maybe like some sweating. So
Correct.
I really don't see much of it.
I don't see much of the water. Correct. I never did see much of the water.
But my point is, when I took your deposition, you told me
Correct.
that you don't notice water coming into the house, correct?
I told you that. Yes, I did. I would never be able to chance to see the water because the baseboards, the special baseboards hold back the water. So that's why you pulled it out and you saw that cancer behind it. Because it's special baseboards.
And I think you said you don't notice.
I don't know that. I didn't notice it. I would never noticed it because I had a carpet from before. I had a carpet. So I never noticed it. I noticed it when Pest Ban came out because the reaction from the H2O or the chemicals that's in that baseboard or the chemicals that's in the Pest Ban. So I would never noticed it. Even to this day, I would probably never noticed it unless I went back there and started doing dancing behind my couch, like you just said, and I would have felt the rug wet. I never went back there, so I never would have felt the floor wet.
Okay. Remind me again why you replaced the carpet?
Because it was mildew, and I know now it's wet and it gets wet or sweating. That's why I replaced it.
So you noticed wet carpet.
And when you brought it to my attention after I noticed that the water in the Pest Ban, I had a chance to go back there and start examining it. If you don't see it or you don't notice it, you're not gonna go back there. No use for me going back there and check every day what's going on. Now that it's brought to my attention, I will go back there and check it because I know what's going on.
I believe yesterday you said the carpet was wet to the touch. It was soggy, it was smelly, mildewy, it was discolored. Those are all the reasons that you replaced it.
Yeah, correct.
At that same time, I also asked you, you testified yesterday that the water in the swell is just as bad as ever, if not worse. You said that yesterday, correct?
Yes,
I don't want to put words in your mouth. I want to make sure that you told the ladies and gentlemen of the jury yesterday that this water is just as bad as ever, if not worse.
yes.
You still stand by that statement?
I have work orders. I sent work orders. I do just stand by it. I usually take pictures and I send the work orders to Tally management.
Your Honor, first, we're going to object to the measurement pictures. They're not in evidence once again. It's showing us.
To the video, not,
It's okay. You, through your question, invited that answer, so I'm not going to strike the answer. You may not want to dive deeper into it.
I want to take you back to your deposition. And this was on March 21st, 2022, correct? So this was approximately 3 years after the preventative maintenance work was done behind your townhome building, correct?
preventive maintenance, meaning who?
The contractor that came out, put the downspouts in, and did those type things that we just discussed.
Type things. Who's the preventive, who sent them?
The contractor that the association sent in and around July of 2019.
Is it association or what it is? You said association meaning,
Yes,
okay, HOA, okay.
yes, you
All right.
remember, we talked about it.
I was
You
there,
agreed
correct,
that-
yes.
You were there,
Mhm.
they came in, you agreed,
Correct.
they put the downspouts down into the drain and buried them and all that.
I agree that they put the downspout, they put the board up. Do you agree they put the board up?
You don't ask questions of the lawyer.
All right,
My point in this is work was done in or around.
okay, you can say that.
July.
Yes, say that.
And it's your testimony here today that that actually made it worse and that the water in the swell is still a raging river, correct?
I didn't say it was raging river still.
Okay, so it's getting better
It has gotten better.
then.
It
Okay,
has gotten better, yes. It's not good, it's not great.
that's actually exactly what you told me.
Exactly what I said. It did get better.
Thanks.
Sean said it yesterday. He said that
Yeah.
it's still, he says it's not a big raging river, but it's still water there. There's definitely still water. And Dr. Spock put that right on the hedge. There's still gonna be water there. There's still water backing up. I have work orders. He said, follow the portal. I did everything I can do.
I appreciate that. But in the simplest regard, since the work's been done, the water in the swale has gotten better. We agree with that, right?
It has gotten better.
Now I want to talk about the fence a little bit. I
Okay,
promise we'd talk about 3 different things.
okay.
It was you that, and your family that wanted to build a fence, correct?
I see neighbors and everybody went the fence. Yes, correct.
That's fine. I'm not
Mhm,
criticizing that. It was your decision to say, hey, this is good for our family, let's build a fence.
correct.
And step 1 was to fill out the ACC request form that I think we've all heard enough about.
Okay.
But step 1 was to fill that out, correct?
Mhm, mhm.
Were you involved in filling that out?
So remember, yes or no?
Yes,
Thank you.
Sorry, Your Honor.
Don't, it's okay.
You assisted in filling that out?
Yes.
I'm gonna hand you what's been marked as third-party defendants, Exhibit 8. We pre-marked them so they're out of order, so
Mhm.
just for your reference. Does that look like the ACC request form you filled out?
Missing some stuff, yes.
Exactly, but this is the form. I
Okay,
understand that
yes.
they've been attachments, but this is the form, correct?
Okay, yes.
Your Honor, I move to introduce third-party defendants Exhibit 8 into evidence.
No objection.
Do I have your exhibit list? Don't think I do. I've got plaintiffs, I've got defendants.
This is gonna be the only one, Your Honor.
Okay.
But
So there's no objection from plaintiff, Mr. McLeod, it's Mr. Pye. Mr. Pye, any objection to? No objection. So it's admitted, but if I could get a copy at some point of the exhibit list,
yes, Your
but third-party defendants 8 is admitted.
Honor. Permission to publish it to the jury, Your Honor.
Yes, sir.
Mr. Ibezims, if you will, just kind of while we're getting this up on screen, read through. So-
Familiar.
Okay. I want to direct your attention to this middle paragraph right here, okay?
Mhm.
Can you read that to the jury, please?
Plans or specifications are not reviewed for engineering or structural design or quality of materials, and improving such plans and specific neither the ACC members therefore or associations assumes liability for responsibility for therefore no for any defect in structure constructed from such plans, specifications. Additionally, if approval is granted, it should not be constructed to imply compliance with any governing city, county code requirements.
So let's break that down a little bit. This plan that you filled out before you built the fence, you were requesting fence, informed you that these are not reviewed for engineering or structural designs. And by approving these, the board is not assuming any liability or responsibility for this fence. You agree that it says that, right?
It says that.
Okay, and this is the form you submitted, right?
This form I submitted, yes, correctly.
And then it further states that if any defect or structural issue comes up, again, it's not their responsibility, correct?
Yes,
It also goes further to say that this approval, if you get approval, does not in any way mean that you've got the proper compliance with any governing ordinances, anything like that. Do you agree it says that, correct?
governing city or county code requirements.
Code ordinance,
Mm-hmm,
same difference.
Mhm.
Okay.
Yes?
yes,
So it's the responsibility of the homeowner and the builder, that being Pennington, to make sure it complies with all of these. You agree with that? The board's not accepting responsibility for any of that, correct?
they are, because Sean made a testimony, say he went out back there to check the fence to make sure it was okay.
One at a time.
Okay,
According to this document, you would agree with that, correct?
correct.
Yesterday, you said it took 3 or 4 months to get this approved, right?
Probably 2 or 3 months, correct.
3 months, okay. May 22nd, 2018. Next, I want to go to what was already admitted as Defendant's Exhibit 15.
You have that in front of you, or is it still up here?
You were seeing that yesterday? This was the approval letter for your fence.
Okay,
Remember, we talked about this yesterday, correct?
correct, yes.
If you'll pull up Exhibit 15.
Exhibit 15 is plaintiff's exhibit 15 or you-
Defendant's Exhibit 15, Your Honor.
as in,
Yes, water section.
okay, got it. This is defense approval letter. Okay.
Ignore the sticker down there because we had it marked for ourselves as well, but since it's already introduced, I'm not going to do it. Let's start with the date. June 18th, 2018.
Mhm.
Is that right?
Yes,
So that's less than a month after you submitted the request, correct?
correct.
Let's talk about the body of this again. In there, and we talked about this yesterday. It says owner is responsible for the maintenance of the fence. You agree with me, right? It says that.
Okay, yes,
So that is now twice that you've been informed that the fence maintenance, the maintenance of the standing structure is your responsibility prior to you starting construction. Agreed?
should the backyard be locked?
That's a separate sentence. Owner is responsible for maintenance of the fence. We'll get to the backyard in a minute. Right now, we're talking about the fence.
The fence is part of my backyard.
You agree that it says owner is responsible for the maintenance of the fence, yes or no?
Okay, yes, it says that.
So you agree with me that it's the second time you were informed that the fence was your responsibility prior to ever erecting the fence, correct?
Yes, okay,
And part 2, it says, should the backyard be locked, homeowner will be responsible for upkeep of the backyard. You see that?
yes,
And I understand your position, but would you agree with me in simple terms that if one did lock their backyard, then they would be responsible for the yard and the maintenance of it?
if they did lock the backyard, Technically, yes.
Yeah, so,
Okay.
so, and I'm saying, let's pretend your neighbor,
Mhm.
John Doe walks his backyard. John Doe is gonna be responsible for the maintenance of that yard, correct?
Correct.
Okay. This is a very important fact and a very important point.
Hmm.
Did you ever lock your back gate?
I never locked my, in the beginning, when a lot of things was happening to me, I did lock my front gate in the beginning. Then when I got cameras, I took the lock off because I felt more comfortable with it.
So first you acknowledge that in the beginning, your gate indeed was locked.
In the beginning, yes.
Yeah. And then at some point, you said after you got cameras, the gate's no longer ever been locked.
It's never, I can trust nobody coming in my house. As you testimony, Sean been back there creeping back. I was very nervous. A lot of things was happening to me in my subdivision. So that's hearsay, right? So I can't talk about that. But when I got the cameras and he said, he put the notice, no trespassing up there, I had no problem not locking the gate.
So let me make sure I understand that.
Mm-hmm.
From the start of the fence until a year and a half, how long until you got the cameras?
It was the first time I saw a dead snake on the back of my patio, and I texted Sean, let me see. I don't remember that date, but let me see, roughly. It's right after I made the complaint, after the HOA meeting. HOA meeting was 4 or 5. It was a couple of months. I don't remember the first time when the first ever HOA meeting when I had that altercation where I was blamed for the fence.
So until that meeting, you're responsible for, you locked the back gate, correct?
To that meeting, no, because I just had got that padlock after the snake. So probably around all that stuff happening, I put a lock on there until I got the cameras. I don't remember the time.
You don't need to convince me.
No, I'm not trying to convince
I know,
you.
I
I'm just
know.
saying, I'm not looking at them. I'm
wanna
worried
make
about
sure-
you.
I want to make sure we all understand
Okay,
that once you got the cameras, that gate was never locked again.
correct, correct.
Nothing further for this witness, Your Honor.
Mr. Stewart, do you have any redirect for Mr. Ibezim?
Yes, Your Honor. 2 minutes.
All right, the clock's running.
I'll give you the one, so we'll make it quick. Then we just introduced D18.
Correct.
That's your exhibit. Read the last 3 lines, that is it.
We have been asking about the fence and concerned about flooding. So we wanted the fence to protect us because nobody was helping. As the cover up began, the first time I called Talia Management via phone records, April 25th, 2018, then nobody was calling back. So we advised to get everything in writing via email or letter.
All right, so that letter shows that 1 month you were complaining to Tully Management about the water problem.
Correct,
And that letter shows that Tully got a copy.
correct.
2 minutes road.
It was less than 2.
All right.
Man of your word. Mr. McLeod, any further? Oh, I'm sorry, Mr. Pye.
No, Your Honor.
All right. Ladies and gentlemen, any questions for Mr. Ibezim? If so, write them down. You know the approach.
John, you have any?
Thank you. All right, council. Whoops. You all can be at ease.
You know, nobody's fun.
Yeah.
Cleared the whole crowd. I was like, you know, no one's sitting in the front.
That's because every time someone like walks in the churches, I'm like, you have to like really pay attention. Right there, they're like cutting down.
She was around paper. I was like, girl, you fucking- the people around look back there. I didn't want to look back. I was like, okay, slow down. Oh, he's getting something.
What would you do?
I'm sorry, so I'm hooked up. He's full of. You should have been on
We're actually able to go out for lunch today. Oh, yeah. Oh, yeah.
So what's for lunch today? I don't know. We've been hanging out with my friend over here. You guys have to. I might go to Wing. I just think it's so bad to eat wings.
Wings are delicious.
I know. I'm
How
good
can
every
how
night.
can something so tasty that's ridiculous?
It's really not. It's the skin and the sauces.
Look at it this way. It's not red meat.
Right. I might do that. It's so, I'm just trying to decide what to wear. Like I get warm, but I need
Go by your voice.
something on my sleeve, and then it's gonna rain. So now I'm sitting in my closet at 6:30. My husband, what should I
So they're making some words like the Google.
But I don't have in between clothes.
It's
What am I
accurate.
gonna
Is
do?
it more accurate?
And which jacket?
My
My go-to is yoga pants and a t-shirt.
Yeah.
Yeah.
I'm like, just wear this.
Yeah, I have a child in city college, like, you know, like.
No, we're overthinking what to wear. But I want to show respect to, you know, the people. Like,
Yeah.
I take what's going on very seriously. So in between that,
Heck, my uniform every day, ever since I started working from home, is effectively sweatpants, and if my wife's lucky, a shirt. Most of the time, she doesn't even get that.
so you can just work with me. So you must be one of the camera off people.
First of all, I am the camera off person, but even when the camera has to be on, because it's one of the serious ones.
You don't have a shirt on?
Usually, no, absolutely. I've got, collared shirt, but nothing underneath. It's just
Just nature.
no. I'm not. I'm not, no, nothing like that. No. But like shorts, you know, underpants maybe, socks, stuff like
I'm
that.
not.
It's not like that commercial where the guy had on his,
No, it's gonna be
Yeah, no.
No.
No, I just in case, I specifically have put my, my desk right here. So if my MacBook closes on accident or something like that, there's no possible way anyone's getting
Any other?
And we'll put it this way, I keep it G as much as I can for the.
I'm that person that, like if I'm having a meeting on, I'm like, everybody turn their camera on.
Oh, really?
Because engagement. I mean, it depends on what you do, like you're probably doing something very technical. Mine usually requires somebody to engage. Camera off, I'm done. So.
I have found that I am extremely vain. I'm not a vain person, but I am extremely vain when I'm staring at myself. I'm like literally looking at my little tiny picture, like is my hair perfect? Like I'm sure right now my hair's a mess
Yeah.
because I can't see it. But if I see myself, I'm like doing this.
I know, that would be kind of weird to be on that camera. The first is that, you know, when they put the camera on, it's like, oh, this is weird seeing myself.
Yeah.
I had the number and everything, just to recall for later. Just a lot.
Yeah, I do too. And one of my friends had a friend who worked from home and she always worked in her pajamas. And so she got up, she had a meeting down at the courthouse. And she got up, and she always has a blouse, because she's on the camera, some blouse. She had on some jumper vest bottoms. She got up and went to the courthouse and
Just forgot about
forgot all about that. And when she looked down, she saw her pajama pants. So she was so
I have
embarrassed.
always worried about that. I mean, I'm the person, I will go to the grocery stores just straight up pajama pants.
But that's the thing now. That's the thing now. It's not, it wasn't back in, you know, back when or whatever, but now people wear their pajamas. I have patients come in, they're in their pajamas.
Now, which hospital are you at?
Keep my name in Cowley.
Oh, right, because my uncle.
Your uncle works in the Arbor Spring. Yeah.
You know, I did a in-service, and that is new glass one, right? When it first opened about, when I was a
It's
sales
about
rep.
10 years now.
It might have been in 2015 where I had to train all of the nurses on the insulin pen.
Oh,
Go unit to
okay.
unit to unit to unit. Like, how do you do, you know, the pens for discharge? So bedside, so we had to go unit to unit to unit to unit to unit and get the sign up. And I remember that. This is such a nice hospital.
Brand new, and they added on to Atlanta, similar to that, you know, what they did in Noonan, how they, the structure.
Yeah. Oh, no,
Or blueprint of design.
I went about probably about 4 months ago. And I was like, there's just so many people who live there now. Because when I go to his house, I just get off sharp.
Yeah.
And I don't go up to the
Yeah.
house. But that house, that city, so many people.
That now, yeah.
We have more house, more land.
They're building more towers onto the hospital now because
Everybody lives there.
all this construction, this dense population, though, all this construction, all these residential areas have popped up around the hospital. It's like you guys.
There's so much, it's like a city.
And now they got Ashley Park there, they got another area there, and
Yeah.
they got good shopping, nice
Yeah,
shopping and everything. But the traffic now is kind of getting a little many.
Oh, the house prices are starting to climb.
Oh, yeah, that stuff is.
It's getting expensive, but
It's ridiculous. We are.
Were you here in Atlanta?
Roswell. Yeah.
because we don't have some taxes.
No, I didn't.
I'm not kidding, I'm like, but then if you talk about ways, they show up. If you need something, they show up. Parks are beautiful.
Are you, did you,
And it's
are you going to the
awesome.
party? Are you going to that party?
Everybody got hands. Like you do anything
My first day.
everybody.
I don't know.
I don't.
Okay, yeah. I'll give you a piece of my paper. I'm gonna give a piece of my jury paper. Jury do the paper. So you put it in.
There's these times,
Yeah.
and I do have to put 30 up on that, but there's these times where you don't want people around. I'm at that point, like, Yeah, I like all people. And I'm not gonna be happy. I'm blind, but, you know, it's like, yeah, I think that's the difference, because when you see people. I just think myself is like, we're not playing. That game. at all. And I'm just at point, I'm like, well, good. Cause I don't wanna be, even one. You might live in a great place. I mean, they do.
Number 37.
I feel. I couldn't, and my kids were, they went to Massillon.
Robertson, okay.
No, I like that, but I moved to Florida for 3 years and came back. But,
That's Savannah. You know, I'm from Savannah. We just moved down here about 7 years.
But that was my neighborhood.
Yeah.
My husband was from Texas, Galveston. He doesn't like
My
Savannah.
son's in Florida.
Yeah.
That's like looking at the location, but he's in.
In Savannah. He did a
University
tour
of
there in Savannah. He was working with the
And
Lockheed
now he's
Martin,
somewhere.
and he went to, they moved him, military ones were actually
LLC.
to Air Force.
He's
So
the
I'm there
person
in
that's
Savannah.
pulling all the documents, closing on, I don't know what. He don't like telling me anything. He don't want to be on Facebook. But so.
But it's a
like,
nice
the
trip.
Lawyers.
It's
the
I only
partners,
met
like,
one person. He
His
said they
job
didn't
is
like
associated,
it.
or he just kind of started in November, but his job is like all the documents for closing is to go through all that. So he's got 2 monitors of all this stuff.
Yeah.
And it's quite stressful. And, but he made the adjustments. One of the partners gave him 30 Lakers tickets.
Yeah.
Because he did a good job. And that's his mother. I'm proud of him. This is his first job.
So you
Yeah.
talked to your manager?
He's been in
Did
school.
you talk to him? Did you
So
talk
his
to your
first
manager?
job.
Did you talk to your manager?
So yeah, when I watched him, it's like, you know,
Your manager.
it's a lot of work, but
Mhm.
you know, I think you can handle it. You just want your kids, you have babies, but you want them to be able to
Mhm.
handle themselves.
Yep.
Whether you're gonna be a gas station attendant or whatever.
Yep.
I think she'll make it with a little anxiety.
I'm gonna tell my kids, I'm like, if you don't want to go to college, don't go to
That's what I
college.
said.
Yeah, I'm not
told my
saying
man, my cases
find
over.
your kids, but
I'll be back
you
when the
gotta
cases
do
over.
you. That's, they are crazy.
I'm gonna tell my kids, you want to become a plumber? Become a plumber.
Look,
There's
That would be
nothing wrong
nice.
with that.
I'm not taking care of you when you're old. I'm not taking care of you because you ain't having a business. So
Yep.
you need gas station. Because there's like forces of people, their kids to be what other people want them.
Yeah.
And that's what makes them all crazy.
Yep, 100%.
You need to be this, you need to be that.
I like what my dad did because not only did he let me get, so my family is nothing but doctors, lawyers, and engineers.
Wow.
I went to art school and I only have a bachelor's. But my parents were like, as long as you find a job that can sustain you, they were like, we don't care what you do.
Well,
And only that, look, that's expensive. And sometimes it don't justify the cost. So if you want to be a plumber, you might. My son is a lawyer, has $300,000. So I'm not sure
Exactly.
which degree was better.
Yeah,
Because that's a lot of debt.
I went to a party school in state at the time of my life, still took 6 years.
What,
to
now where did you
graduate.
go again?
Georgia Southern.
Okay, down here. No wonder you know where the restaurants are.
Oh, no, Georgia Southern, like down in
Oh,
Savannah.
Southern is in the rural.
Yeah.
16.
Ah.
No, I had to go to the actual college campus.
Oh.
I couldn't go to a city school.
What's your mascot?
Yeah.
Mhm. Mhm.
Yeah, but for the life of me, I couldn't tell you anything more than that because they don't play any other teams that are worth.
Mm.
It's like being the tallest kid in the ball.
Be aware.
You're still a kid. Well, they play Georgia every 4 years and they get whooped every 4 years. Yeah.
They were doing that with
Yeah, but that's the thing though, is that they're like, oh, our big competition is
really?
Appalachian State. What does that state do? Nothing.
May I see it? Go to order.
I'm gonna say, watch.
All right, Mr. Ibezim, a few more questions. On your you're part of building 30.
Correct.
Are there any other 6 units in building 30?
The 6 buildings, yes, yes.
Okay, however many there are there, excuse me, any other units in building 30 that have a fence in the back like you do?
I don't know if that's building 31 or 30, it's 2 houses down, so. Building 30 is the whole 6 units? No, it's 2 more houses, which would be building 31. What you saw in the picture yesterday in that swell, or one of the jurors asked a question about the electric box. You see that brown thing? I think the attorney didn't want to answer that question. Ask them, what's that brown thing? That's another fence blocking the swell.
But that's a
Wow.
fence on a completely different building, building 31.
But it connects to the sewer drive. So yes, it's 31, yes.
But it's building 31. On your building, the only fence is your unit.
Because I'm next to the last unit, yes, so
Yeah.
2 houses down, yes.
Okay, but then if we were to go down to building 31 and look in the backyard, we'd see 1 or 2 other fences.
Let's see, I don't know if they built another one, but they did do some work back there and they have another fence.
Okay. During heavy rains now, 2023, during heavy rains now, is there still water that flows from the swale, not the concrete pad, but the swale under your fence into your yard?
Under the swell, yes, not as much, like I stated inside the testimony, not as much, but it's still water.
Okay. Do you know how far the fence is, the back part of the fence, part with the gate, how far that is from the edge of your home?
I don't know, I had to go by measurements, I'm not sure. Like I said, I had to go by the same schematics of that fence that was 2 houses down.
But you don't know if that's 10 feet, 20 feet, how
I
far?
don't remember, I have to look at the schematics.
Okay. Were you ever asked, or was it ever recommended to you to remove a little bit more of the bottom of the fence?
That was not recommended to me. As Sean stated, he went back there, he never making a recommendation, nobody sent me no letter or anything. As you see in my document that's been turned into evidence, that's what it's called, you see the shovels there. So I always was shoveling or digging it out. And another thing I didn't bring up, why?
So I'm not asking you to bring up other things. My question was, were you ever asked by someone, told by someone, or was it recommended to you to increase the gap between the bottom of your fence and the ground?
The builders did. So when the builders asked me to do it, because I didn't believe in any way, I had no trust in them, I asked the HOA or the HOA, I could see them CCing everybody and the HOA never asked me to up the fence.
Okay, so you're changing your answer a little bit. So the builders, as in Water's Edge,
As Water's Edge,
they said, hey, one thing you could do to address this is, I'm gonna call it raise your fence, not make the top higher, but increase the gap. Why didn't you do that?
because it wouldn't make a difference. Because like I said, if you're on a slope on a hill, the ground is always moving. So even if I lifted it up, it's still not gonna be that much as you want it to be, because I still always had to dig out because the ground is always shifting from the top of the hill and everything that's bringing with it. Not just the water, the mud, the straw, the pine straw, the leaves, everything is always gonna shift it over and always have, no matter how much I dug out, it's never gonna be how much they want it to be, because the way the water and the mud and everything, and landslide, should I say, always coming down the hill, will never always.
So you didn't follow the recommendation of Water's Edge because you didn't think that would fix things?
And I didn't get direction from my HOA that I paid my dues to or covenants to, or the person that approved it didn't tell me not to do it. So I'm not gonna do it if somebody else told me from the outside to do it.
Okay. Did you ever contact Mr. Silverstone or Water's Edge Group to try to pursue your warranty claim? Or was it always through QWB?
Many emails, many text messages to even Silverstone, even a conversation we had on the phone. So I always reached out to them.
Okay. And was it then your understanding that Mr. Silverstone forwarded your concern to the warranty company, or were you the one who filed the claim with the warranty company?
I got on the phone with the chief engineer a couple times. I had to change my number to act like to get into him, just to be able to talk to the chief engineer. So I talked to the chief
Engineer of the
QB.
warranty company?
Yes, the whole guy.
So my question isn't to whom did you speak? My question was, did you file the claim with the warranty company, or did Waters Edge do it on your behalf?
Waters Edge did not do it. I had to file.
You did?
Yes.
Because it's your claim, it's
Yes,
not Waters
yes,
Edge's claim.
yes.
Okay. And when was it that you filed that claim? Year, month, or in relation to a particular incident we've been talking about?
When they came out with, I don't remember the day or anything, but the document yesterday that he produced, it said that he came out for the defect inspection or whatever, that report they gave me, and I said, this is non-warrantable items. I don't remember that date, but
Okay.
it's on that.
Why is it that when you received a partial denial that the warranty company said, we're going to cover this, we're not going to cover that, the things they said they weren't going to cover, we all saw the same letter. It said, but if you want to challenge this, follow this appeal process.
Because
you didn't do that. Tell the jury, not me, why you didn't do the appeal.
You saw the rejection. They didn't put the whole warranty thing yesterday. Only picked and choose. Like I said, if you saw that whole document, you would see everything that was wrong with the situation. It said some things were warrantable, some things wasn't not warrantable. Only thing that I had a big flag on is that the gate, the outside of my counter area, they say once it steps out, it's murky because the patio's limited common area. The backyard.
So I'm gonna interrupt you. I know the
Yeah.
lawyers don't get to do that, but I can.
Okay.
My question is, why did you not appeal?
Because
Some
it
things
said-
they said they'd cover. Let me finish the
All right.
question. Some things they said they'd cover, maybe not many.
Yes.
And then some things they said we're not covering. And then we all saw the language. If you disagree with this, you can appeal. Here's how you do it. And you eventually said, I did not appeal. The question is, why did you not appeal?
Because we got another letter saying from Quality Builders Warranty, they didn't submit or show you that those items were non-warrantable. So there's no warranty. So it makes no sense to file arbitration when it's not warrantable. So I'm gonna waste more money to go file arbitration for what? If it's not warrantable, it says non-warrantable. That's not part of my house. They give you also a diagram with 210 warranty, a whole diagram for number 1, 2, 3, 4, 5, 6, and what's under warranty or not. My footing and my slab is not under warranty. Everything inside my house is under warranty, not outside of my house. So that's why they didn't go outside. They only did that board because they didn't care about outside because they know I didn't have no warranty for that. So you can do whatever they want to do. I don't have warranty for the outside of my house. I only have warranty for the 4 walls in the condo. It's only the 4 inside the house. I don't have warranty for outside the house.
Did you have a home inspection performed before you bought the house?
I stated yesterday, the house was new. I went, the house was brand new. I even asked the builders,
Did you have an inspection?
No, they said the house was
when
no,
you bought
no.
the house?
They said the house was new, I don't need one.
Okay, whether you needed one or not, did you want one?
I didn't know. Like I said, it was my first time buying a home. I
First
didn't know.
time through the process?
Yes, I didn't.
Was the sheetrock, we saw pictures that you took of I think you call it your living room, baseboard removed, and there was some sheetrock deterioration. I don't know what the right word is. Was that sheetrock replaced, or
No.
was there just new baseboard put over it?
New baseboards, left it open for 2 months, 3 months until they came with like I said, the big Mack truck to deliver it.
Have you ever been fined for having your fence arguably in the wrong place? It extends too far, it blocks the swale, or it's not low enough. Ever been fined for your fence?
No, not at all. Not one letter, not one fine, not recommendation. Like I said, we was at the board meeting, he told everybody because I was making a big thing out of it.
So
that the
my
fence is
question was
illegal.
just whether you've been fined or not. You said you have not. Thank you. Did you have to pay any money to file your lawsuit in Gwinnett County?
Yes.
Do you remember how much that was?
Not off the top of my head, probably a couple $100.
Okay. Did you ever hire an outside company to try to figure out what the heck's going on with the water, instead of relying on the builder, the homeowners association. You've made very clear your discontent with the work that was done by all these other folks. Did you ever say, you know what, I'm bringing in my own folks?
Great question. I brought in the county. County came, I got landscape, I got my own advices. Even, I think Alan Ducker, the person that they hired, came out and told me this, how did this happen? How do you close on this? So I did, yes, I have very much more recommendation. They might say, how come you didn't see it? On both sides, you saw all that pine straw. All that pine straw was in my lawn, inside, not my lawn, inside my patio. It was about this high, a pine straw. So no way I could have saw the defects and everything until I pulled back the veil and started pulling back everything. And that's when I saw the defects and everything. It started small, they got bigger, but that's when I started seeing everything after the pine straw.
Okay. Mr. McLeod, are you able to put up the photograph that we talked about while we were looking at these juror questions? While that's coming up, Mr. Ibezim.
Yes.
Was there some work that was done because QWB did determine that some things were under warranty and needed to be fixed?
Two part. Yes, Your Honor. They fixed what they wanted to fix. Say this is a cat.
So
yes.
Okay. My question is, was there some work done? Not who wanted it? Was there some work done?
Concerning to the backyard or concerning to my house?
Did
There was one thing that was done. Yes,
Okay.
Your Honor.
And did you find that the quality of the work that was done as a result of QWB acknowledging that some things were under warranty and were defective, did you find that the quality of that work was acceptable?
No, because it wasn't painted.
Okay. Do we have the picture up? We're getting there. While he's still trying to do that,
Okay.
Do you believe that there are construction defects in your home? And if so, what are those construction defects?
The roof, we're gonna talk about the roof. I had about $8,000 worth of damage on my roof already from the backed up water. They never talked about that. My house was constructed without a cable wire. There was no cable, there's no cable downstairs, so I don't sit downstairs anymore anyway. It comes back to that. There's no cable wire in the wall. They forgot to put the cable wire downstairs. So I have the cable outlet, but there's no wire. So when I called the cable company,
So we've got cable, we've got roof, any other construction?
floors. They didn't change the floors. It was recommended to change the floors. They didn't do it.
Recommended before you moved in?
It was recommended by the warranty company. They found defects on the floor. They didn't do it.
Okay, so we've got floors, roof, cable, anything
Correct.
else?
Not at this. Yes. Inside the AC duct. Inside the AC duct upstairs, I have a problem with the unit itself. So every time it gets hot in the house and it's cold outside, it will sweat now. So I have like water beads coming down. I would say like the laundry room and everything. So I don't know how to explain it. So it's a pipe. It's the HEV pipe inside the attic. There's a pipe up there. So when it's hot and it's cold or the weather changes, it sweats. So they said that some builders try not to pad that or put something around it so it won't have no condensation coming through the top of my loft area.
Okay. Got it. Let's look at this picture on the
Yes.
screen. This is your backyard?
Yes.
Okay, it should be on the screen right in front of you.
Yes. Oh, I have something on. Okay, unmute, stay muted.
Stay muted.
Okay, got it.
All right, see it there?
Yes.
Is that your backyard?
Correct.
That's your HVAC unit.
Yes. Yes.
That HVAC unit is on I think it's plastic, but a pad of some sort.
Yes.
Is a lot lower than the concrete slab of your neighbors.
Correct.
Has it always been at that elevation, or did it used to be the same height as?
No, it didn't sink. No,
It's always been below.
It's always been below like that.
Okay.
Correct.
Your siding,
Correct.
does it extend all the way to the ground, or is there a little gap, not in the sense that it's open to your house, but is the last, I count 1, 2, 3, 4, basically panels of siding, and then it looks like it's going to be cement and the ground. Is that accurate, or is there one more board of siding?
On the bottom of it right here,
Yeah.
underneath that, no, that's, this house is built on the slab. That's why the concrete is messed up and the foundation is messed up. That's why they never got figured. The water that's inundated through here, a condo, this is based on a slab. This house was built on the slab, on the foundation.
The siding doesn't
Yes.
touch the ground. The siding is a little bit up off the ground. Is that correct?
Yes, it's about 3 inches, 2
Okay.
inches.
All right. So the AC slab is where it has been. Where does the dirt come from that you talk about running against your house and you're having to shovel?
It's on the other side, I'm sorry, on the other side of the picture, when you see it right here, this is where,
So
in this
not
one.
from, there's an arrow pointing somewhere.
yes,
not
that's
where
where water comes in, straight water.
Not
comes in
dirt.
there, Not dirt,
Okay.
water, all water, that's
Got it.
not dirt.
Okay. Mr. Stewart, do you have any questions based on what Mr. Ibezim and I have been talking about?
No, Your Honor.
Mr. Pye,
No, Your Honor.
Mr. Dorsey?
No, Your Honor.
All right, Mr. Ibezim, you can step down. Thank you. And we can take that image down. Mr. Stewart, your next witness, please.
Last witness, I'll call Tia to the stand.
Ms. Ibezim, come on up, please.
So help me God, yes. My name- Yes. Do I have to take my mask off if everybody's mask is?
You
off?
don't, but then you're gonna need to speak real clearly in the microphone. If we can't hear you, then I will ask you to. But if you want to try a mask on, as long as we can hear you, you're good to go.
Okay, no
All right.
problem. My name is Tia Ibezims. Let me go a little bit closer.
I'll say once again.
Tia Ibezims.
It's been unsuccessful, I'll try to move a little faster.
Okay,
Where'd you originally come from?
say that again, sir.
Where were you born? Where were you-
Oh, New York, New York, Westchester County, Mount Vernon.
Where did you and your husband meet?
We met in Mount Vernon, New York.
What were you doing that time? Like, what year was that? Well, I'm asking, did you get married on August 13th, 2006?
Yes, we did, but we met in 2005.
What were you doing in 2006?
As far as profession?
Just working or?
Yeah, I was working, yes.
Okay, what type of work were you doing there?
I was a registered nurse since 2000.
Where did you attend the nursing?
I did my undergrad at Binghamton University,
Where's that located?
Binghamton, New York.
So you're doing that, when did you decide to move to Georgia?
Okay, about 2014.
What made you do that?
We wanted to buy a house because the housing was just so much in New York. We paid a lot of money for rent, so we wanted to do that.
So you moved to Georgia, why did you pick Georgia versus Florida?
My grandmother's sister lives down here in Beaufort, and her daughter and my brother moved down here too. He went to Morehouse, so I just wanted to be close to family. Mhm,
So 2006, you got married, you moved to Georgia in 2014.
mhm.
But when did you have your children?
So Chris, my oldest was born in 2007, May, and then Kyle was 2012.
Not going into great detail, what type of health problems do they have?
Well, they're on the spectrum. They're on the spectrum. I don't know if anybody knows what that means, but special needs, and it ranges. It just depends. And you have to get like help. I know we spent a lot of time with speech therapy because both of them didn't talk till they were 5. Now they don't stop, but it's gotten a lot better. They're real smart boys, but you know, it's always a work in progress. Yeah.
What about asthma, things like that?
Yeah, Chris, my oldest, has asthma.
Kyle's okay?
He's all right. Yeah.
All right, and so you moved down, what type of work did you start doing, or what job did you first get paid?
Oh, I worked at a nursing home as a educator.
How long did you do that?
I did it for a year, just because we knew the goal was to always get a house. And I know that it was hard to kind of prove your residency and everything, because we've talked to people since we've been down here. So the recommendation was to be on record for a job for at least a year and make sure our bank statements, everything was in order. So that took us like 2 to 3 years. And then it brings us to March 2018. So.
Okay, so you did that.
Mhm.
And where were you living then? You said apartment?
We rented a house in Beaufort.
In the house in Beaufort.
Mhm.
How far is that away from the townhome that you bought?
Beaufort is funny because you have the city of Beaufort and then the part that's a part of Gwinnett County. So it's actually on the other side of Beaufort. We weren't that close to the Mall of Georgia. You would have to drive. Now where I live, I can ride my bike to the Mall of Georgia. So it's much closer.
Right, so from the old house to your townhome, 1 mile, 10 miles?
Oh, maybe 6 or 7 miles.
Okay, so
yeah.
You're familiar with that area before you bought your townhome?
Not where we live at now. We just discovered that because when we were looking for homes, we were just riding around and speaking to realtors and just trying to figure out where we're going to live. So, or buy a house, I should say.
We heard Chris talked about how he was responsible and he found the house. Were you involved? Put down the deposit, find the house, things like that?
Well, see, when you say that, it's like it's separate. So, because we're married, so we're as one. So whatever he pays for, I pay for. So yeah, that's whatever he wanted, I wanted. So.
I'm asking, when you were looking, did you tour the house like he did beforehand, or did he go by himself? What did he see?
Oh, no. Once he found something, like same thing. If I found something like, hey, babe, I found a house. Can we go look at it? And that's what we did. So when he did find this house, when he put the earnest money down, we went to go tour it with the project manager.
You saw it before it closed, you actually walked.
Oh, yes, absolutely. Yes.
Is that about the time or before you signed the purchase agreement?
Yes, yes.
Where are you working? Where are you working now?
I have a few jobs. I work at Northside Hospital and I work as a clinical instructor at University of North Georgia. And I work at a rehab hospital in Compass. So I do 3 things. I'm trying to phase out of one, but so.
Well, how many hours a week do you work?
It varies. It varies. But I guess if I had to say it under oath, maybe like 60 sometimes. It just depends.
Now, Chris works as well, but do you have children in daycare?
No, 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 we can't trust people with that because Kyle is a little bit too much sometimes. But so I work nights most of the time, except when I'm teaching the nursing students. And now my husband works days. We kind of flip flop. That's just the easiest thing for us. One day, and then I think somebody came down with some infection, and I just said that's enough of that. Not too much, probably 2 times in their entire life they've been in daycare when we lived in New York.
So you bought the townhome located 3283 Wild Basil Lane, is that correct?
That's correct.
Well, it was established on March 9th, 2018.
Okay, yes.
Having design or input on what to put in the house as far as there's going to be a loft upstairs?
No, it was already put together.
Totally finished by the time y'all found it?
There were some things like cosmetic things that needed to be done, but the project manager promised when we do our final walkthrough, he'll put blue tape up. And if there's any things that we see, he can come back and do that before everything is finalized.
Yeah. First asked yesterday about punch list. Was there things you came up with before?
Yeah, he gave us a sheet with boxes to check off what needed to be done, like things that we saw that just looked, needed to be touched up. If I could remember, maybe some chip paint stuff. I know, I'm not sure if nail pops was it at that point, but there were some things. I can't remember. I'm sorry, Larry, everything, but we had a few things on the list. And if I remember, because this is inside the house we're talking about, there were just a few things. And I believe he did meet that when we finished walking through. He had to clean up with some dust stuff, some things in the garage that needs to be put up, but it was decent.
Okay. And so we heard Chris said this is the first house he's ever owned since y'all been married. Did you ever own a house or anything before you got married?
No, not in my name, no. Mm-mm.
This is the first one.
This is the first one, yeah.
You asked her a question about, did you hire outside independent company to do the inspection reports or anything?
No, we were advised that we didn't. I wish, of course, we did, but we did not because it was brand new construction. So we felt like if it's brand new, like a brand new car, there's not much things going on with it. There's been no previous owners. But now you know, brand new construction doesn't mean no problems, right? So, so yeah.
So you went to close it with you and Chris, two sons, Chris, all four of you went to close it.
Yes,
And Mr. Silverstone was there.
yes, he was. Mhm.
Anybody besides the six of you?
I don't think so, no.
Is there any discussion there about your liability, responsibility for the swell area or the backyard?
The swell wasn't, see, this is a new term. So the swell was not mentioned during closing, but there were a stack of papers like this big that I was going through. I tried to speed read, but everything was not, because there's a lot going on. Matter of fact, that day I had to work. So we went down to Atlanta for closing and I came right back up and we said, here, kids, here's your new house. And then I had to go to work because we had to go back and pack and do all these things. So it wasn't like, I mean, when you sign, you must have like 500 papers you're signing and then you're waiting for copies. And it was a long process. We were happy, but it was just a lot to read through.
And so day of closing, you were working still full time, I think. And Chris now talked about how he works now
At the time, he wasn't working full time, no.
he working at all.
I don't think so, no.
He was watching the children.
That just worked best for us at the time.
And the house was bought in your name only.
Yes.
Why was that?
Well, I don't know if there was a particular reason, just because too, if I'm working, and having the income, that probably made more sense. And I don't think it mattered either because again, where's one? So it doesn't matter if it's in my name or his name, it's his house. So, yeah.
All right, so after closing, we just saw exhibit 18, email from Chris saying that he had told Mr. Tully April 15, 2018, month and 7 days after you purchased that home, there was a water problem.
Yes.
Were you involved with him telling Mr. Tully there was a problem within a month?
Yeah, because when it rained before the fence, you can see there was still a lot of water back there. So, yeah.
All right, so you saw there was a problem before the fence was put up.
Yeah.
The fence was approved, you saw on May 22nd. Excuse me, new application was filed May 22nd.
Right, yeah. It took about 30 days or something to get the approval. Yeah. Okay.
3.5 weeks or so.
Yes.
Whose idea was it to build a fence? Yours or Chris?
It was a combo because we just knew if Chris was okay, but I knew if Kyle went in the backyard, there's a big hill. I didn't want him to go up there, getting bitten by any rodents or snakes and stuff like that. So, because he was a runner, not anymore, thank goodness, but he was a runner. So.
Runner. Do you have problems with you in the apartment stuff being a runner?
No, because when we lived in an apartment, he was like 2. But as he started walking, yeah, you turn your head, he's gone. He's done it before. So
15, I think he's 10 right now. So they're about 10 and 5 time he walks the town hall.
Yeah.
Your question about whether you bought it with rapid waters, that's why you want to protect yourself from those or something, or because worry about the children, whatever.
I think it was a combination. I can't just pick just one reason, but if he had to ask me, it was because I didn't want anybody to come in and mess with the kids or them running away or, especially now that we have pets. So I don't want to make sure that they run away if they go back there, but they can't do that right now. So.
How long ago did you obtain your 2 dogs?
Okay, well, we have 2 dogs now, but we had a Basenji before the 2 dogs. Basenji is a mix from Congo, Africa, but we had to get rid of him. We found a Basenji rescue group just because he howled a lot. These are they're related to African wild dogs. So he would howl in the middle of the night. So I just wanted to make sure that didn't wake everybody up. But now we got the 2 miniature schnauzers, so.
The day of closing 2018, did you own a dog then?
No.
How long has it been?
2020.
Okay, so it's a factor now about the dogs, but the time they put.
No, it was really about the kids. It was really about Kyle not running away when he goes outside. That's what it was about, making sure that he was safe if he went outside.
Okay. So when did you realize there was a serious problem? far as the water problem?
It was at the same time that I noticed my husband did.
And approximately how long have you been in?
When he sent that email to Mike Tolly around that time.
And did Mike Colley ever respond back to you at that time saying it's not a problem or anything like that?
I don't remember the content of the email. So there was so many emails back and forth, so.
So what happens when you finally had heavy rains, when it's just got a small downpour, we had heavy rain? What did you observe before you complained?
This is before the fence, right? This is the timeline before the fence.
First time you saw heavy rain, what was the experience?
It was a lot of water, and we just couldn't figure out why it was just like pooling like right there by our window. So
So it wasn't just the swell you saw on the patio in those areas?
it was really the entire backyard. The entire backyard's covered with water, and if it rains long enough, it will back up to that door of the patio.
And did you observe when you looked out the window or the back door, whatever, what was coming from the neighbor's yard?
Am I looking to my left or my right? To the right. Eventually, what we noticed, not initially, because see, when it rained, and I don't know if it was like an omen, every time I went to work, it rained at 6 p.m. So it's nighttime. So a lot of time it rained at night. So until we achieved some type of floodlights back there, which we have with the cameras, you couldn't really see everything. But once everything started becoming apparent, they have our neighbors to our right has a crack in their slab. So there's water pouring out of that slab and water also coming off. And now that I know what's called a swell, it's coming from that way as well. So you have a couple of different directions the water's coming from.
You saw that personally?
Yes, with my own two eyes.
Night, couldn't see it, but when the daytime.
Yes, we try to every time if we have an opportunity to do it, because the first time I believe it actually happened, I must have been at work. But the next time it rained, my husband, he started recording. I started looking, I'm starting to understand the biggest scope of like what's actually happening. So.
When you bought your town, the first movie, there's already was a wooden dividing fence. between-
Yeah, that came like that. Yes. It's like a little privacy. I'm assuming it's a privacy situation. So, you know, if you're on your patio, you're not like looking at somebody right there. So.
So walking back door, there's a privacy fence on your right and a privacy. fence
Yes.
on your left.
Mhm.
One's what we've been seeing in all the pictures.
It's from the right, yeah, because it's a big drop off. It's like a stair step. So if I'm on my neighbor's patio, they can look over and look down at our backyard. Mhm.
Last question, we're kind of talking over each other.
I'm sorry. Okay, I apologize.
I'll try to wait till you finish.
Okay.
Thanks a lot, Tia. Okay, so with the fence next door, were you able to see all that was going on for while water was coming under it?
Eventually, yes.
Okay, so when you walked under and then overlooked under, what did you observe as far as the process?
Oh, I'm outside now, right? You're saying outside?
Yes.
So,
From the neighbor to the uphill.
so the neighbor to our right, they have a big, I call it a gash, but I don't think that's the right word. It was just an opening in their concrete slab. So water was coming through that, plus coming from, now that I know it's a swell, was coming into the backyard.
Right, so pretty soon on, you recognize the problem was some defect in the neighbor's slab.
Yeah.
And you try to go talk to your neighbor.
I think, yeah, we did, because they have a real estate agent at that time. We've had 3 neighbors next door since then. So, yeah, but initially, yes, we did.
Were they owners or renters?
I believe they're renters, because the true owners are not there. We spoke to the real estate agents and they didn't want to hear anything, because I don't want to go into that, but they didn't want to talk to us.
Was the problem also the language?
Yes, they were. Yeah, I think they were Korean, actually. Mhm.
Try to work with your neighbors, that did not work.
No.
What did you do next?
You know, I believe just putting in work orders and emails, just trying to figure out how can we fix this? Because at this point, we're not using the backyard because it's always saturated.
So we know in May, sent approval in, it approved in July, and about June, they put the fence in, and problem continues. So what did you do after the fence?
After we put the fence in,
Did you go to a association? Did you go to the Waters Edge, the builder? Who did you go to?
I know we try to reach out to Waters Edge Group. We try to reach out to Waters Edge Group. I want to say it was maybe a combination of both. Because I'm gonna be honest, I didn't realize And I keep saying this, you know, it's a process when you get a new home, you know, and learning different things as a property. So we thought Tolly was the HOA president because of all the correspondence that we had back and forth. We didn't meet Sean until like the fall of that year. So I know we spoke to Tolly management and we spoke to Water's Edge through emails, text messages, sometimes calling, but we also have a property manager, not a property manager, a community manager, like what was her name, Angela or Liz, because it was at Tolly Management. So they probably assigned somebody to like certain homes that you email. So we have multiple emails through these entities, you know, so.
Okay, you reached out to all these folks. Who's the first one that actually talked to you or came out about the water issue?
Oh, the first one, I remember Trevor being there. Trevor was there. And we told him about that situation.
Where was that true?
Yeah, right there. Yes. Mhm.
And when did you realize, or what, heard Chris talk about a little bit, but when did you realize water was getting into your town?
So Pest Ban was there because they, you know, you get these welcome packets and they tell you all these things that you get with your new home. Pest Ban was one. When I reached out to them, they said they don't come back and do some preventative maintenance. When they came there, they realized, I guess that these rings that they put in the ground that they have to bury, they realized they didn't bury any of them. So they wound up going in the backyard to dig up all that stuff to put the rings there. Plus they wanted to put some type of fluid in there to prevent, if we do have any issues, then, you know, ants or whatever, it would help. But when she sprayed it, shortly after that, that's when we noticed the discoloration on the wall.
Okay, so they put these spike type things in the back on the ground.
Yeah, I think they were rings, if I'm not mistaken. Yeah. Mhm.
Didn't have any problem with that.
No, that was okay. That was just a part of like, you know, talking to them and them coming out.
Okay, and so when they sprayed the baseboard stuff, what did you discover?
A couple of days later, because Kyle had a toy rolled under the couch. So I had to move the couch out the way. And that's when I said, Chris, come here. What is this? You know, it was just confused about where this color came from.
And that turned out to be what?
Well, water, now that we know, or, you know, whatever the effects of it was.
Right. Contact the Warden's Edge group.
Yes.
Trevor and did Chris Knight.
Chris, yeah, the project manager came out.
Did they come out together?
Yeah, I think they worked together. Yes.
Were you there when they came?
I was, because I was at the dining room table sitting down watching them, you know, so and my husband was talking to them.
What did you hear or say to them yourself?
I don't remember exactly verbatim what I said to them, you know, so because my husband was talking to them most of the time. So I was just like a witness there, just trying to figure out what's going on. So.
What do they say about it? Do they say there's a problem right with that, we'll fix it, or they say we'll let you investigate, or what?
Well, we were telling them what we were seeing and about the carpet. And when Trevor went to pull the baseboards off, he said, I bet you there's no water here. And then he confirmed shortly afterwards there was water there. Mhm.
All right, we've seen the picture, so they came out and took out the baseboard,
Mhm.
that picture. And then eventually they put new ones back in that took them good.
Not all of them. They only replaced half, okay? Did not replace the sheetrock. And we have to keep on painting the wall when it does, you know, the paint disappears. But he did have them delivered to us, so.
You say only half, but they're supposed to only replace half.
That's what was promised to us. They said they'll just replace all the baseboards in that living area because my dining room and living room is like a combination. So, yeah, they were going to do on that side by the windows because I have 3 windows. And then to the side where I have my dining room table, they told us they were going to do all of that, but they didn't replace it. But for that purpose of where the water intrusion was, that's what was replaced 2 months later.
You have any knowledge, understand, we heard testimony yesterday where the hole in the wall there, and they put ground in it or something to fill it. Were you there and they did any of that?
One more time, say that again.
We heard testimony that when they came out about the water problem, they saw like a hole in the fountain.
Yes, yes. Yeah, yes.
Had put ground or something into it. Did you see that? See what happened?
Who put that there? You mean Water's Edge?
Trevor or? Chris?
No, they didn't do that. The hole in the slab, they didn't fix that. They didn't do that.
Are you talking about the slab outdoors?
Yeah, our next door neighbor, that's never been fixed. I mean, well, they put a board up, the HOA, the people that they hired, they put cement there and put the wood there. Trevor did not put the cement there on the outside.
Tell me about the back wall. I think they said there was a hole or some kind of. Wood.
Yes, that's what they said. I didn't go ahead and see it, like standing next to them with them, but yeah, that's what they said they saw.
Okay. So you don't know, you wasn't there, don't know, yes, they did or not, put some kind of fix of the back wall.
That's what they said, Larry, but I'm not standing next to Chris because Chris was outside. I've never seen Trevor go outside. So Chris was outside. You can see his hands doing something, but I never got a report on what he did outside.
Okay.
Yeah.
After they did the work though, since then, we heard something might be wet or
Mhm.
whatever.
So the carpet, that's why we replaced it.
Okay. So did the carpet continue to get wet? Was it after that or only one time or what?
No, it was continuous because, just thinking about the water being wet all the time, that's going to lead to other issues. It's going to start stinking, so we had to replace it.
And did you talk to water it's about the problem that, hey, the water, because of your condition that having water, it's caused my carpets to stink and mildew and things. Did you talk to them about replacing the carpet?
I don't know if that was the language I'm gonna use. I think we kept talking about the problem, but I don't think I've ever said, Ian, I need you to replace my carpet. I never said that, no.
Okay. So we know by September, when they came out, talked about the fence problem, don't contact us anymore. Had you replaced the carpet by then?
You mean in 2018?
Yeah.
No.
Okay, so all September, he said, don't contact you anymore, go to a warranty.
Right. Yeah.
After that, replace your carpet,
Afterwards, yes. Mhm.
did that on your own.
I had to.
I'm sure the Mark claims exhibit 14.
Yes, no problem.
Remember what that is?
Oh, I was like, oh, where I wrote a check for that much. Yeah, I wrote a check to Delta Carpet, and this was the guy who came out that we. Oh.
You know what that is?
Oh, yes, I'm sorry.
Is that a check you wrote? And the-
Yes, an invoice, yes.
It's a check and invoice for what?
Carpet replacement.
Okay. Any objection, Mr. McLeod? I don't know who's handling this witness for the defendants.
Yeah, no objection, Your Honor.
Okay. Any objection, Mr. Dorsey?
No objection.
Ms. Wilson? All right. 14 is admitted. Plaintiff's 14.
For documentation, what was the date you wrote the check when they did the repair?
Oh, this is May 11th.
May 11, what year?
Oh, sorry, 2020.
All right, so it's 20 over a year after the
Yeah.
water's had been out to work in the yard and things like that.
Right.
What's this check for?
$2,112.32.
What did they do when they did that for?
They put the luxury vinyl tile down. Yeah,
So they took the carpet up altogether?
yes, they did.
You no longer have carpet?
No, they took it with them, or did we throw it out? I don't know if they took it with them, but they put the flooring down, yeah.
All right, so then you had tiles and then let's go back now to the water problem.
Okay.
What was going on when they put in the check dam, you see them do that work, came out?
Yes, because
Well,
on the second floor, you can see them, just doing work. Not them like the association, but you see men out there and you just don't know who they are, but they're doing something.
right.
Mhm.
And did you notice when they put the check down and things stayed the same, it worse or better, what?
I think it made it worse because I felt like more water was being diverted through okay, this is before or after the fence.
Well, that's the sense, but when they put the check down, I think the testimony's been, fence went in about July.
Okay, got you.
Check dam was put in.
Right. The check dam didn't help. It didn't help. No.
Did you have communications with Mr. Silverstone?
We did.
You did.
I'm sorry.
Did you have communication with Silverstone, the CEO, what was that?
Yes.
Let me show you the mark exhibit 10. Identify what that is that.
So at the top is, do we have to show it or do you want me to just identify it? Okay. Yeah, this is an email that was sent from my email address on Wednesday, August 8th at 10:29 p.m.
What year?
2018.
So this is email between you and Mr. Silverstone,
Yes.
August 8th, 2018. Is that correct?
Yes, that's correct.
All right, give me exhibit 10.
Any objection to Exhibit 10, Mr. McLeod?
There.
Ms. Wilson?
No, Your Honor.
Admitted.
So Let's read the first line. We say thank you.
Thank you. The only reason I used Pest Band because it was a big attraction and recommended by Water's Edge. I thought you guys have a contract with them since it's built into the house. Okay.
All right, so that's the best thing you're talking about. Terminating.
Yes, yes. Mhm.
So why did you contact Pest Band to begin with? You don't know that a couple of times. August 6th.
Why did we contact Pest Band? I don't know how to answer that because we weren't having like termite issues or anything, but we're going through our welcome packet. And it might have even said to call them for preventative maintenance or every so often. So I'm thinking that's the reason. So.
Okay,
Mhm.
go ahead and read the rest.
Sure. So I stopped that. So please, I need help with this issue. Also, they are blaming the builders for a leak on video. Also, I found out termite stations were not even installed. They are welcome anytime from 9 a.m. to 2 p.m.
So look at the one sentence you said. I need help with the issue. Also, they are blaming the builder for a leak on the video. Who's blaming the builder?
But the issue, also I guess Pest Ban are blaming the builders for a leak on video.
You typed this?
I did, but I'm gonna be honest, Larry, sometimes when you're typing things, this is 10:29 p.m. I mean, I don't know exactly what I meant by that, but so we have plenty of videos, but it's probably one of the earlier videos.
So this would be a video that you or Chris took, you sent it.
Mm-hmm. Mm-hmm.
This email from Mr. Silverstein. Right?
Yes. Mm-hmm.
So you sent it video released by August 8th, 2018.
Yes.
So here's the video about the leak.
Okay.
They drop down when he responds back to you the same day, August the 8th.
Oh, okay. Gotcha. Mm-hmm.
It says the topic. Go ahead and read the first.
Sure. It says, I took a sabbatical with my wife and family. I'm just getting back into town. We will take care of any issues in the house and water flow from the house to the property's drainage system.
Was that company to know that Water's Edge Group said, we're going to take care, we're going to solve all the water problems for you?
Well, I mean, that's what it says in the sentence. Let me read that again. Hold on. We will take care of any issues in the house and water flow. So that means from outside the house to the property's drainage system. That's what it sounds like to me.
And when you got that on, how do you feel?
I felt pretty confident, you know.
At that time, they hadn't done anything to make you should distrust him or.
No, not at that time. I mean, the one time that I met him, he seemed very respectful at the time. Mm-hmm.
The next paragraph.
Okay, sure. So water drainage to the detention area was final platted by the original developer and approved by Gwinnett County. It is not in our preview. Trevor will meet with the inspector to see if there's anything we can do to help. But ultimately, this is an HOA issue, or maybe the original developer, if they are still around.
All right, so let me ask that. So right away, they're coming, not us probably. We'll get more stuff for you.
It's like two things, and yeah.
Might be the association, it might be someone else.
Yeah.
That's what you're hearing.
Yeah. Mhm.
Right. Had you at that time that you'd already been talking with Trevor with the management
Mhm.
company, association?
Mhm, mhm.
And that
You need
might
to
be-
say
no.
yes or no.
I'm sorry.
It's okay.
I know you're going to keep me in check. Yes.
All right. What had Trevor told you about fixing the problem?
He said he was going to replace the baseboards.
Go back.
Okay.
You said really you talked about totally about the water problem back in April, May.
Okay, yes.
And
Okay.
before you talked to Silverstone.
Right.
And so what was totally the management plan to do or not do, or what direction did they give?
I can't speak to it. Is it in an email?
We're gonna go through all of it.
I know. It's overwhelming in my brain right now. I'm not sure. He probably told us to speak to the builder.
I want you to speculate. If you don't remember, that's okay. It was a few years ago. So either you remember or you don't.
At this time, I can't remember, but if I remember it while I'm on here, can I recall? Okay, all right.
You know what I'm saying? You reached out to Mr. Silverstone. You know why you picked the email Mr. Silverstone about this problem?
I didn't feel like there was a blockage between us. I felt like I could reach out to him if there was an issue, you know, since we bought one of his houses. He didn't say like, do not contact me after you sign all your life away for this house, you know, so.
You met Mr. Silverstone.
Yes, right.
And After that, between the time of closing and Salt Lake, have you had any other communication with Silverstone?
You mean before this email?
Yes.
I don't think
You
so.
don't remember? That's fine.
I don't remember. I'm gonna say I don't remember.
So then read the third paragraph.
Okay, sure. So third paragraph says, your house is not anywhere close to floodplain. I also do not see anything that is a major issue or for you to be sad about.
Let me ask you about that.
Okay.
No major is not to be sad about. Was you and Chris concerned about the problem? Was it having impacted your family at this time?
Absolutely.
How was it impacting you at that time?
I mean, because, this is our first house and we're already having issues. And it's not just any house. This is a brand new home. And I guess looking back on it, we thought that if we're going to have issues, it wasn't going to come up at least into a couple of years, hopefully, nothing major. So the fact that after, shortly after we get our brand new house, first time home buyers from New York, we come down here and you got all these issues, we just feel disappointed. Yeah.
So you said nothing for you to be sad about. Then we'll read the next.
Sure. So from what I can see, you may have waiting a little long prior to informing us about the issues. He says from what he can see. Okay.
So does that mean, refresh your memory, was that the first time maybe you reached out to him or do you not?
I don't know.
Okay.
I don't know.
So read the last thing.
Sure. Please let me know sometimes when it would be convenient for you to meet with Trevor and Chris. Trevor's calendar fills up pretty quickly. Salon. Best regards.
So
He's saying goodbye. Yeah.
all right. And so here he says Chris and Trevor. So this would be before the base course replaced.
Yeah. Yes. I believe so. Yes.
I won't go through all of that. We've heard
Yes.
10 times already.
Yeah.
So Trevor, Chris came out, base course replaced.
Mhm.
Eventually, you heard from Ms. Silverstone, it's the fence, we're not going to do any more work.
Yes. I remember that email. Yeah.
Do you have personal conversations with Silverstone?
Yeah. Yeah, I spoke to him on the phone and then my husband got on the phone. So we were like on speaker talking to him. And he said, he said, we're done. We're not coming back out there. Just go ahead and speak to, I don't know if he said speak to the HOA, but he just basically was clear about he was done.
Some emails, things we already do.
Yeah.
Do you say go to board?
Yes, that's right. Because we had to put that, we had to go through a portal to put in, a request for people to come out, take a look at it.
So did you do exactly what he recommended that you do?
With that, yes.
All right, so you went to portal, make a complaint to the warranty company and they came out.
Yes, they did.
We've seen all the things and then they denied the water part of your claim.
Right.
Did you talk to Silverstone more about?
Yes, I'm sure we did. Yes.
And as far as, was he cooperative and wanted to meet with you, talk about it further or what?
After the warranty issue, I don't think I've ever had like a phone call with him. Now, probably text messages and emails, but I know if I called, I don't think he picked up. That was not something, we never had a conversation. This is my first time seeing him since I closed. So
we heard testimony on that. Chris and some things say, I'm going to sue you. Did you ever see anything from Mr. Silverstone about suing you? About a small suit or anything?
he said on the voice, not the voicemail, he said on the phone, because they're going back and forth, they're talking to each other. He said, you go ahead and sue. He said, you're going to lose. That's what he said.
All right, you were in the room?
Yes, I was in the room. I heard it verbatim that he said that we're going to lose.
You wouldn't know when that was?
Probably this year, it had to be during 2018.
Okay.
Yeah.
All right, so we've done all the testimony, we won't go through everything.
Right.
Well, let me ask you talking to Mr. Smith, the association president, did he say anything to you about Blake's warranty time?
So just because out of respect, I don't always talk to like men like that. If I'm going to talk to him, usually my husband is present. I've had a couple of conversations. He's called me, but then I just try to have my husband talk to him. But I remember him saying every time he would speak to my husband, just wait, don't worry, we'll take care of you. Just wait till the warranty runs out. So that was said repeatedly.
All right. So when you did the warranty and you understood you have a 1-year period.
Yes.
You personally, you and Chris decided, we're not going to appeal the fact that the warranty company says the fence area, your backyard not covered by warranty.
Right.
Why did you decide not to do it?
You just said it. If it's not covered, what is there to appeal? You know what I'm saying? So I'm gonna sit there and go to arbitration and talk to somebody about something that's not covered. It doesn't make any sense to me.
Right.
Yeah.
So where's that, at that time, didn't, as the warrant came back, they didn't do any more work out there.
Water's Edge, no.
And that was after they put in the check down.
Yes, they did the check
They
down.
did the work as well.
They put the rocks, yes.
Did the problem go away and get better?
No, it did not.
All right, so a year goes by,
Yes.
March 2019,
Okay.
time for the warning runs out. Did you have any more conversation? with Silverstone?
Not with Silverstone, I mean, email. So conversation, email, text, phone, but not phone. I haven't spoken to him on the phone, no.
Okay, so it's an email. We heard testimony back on May 11th.
Okay.
2019, the Gray Engineering report came out, when did their inspection. And then on May-
You said raise engineering? Okay,
Gray
sorry.
Engineering First.
Okay.
and then May 8th, 2019, Alan Duck did his proposal about fixing the back.
Right.
Had you had any interaction with Alan Duck before the landscaper?
I've seen his company in the neighborhood. Now that I know like who's tied to who. And the first one, Raise Engineering, that honestly, you didn't even know about this until this situation that we're in right now with the suit, so.
So you saw what, you got a copy of Mr. Duckett's proposal about how to fix the slab next door and fix the swell and things of that nature?
Did we get a copy of it?
You,
I don't think so. I've never seen it.
okay, so you don't, now let me give you another.
If you could refresh, if I have it in an email, if it was emailed to me, show it to me, Larry, but I don't like off the top of my head, no.
This report out on May 8th, this is email that you sent Ms. Silverstone.
Okay.
later,
Okay.
May 10th, then you hear back from him. Here's the email he sent. Could you identify exhibit 15, please?
Okay. So it says from Chris.
I just tell, look at the date.
Yes, so I'm gonna say the date. So it's Wednesday, November 20th, 2019. So it's from Chris to, wait, which one are we looking at here? This is exhibit 15.
Supposedly 15, but I just heard Ms. Ibezims say November and Mr. Stewart is saying May, so I'm confused.
I'm
Let
sorry.
me look at it for you.
Okay,
You see at the very top, that's when Chris emailed it to me. It shows he
Okay.
Emailed it to me in
Right.
November 2019.
yes,
But down below, it shows Mr. Silverstone, from Ms. Silverstone, on May 10th, 2019.
yes.
And it's sent to you and several other folks.
Okay, yes,
So his email to you was on May 10th, 2019, correct?
yes, correct.
Before we look at it, I tend to exhibit 15.
Any objection, Mr. McLeod?
Trying to find it, Your Honor, apologize.
No, Your Honor.
No objection. All right, Ms. Wilson? All right, it's admitted.
All right, so again, what's the date of that? email?
Sorry, I'm sorry. It's just so many things here. So now Friday, May 10th, 2019, that's from Ian.
May 10th, 2019.
Okay,
Okay, can you read very short, what did he write you on May 10th? This is after, a month after the warranty runs out.
okay. Right.
After the warranty run out.
Yeah. Yes, and it says subject is water seepage. So it says as previously reported, see attached, your issue is incorrect installation of the fence that you installed and refuse to correct. Remove your fence, correct the grading. How can you correct grading? I'm just realizing that now.
Of course,
Correct.
that's not in what you're reading, so you need to just read what's in there.
Okay, all
Okay.
right. So correct the grading, and if there is still an issue, we will look at it.
All right, stop there.
Mm-hmm.
He tells you, remove your fence. Now, he told you that many times before, but you take the fence down, you're gonna have a problem back in 2018. You remember that?
To remove, I don't think he tells to remove. This is the first time I think in an email say to remove the fence. I know he said the problem was the fence.
You say repair, to make it better, or do something with the fence.
Right.
Then told to do that.
Yes,
All right, so here he is,
saying to remove it.
2 months after your warranty expired, saying, remove your fence. Then said, correct the grading. Did you have any thoughts of going out and working with swell or trying to fix the grading?
No,
Did you believe at that time you had the authority to hire someone to go out and change your swell?
no, because we own the inside of our condo outside, I don't even know if we're just learning all these terms. So grading probably was a new term for me as well, so.
Okay, so he tells you, move your fence, fix the grading. If there is still an issue, we will look at it. So he said he'll come back out, right?
Oh, and if there's still an issue, we will look at it, yes. Mhm.
You didn't ever remove your fence, right?
No,
HO Association, Mrs. Smith never told you to move the fence.
no, absolutely not, no.
No one at that association told you.
Nobody, no,
No one even told you to modify the fence.
No.
It wasn't fine.
no.
I heard Ms. Smith say, he said the fence is not even an issue because it's working.
He agreed with us.
You're leading and it's time for lunch. So I understand, but I am, because it's time for lunch.
I mean, I will stop right there.
Great, perfect. Ladies and gentlemen, let's be back at 1:20, where we will pick up with the direct examination of Ms. Ibezims. Ms. Ibezims, during lunch, you're free to talk to Mr. Stewart, just not about the substance of your testimony, okay?
No problem.
All right.
Mhm.
Hello, Mr. Stewart. All right, Mr. Stewart, anything before we break for lunch?
I was trying to worry about how long it's going to take, because, you know, I promised you by noon I'd be done, but 3.5
We
hours.
are at 12:20.
I thought my whole case would be done. Okay, nothing else, Your Honor.
All right, Mr. McLeod, Mr. Dorsey, I guess it'd actually be Ms. Wilson. Let's be back at 1:10, just in case there are things we need to talk about. I'll try to be back here at 1:10.
When do you plan on addressing the whole verdict form issue, as it is very prevalent as we walk in the defendant's case in chief? And
I don't know what you mean by addressing it. We've been talking about it throughout. You know where I am now with it, which is,
I meant, when do you expect on rendering a formal opinion?
I'll change if someone brings up reasons why I shouldn't, but you know where I am right now. So could it change during the charge conference? Yes, it could change during the charge conference, but I've shared with you my thinking right now. Okay.
Thank you.
All right. See you guys at 1:10. We can go off the record. Thank you.
Leave these papers right here.
Yes, ma'am. The lawyers will manage that.
Are you doing good?
That's what we're excited.
I'm talking too fast for this, so that's good.
My other one was. Yeah. The one I wore yesterday, I can't either.
Talk about a meeting. I sure hope you say it. I know, that's. It actually struck me. Hey, come on. Okay, going ahead.
Yeah, I'd love to know about this special training. Let me get one.
You probably expect me to have lunch.
Come on, Sean, you get the
Come with it. You guys want to have lunch, you want to stay here and work?
Where are you going to lunch?
I don't know, just some sandwich shop, try to do the best.
I wouldn't mind a sandwich, or you,
I would like to leave the courtroom, so
Okay.
I'll just go for the trip.
Okay, come on.
grab. That would be. Okay. All right. Sorry.
That's like the same day.
No, please. I'm sure that. They do so. Okay, so. So. Come through trash can. Sorry. $52 to, well, I don't know, $38. $5.
Yeah, $5.
5 daughters, 5 marriages.
I do not put a list.
My mom was also $45, so. According to her parents, all the time, but he did learn a lot of stuff about like what is it?
And shoes.
Yeah.
For goodness sakes, never she, my daughter's a boy.
And I bought over the years. I have 2 daughters. I have 3 brothers. I'm a twin brother. I'm a twin. So I've never been to the dollar farm at all, really. 2 daughters and it's been a revelation, to say the least. And it's really has been the most biggest revelation. It's been $1 that is something that I have never been still. Years.
Interesting.
That's a good lesson. Can I call you about that too? I mean, in fact, I might call you sooner about that.
That's why I've been working for 50 years. I just don't want to be part of that drama. But I tell you, the testimony flows. Periods come and go. What, back in, once they get emancipated, once they're out of the house, you know, so, I mean, we become friends rather than father. My daughter still call me daddy. And they ask me, Daddy, what do you? Tells me to go to you. So here I am with this advice. To me, what I would do.
How you doing? Did you get a good lunch break?
I did, thank you.
Excellent. It was all right. We have everyone we need. We do. All right, let's go back on the record, Mr. Casanos.
Back on the record, 1:12 PM.
All right. Mr. Stewart, I'll start with you. You're on your final witness.
Yes, Your Honor.
All right. And after the complete examination of Ms. Ibezims, you plan on resting. Correct. Okay. You take a break to work through whatever legal arguments are brought up as a result of plaintiff's resting. Mr. McLeod, you've got all the witnesses you need here to present your case if we keep going.
Yes, Your Honor.
All right. And then Mr. Dorsey, I don't know if anything has changed because of the way I'm envisioning the structure of the verdict form. Are you still planning on putting up witnesses after Mr. McLeod's done?
It would really just depend on who exactly he calls, but I think we can handle all of it. If not, there may be a very, very short effect. But we will have one witness at absolute most.
Okay.
And I'm not gonna replow ground, so.
Appreciated. And I bet the jurors would say the same thing. Mr. Stewart, is there anything you want to cover right now? We've got a few minutes. The jurors aren't late yet. I don't know if they're all back. They're not all back. So we've got a few minutes. You also can just be at ease, but we've got a few minutes.
I don't have anything, Your Honor.
Okay. Did you have a case you wanted me to look at that stands for the proposition, 2 different issues. One that stands for the proposition that there is no apportionment in nuisance cases. Or 2, I'm pretty sure you have one on the second one, that addressing this question of control and continuing nuisances. If you were the original source of the nuisance, but you don't control it anymore legally or physically, you still could be part of the group liable for the continuing. And you mentioned some case.
I gave you Green versus Eastern Land that directly fronts that issue.
And what was the site for that?
It
Was that the 284 Georgia appeals?
643.
643. Okay, I've got that. I'll need to look at that.
One paragraph, if you want me to read it to you, I'll be glad to.
What page is that one paragraph on?
I mean,
Is that 284 Georgia Ave, 623, is that?
Yes, sir.
Okay.
Well, unless it's a 50-page opinion, I'll probably find what you're talking about.
It's on 645.
Okay. And I have a draft charge from Ms. Niles that I will try to make some headway on during your examination of witnesses so that then I can get it to you all so that we can talk about it after we let the jurors go home today, since it's Thursday. Mr. McLeod, anything we need to be talking about?
Not just on the.
Okay. Mr. Dorsey? Okay, well, if you'll let us know, Deputy Gordon, when we get all our jurors, we will start then. They'll be shocked.
Page 648.
Mr. Stewart,
You
Ms.
still there? 648. Page
Six-
640.
Okay, 640.
645, address it, 648 gives the answer.
Ms. Ibezim is nearby.
Yes, they're out the hall.
Okay.
Number 2 on 648.
Okay.
Yeah, that Walmart. Yeah. So you just. Shirley dropped off first, then Justin and David, they both dropped off. And yeah, she kept saying it was us. Like I told them, I felt like they talked about it.
I just gotta go sit back up here.
That's fine.
She was smart. She was smart. And nice. Fire. That's a shit. Yeah. So, yeah, it got crazy. You love me. Yeah, yeah. I said that. The board approved it, Andrew, unfortunately, in your eyes, it says like. Yeah. Why was this? Because Andre says, I'm like, you can't answer that. That's why I think you get to answer that because you're the cause of it. She's something wrong with her. It really is. It really is. She answered this. The first time she Chad, you know, Chad. Yeah, that's just even. Yeah. Driveways there. Yes, they are. And so. Three of them said, listen. Yeah, I'm sure he did. I'm sure he did. And they were picking and choosing who to do, everything. Because they had, oh, my neck is not. It's like, one of them. She raised.
We're good? Okay. Mr. McLeod. Oh, okay, that's fine. Just letting you know the jurors are here, so we're gonna bring them in. All right. Mr. Stewart, if you'll come back to the podium.
Okay.
Jurors.
All right, so jurors. Jurors are present.
Thank you, Deputy Gordon. You all can be seated. Deputy Gordon taking okay care of you all? Good, all right. I have to do periodic reports on him. Never know. All right, he lives another day. We broke for lunch in the middle of, and I'm sorry for interrupting it, but it was lunchtime, and our firefighter was going to get angry if we didn't break for lunch. No, it was time to break.
Take your time.
But we were in the middle of Mr. Stewart's examination of Ms. Ibezim, and we will pick up where you left off, sir.
Back up chronologically, we went to the letter, email, it was all day 2018. Silverstone wrote you, where he said, we will take care of any issues with house, the water from the house into the property drainage system. And then he did the work, did the check dam, when stocks, or whatever, things of that nature. Y'all complaining again, it wasn't working. Then he said, hey, I'm not doing more, go to warranty. General. That was introduced in the exhibit 22 with the warranty report came out on September 28, 2018, where they said it's not covered by the warranty. Then after that,
Your Honor, he's leading the witness.
I'm depressed. We're getting right to the question. Start. We got up to May 10th.
Okay, so you're on notice now. Folks are going to be objecting to leading. I do think here it was a well-played objection, but I think what's happening right now, I find that Mr. Stewart is simply reorienting juror, all of us, witness in particular, as to where we're picking up. And so I expect we won't hear a narrative like this going forward. But if the second question is like that and you object, sustained. Okay,
Understood.
all right.
Thank you.
You're welcome.
All right, so warrant came back, September 2018, denied. 12 months expired in March. Then we went to a letter that's used, email Mrs. Silverstone to you, May 10th, 2019. Even though this is after you already said it died in the warranty and all that, you sent an email to you. We were just reading that.
Okay.
Plaintiff Exhibit 15.
Okay,
I'll read, we just went over the first paragraph, I'll read that to you. He wrote, as police reported, MCC attacks, your issue is incorrect installation of the fence that you installed and refused to correct. Remove your fence, correct the grading, if there's still an issue, we will look at it. In the next, we will, one more sentence in the letter, what do you say? Email.
okay, can you hear me okay?
Yes, I can.
Okay. Other than that, there is nothing we can do. If you still disagree, QBW has an arbitration process that you can follow. Best regards.
Okay. Now, this is 2 months after your warranty expired. What did you understand it to mean that you go to QBW, who's the 210 warranty company? Were you able to do that after they already denied it? You didn't meet the 30-day bill deadline? 1 year expired? What's he talking about? Go to QBW? Do you have any understanding of that?
I do not, because it's after, basically he's telling us that he can't do nothing else for us.
Okay. So at that time, you understood the warranty wasn't going to work. He wasn't going to do anything for you. Was the problem still going on?
Absolutely, yes.
In fact, it's still going on for today.
Yes.
Objection, Your Honor, he's leading the witness.
That's a yes or no question. How's that be? It's still going on today?
Okay, I heard you say, and it's still going on today, as opposed to, is it and subtle, but just don't be suggesting the answers in your questions. You developed a certain cadence because there were no objections towards the end of your examination before lunch. Hey, I appreciate that, but I'll overrule the objection here based on how you've clarified your question, but we'll all be mindful of leading. Thank you.
Yeah. So now we get up. Letter we just read, and then on May 14th, the defendant sent us to exhibit D28. May 14th, 2019. This is an email that you sent to Mr. Smith, Association President. Look over that. It's already been admitted to evidence, so it's not.
Thank you. Larry, I'm just reading it to myself first so I can, okay. Okay, I recognize the email.
Okay, so what's that email again?
This is May 14th, Tuesday, May 14th, 2019.
Context, we introduced evidence. Grading report was done on my earlier on May 11th. And the Allen Duck report was done May 8th, 6 days before this email you sent to the association president. Read what you first. Read the email.
Can you, you're welcome to do that. I just want to make sure I'm following. What exhibit number from the defense did you say it was? I just don't remember.
It's D28.
28. Got it. Thank you.
So this is from May 14th, 2019.
You wrote this, right?
It's under my email, says from Tia Ibezim.
You wrote it, that's you, right?
I am Tia Ibezim.
I want to make sure we're not, you didn't take somebody's email, that's your email.
Yes.
But so we're clear, because you're not saying, yes, you wrote it. We've also heard that your husband sometimes writes emails from under your address. This is in evidence, it's not going to change whether it's admitted. But do you recall writing that? Is it possible that your husband wrote it? Just so we're clear, because your lawyer is pressing you about you having written it, and you have simply said, "It's my email address."
I did say that. Well, I'm going to say right now, I don't remember writing everything in here, because when we write emails under ibezimfamily80@gmail, it says 1. So I could be sitting at the computer and he's telling me he's writing the email. So
So either came from Chris or you, but.
yes, I do recognize the email for sure. Mhm.
Read the email.
I will read it. It says, Sean, I'm not sure what is going on here, but either you are not informing Mike of everything that you have told my husband, or you both don't give a flying F on what is going on. I am requesting a report from Alan, the landscaper who came to my house last week. I want to know what the solution is. We are out of warranty, so please, please, please don't mention the builder anymore. They cannot help us. Alan stayed, the grading is done wrong and he was not even sure what he needs to do. We need to have a verbal conversation. And then I have my phone number and times that I can be reached.
Okay. That was on May 14th. You wrote that to Ms. Smith.
Yes.
We know that the report for Alan was issued on May 8th, 6 days earlier. You hadn't seen it yet.
I have not seen a report from Alan, the landscaper, no.
Okay. Then on June 10th is when we get the Elmina report.
Right, yes. I remember them coming out to our home. Mhm.
Did you get an email from Mrs. Smith on June 10th?
Yes, was that around we had a meeting around that time.
Right before the meeting, he sent your email about what, you still have your phone with you?
Oof, Kyle has my phone.
Oh, you got it right there? It's not right.
Got it.
Oh, you got it,
I
okay.
from him.
Okay,
We want to introduce that as also your refresh your memories. Read the email.
Okay, sure.
On June 10th.
okay, thank you.
He's already been there. Mr. Bishop.
Yes, no problem. June 10th. Okay, so this is from Sean Smith. June 10th, I had to blow it up. June 10th at 11:51 a.m. So it says Chris and Tia. Oh, can I read it? Is that okay?
You want to just
If it's in evidence, you need to let us know what, I understand this is a proxy. So if it's not in evidence, then no one should be reading.
Okay, I apologize then. No problem. I apologize. I thought I was reading it.
Before we go any further, Ms. Wilson?
I'm gonna object to the extent that we don't know which exhibit this is.
This is email from Mr. Sonic.
So it's not an exhibit, it's being used to refresh a recollection, which is why it should not be read aloud. This simply is something, Ms. Ibezim, you can look at. And if that
Right.
refreshes your recollection, you can then answer questions from your lawyer. But you need to be careful that in answering them, you're not simply reading from whatever this document is.
I apologize. I think I
You haven't done
misunderstood.
anything wrong.
Okay,
You haven't-
okay.
I just, when your lawyer was going to ask you to read it into the record, then he paused, and that was correct. It's not in the record.
Okay,
So you understand the posture we're in now. You may want to see it. You're entitled to see what's being used to refresh someone's recollection. But it's not in the record. There's not an exhibit number to attach to it right now.
Yes.
Okay.
Thank you.
This is being added because of Sean Smith's testimony.
But you shouldn't
Got you.
talk about why it's being, you're not testifying. You're, see what questions you can get from her.
Objection, is this something that was produced in discovery first?
Oh, yeah, June 10th.
June 10th, what year?
this is 2019. Okay,
Remember yesterday, that's when you had your meeting with the firemen. People got
Yes.
together about that time.
I do remember.
So keep reading that.
I'm gonna
Yes,
read
Ms.
it. Let
Wilson.
me just read it myself real quick.
If I could also please review the email.
Right. So I'm gonna let her read it, and then before, well, They may have it, but much like you didn't seem to be able to find something you had produced, it may be that finding one email in the haystack of emails is tricky. So let's have Ms. Ibezim read it, and then we'll have Ms. Wilson read it.
I'll have them both.
Great.
You have this?
I'm having to do the on the
Okay, I do remember, I recall this email. Okay. So my memory's been refreshed.
That's an email that you received from Mr. Smith on June 10th.
Yes.
11. All right, so this is my type of the one we just read. It's like the other one you sent to him. I have to read that to refresh your memory. What's your understanding as far as his direction to you and your family about contacting him?
Do not.
What about
Contact.
going to any board meetings, things like that?
I wouldn't feel comfortable after receiving an email like that.
Like you read the email, do you give any directions about whether it should come to board meetings and things like that?
Not in this email. Let me look at it one more time. Looking at this email, it doesn't say any, it's not referring to don't come to a board meeting. It doesn't say that verbatim.
So just in general, then, what is your understanding, his direction you about working with him in the future about?
Dude, we cannot. That's what I got from the email, that I wouldn't be able to contact him.
That's for you and Chris?
It says it's addressed to me and my husband.
So June 10th, the same day they got the Albino report, you see this email from Mrs. Smith.
Yes.
But that day or a day or two later, they had the meeting.
Yes. I think it might have been June 11th, if I'm recalling. Yeah.
The next day.
Yes. Mhm.
Were you and your husband both invited?
So we were invited via email, but it was literally 3 hours before the meeting. And I just happened to, because I check my email often, and I checked it. And if I could recall, the email was at 3 something, and it was from Mr. Tolley. And it told us that we're going to review the engineering report, bring your concerns, but it also was direction, do not bring my husband.
You were invited, but Chris was not.
Right, absolutely, yeah.
And did you attend the meeting on June 11th?
We did, we all came.
So your husband did come?
It's not, yeah, but our family, we went to the meeting,
Two sons.
and my 2 sons came, yes.
What do you call? We heard Mr. Smith say it was very cordial, nice meeting. What happened during that meeting?
When we came in, the board was already seated, and there was a table where I assumed that me and my husband will be sitting at. And then we reviewed I don't know if we reviewed the report. I think they just reviewed what we're going to do to the house as far as what the issue was.
Did they tell you they had made a decision? Or did you see that?
No, that was going to come later. We were told, I believe by Mike, that they would get in contact with us. And we wanted to see a copy of the report because they had it in their hands, but we were told it would be sent to us later.
Okay, so you didn't get the report, but you were told there was a report.
I believe it was in their hands when they had it in front of them. Yeah, but they wouldn't give it to us like in real time.
The same thing to you about when they're going to make the decision, what would come next?
I believe the words were shortly. We'll make a decision shortly or soon, to that effect.
Did you or Chris have any input in that meeting or discussion about what your views?
We were able to show videos of what was going on to the board, because I want to say this is the first time we had a chance to have the entire board, because a lot of the communication was between the HOA president. So the whole board was there, and we had an opportunity to show them videos of our problems.
Was those the same videos we saw?
Yes, it was.
It was adjourned, and what happened next?
We went home, and then I want to say maybe a day or two, we received an email from Tolley.
Generally, what do they tell you if they want to do?
At the meeting, they didn't know what they wanted to do. They told us what option they were gonna choose.
Okay. And did the rule ever change about don't contact me anymore, Mr. Smith?
I've never received any to this day to say that, oh, it's okay for us to communicate. That was like the last time we should have, really, unless because of the roof was leaking, but other than that, we haven't had any other conversation.
And you heard Mr. Smith say that he filed a protective order, tried to get.
He did,
Did you know
sorry,
about that before court?
before this court? No, I did not. No. We didn't know that he went to the police. This is kind of like a discovery for us with some things. So this was the first time that I heard of that.
You heard it during this trial about it.
Yes, that was the first time I heard it. Attached to the email, there was something handwritten to us. It was like an attachment to say that don't come near his house or whatever. But this is the first time that I'm hearing that he actually went to the police station to report. I'm not sure what, but to talk to them.
You wouldn't have any knowledge about what day he filed that or how long after this meeting?
So on the email, there's an attachment about what he said, don't come near him. The day that he went to the police station, well, what he said in his testimony that he went.
What do you know?
Okay, I don't know. I don't know exactly the day he went to the police station. I don't.
All right, it's come into evidence that you filed your lawsuit in Gwinnett County, you and your husband.
Yes.
1st of July 2019.
Yes.
So this is like 3 weeks after this meeting.
Right, yeah, we're on time order.
All right, and after that, about 2 months later, that you filed the Gwinnett action, is when preventive maintenance came out and tried to implement the repairs.
Preventative maintenance through the HOA?
Right.
Yes.
All right, and so when they did their repairs, that you filed the lawsuit, how did that help or not help?
It didn't help because when the, we're calling them maintenance men who came to the home, they put a board up and some cement, but water at some point kept coming around that. So it may not have come up from that direct area, but it just went around it. And it, to me, it made it worse.
All right, so yesterday we saw exhibit 21 was the picture there with the board.
Right, yes.
You personally go out there and look at that.
Not in that moment because my husband was outside, but after they left, we looked at it and we took pictures.
And have you stood in the window on a rainy day and looked down?
Yes. Mm-hmm.
What's the result of what they did from that board up?
Well, the board is wet when it's raining and there's water that's coming, it's spilling out on, sorry about that, on the sides and on top, along with the water that's coming underneath the slab.
Still coming on your property.
Yes, it is.
All right. You heard Mr. Smith say he didn't know anything about work in time. I heard your husband say that he was there and he saw Ms. Smith.
Yes, we did.
Were you there when they did that work?
Yes, I was there. Yeah, I was at the dining room table when it was being done.
All right, so did you look out the window?
I did. Mm-hmm.
You know who actually was out there doing the work?
There was a couple of men there doing work. And then on the other side of the fence, Sean was standing there.
You saw Sean too?
I did see Sean. Because as soon as my husband saw him, he said, guess who's out here? And he pointed and Sean was right over the fence.
All right. It was introduced about the $6,000 repair of the rebuild of the paper.
Yes. Okay.
There listed 6 items. Does it say anything about the slab or doing putting the board up or anything?
Is
You know
there?
who actually did the work?
No.
I know Sean was there. Do you know if they worked for Water's Edge or who they worked?
We didn't know who they were. But can I say something real quick? There was a tag on our door.
You're answering his questions, and you can't bring up things that don't relate to the question that's in front of you.
It does.
Okay, I think what you're about to say. While that was going on, did someone knock on your door?
Yes, they left a tag with their phone number. That's what I was going to say.
Okay. Whose phone number was that, or as far as you know what
They-
company it was, or who the individual was?
It went to a voicemail.
Okay, so was a tag that was put on your door? Or
Yeah, it was on the doorknob.
what meaning went to voicemail?
When we called, they said, we'll be back on this day and time to do whatever work. When we called, it went to voicemail.
Okay.
Yes,
Why were you calling that number?
because we wanted to know what was the next step, like what exactly is going to be done.
Well, did they believe they had finished, or they plan to come back? What did they
This is before they did the work.
Okay. All right, So was that Sunday before they came out there that you saw them put the board up, or the day of the board?
So before the work was done in the backyard, there was a tag on the door with a phone number saying that we're going to come to do the work in the back. I don't know exactly what it said, Larry. It was like a door tag. We called it and went to voicemail. Then on the day that the work was supposed to be done, they came out there to do that because it was like a reminder, just making sure your fence is open so we can get in to do the work. That's what it said on the door tag.
Okay.
Yes,
They all worked fine as far as you did inside, they did the work.
yes.
They left after they did the work. What happened next time it rained?
Next time it rained, it still flooded. It wasn't fixed.
And that was after the lawsuit was filed?
So the lawsuit was filed in August. They did the work in that summertime. So we're talking about 2019 summer. Okay.
That time you didn't, Fred, instructed not to have any contact with Mr. Smith or the association.
No, don't call him after that.
Mr. Silverstone told you not to contact, have any more communication for history.
Right.
You'd already submitted the application for warranty and they denied it. That's right.
That's correct.
Where did you go next?
Where could you go? I remember somebody from Gwinnett County came out to kind of look at what we were doing, the whole situation. So to see if our steps were okay or appropriate.
When you say steps, meaning the steps that had been taken or like the front steps of your house?
So let me restate that then. So the guy who came from Gwinnett County to tell us, okay, is this right? Like all this flooding and everything, what could be the cause? Because at this point, we're trying to figure out what our next move is. In addition to continuing to contact, we did contact the HOA, put work orders in, but, can't call Sean, I can't call Tolly. We had their numbers, but at that point we can't, not Tolly, sorry, Ian, I meant to say Ian and HOA. So, yeah.
Okay, but steps as in steps that were taken, not that there was an issue with some steps in your house.
Oh, no, not
Okay.
that, no.
Was there anywhere else you thought you could go or just do the work yourself and everything kind of fixed?
I would not be able to do that work myself. I would have to hire somebody, but I really felt like, that if the outside of it is not, it's limited common areas. So for us, we needed to either still speak to the builders or we needed to speak to the HOA. To me, it was like either or.
Do you have authority or right or ability to do work on the neighbor's yard?
No, because we tried to talk to them.
We heard about did their work, they hired the $6,000 work, they connected the pipes to the ground.
Yes, I remember that.
We heard more testimony about whether the swell is better or worse. What is your viewpoint from that time forward? When it rains heavily, is the swell now better or fixed or not?
I don't think it's fixed.
Three options, I believe.
If it's not suggesting the answer, isn't it true that X happened?
Right, and at first he did start with asking her what happened, but then he proceeded with suggesting answers to that question. And at that point, the question became
Okay, why don't you simply say what happened? What happened next, as opposed to which of these three do you like the most of the options I'm giving you?
Tell in your own words. Next
Okay.
time you had heavy rain, was the problem solved as we heard?
It was not.
What kind of problem did you have after they did everything that was done by orders ed, everything that was done by the association?
So every time it rained, the water that collected by our window to the right still remained. That was a problem. And then also too, on the other side of that privacy fence that we have, that's where the pipe leads out onto our neighbor's slab. So now when if it rains heavy, that water somehow overfills our gutters. And so now if you look out my right window, it looks like it's a waterfall. It's copious amounts of water that falls from there. And it wasn't like that before the HOA did the work.
You said the gutters above your house, your unit and the unit next door, there's a heavy rain, what do you see?
Like a waterfall. You look outside, it's literally water because it's so loud. It's like, okay, what's going on outside? I see light rain, but in my mind, that water is like collecting up there. So something must be trapped or clogged.
And You were told to go to the portal. Have y'all reported that to them?
Yes, we have.
The problem, with gutters overflowing?
Yes, we have a work order for that.
Has anybody ever fixed that problem?
So we were sent, some roofers came out because there was some leaking up there. And then when the guy from the roof came, he said that the roof was soft. And so now my husband's just asking him questions, what could be cause of it? And he said, because if your gutters are backing out and that water is just kind of sitting there, it's like wearing down that area there.
The answer contains hearsay, Your Honor.
Okay.
I move to strike.
True,
the
okay.
answer.
All right. That was, ladies and gentlemen, whatever Ms. Ibezim just shared with you that she or her husband were told by the roofer, you should disregard. We need the roofer here to tell us that. It's okay. Your lawyer's going to need to stop you when you start because we're now getting objections.
Okay.
All right.
I see that.
All right.
Do you know who hired the roofer to come out?
I'm going to say the HOA. HOA.
Are you guessing? Do you have?
I know it wasn't the builder. So because of our work order through the HOA must have sent him.
So you went to the portal and afterwards someone came to do that?
Yes.
And did the problem get better after the roofer left?
Temporarily. And then it started happening again because you can hear when it rains, you can hear it raining in that spot specifically because if you were to go outside, you don't hear it, but inside you hear it like pouring.
All right, so that's a problem on your patio or within your unit. But what about the swell itself? If you didn't know the drain things, is that much better?
A little bit, but if I have to be honest, since I'm up here, I don't always look out there. I'm always just looking in our backyard, even though those two can be related. It's over to the right and runs through behind our fence. So.
Complaints about the fence, things of that nature. You're talking just still. You've been told you had to remove your fence, would you move it?
I would ask for, is there any other options first?
Why is that?
I feel like there's always options. Like if you're sick, do I need to take these antibiotics or do I need to drink something first, like vitamin C? Can I doctor myself up before I just go to the antibiotics? There should be options for a lot of things.
All right, so the last 3 or 4 years, this is lawsuit's been filing. Has the problem changed?
No, it has not.
Is it still a problem with heavy rain come?
When it rains very heavy, it's still a problem.
Let me ask you about you and your husband. One email you read said, please, 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 we're usually polite, nice.
Please to me is trying to be polite, but like urgent to me, like, please, please, please help us. Like, what's our next step?
So were you ever personally have run-ins with Mr. Smith or with Mr. Silverstone?
No, I've never had personal run-ins, never, to me, bad words between us.
You heard that Mr. Smith said that him and your husband got along pretty good at first, but things turned bad. Was your husband towards most of these people that came out?
Yes, he was.
Were you there several times?
I'm home because I work at night. So I'm home during the day all the time.
When you asked politely and asked them to do this, and things of that nature, did it help?
It did not help.
Were you upset and frustrated?
All the time.
Did your husband eventually get more upset? Said things probably shouldn't have said?
When I'm upset, I usually get upset with tears. And then my husband gets upset because he can't fix the problem. So I'm sure that as a man, he just wants to do what's right for the family or his wife.
As far as the fact they wouldn't do anything, how does that impact you and your husband, children, as far as unhappiness or frustration?
The fact that we, had permission to put the fence up and we could just have like a little bit of space for our children and our pets, we can't use that space now. So as far as the way that we intended to, because it's always saturated and wet.
We actually heard testimony, actually, owns a gun.
Who doesn't in Georgia? Yes, he owns a gun.
Is it a licensed gun?
Yes, it is licensed, although the law just recently changed where you don't need a license anymore.
Right. Was there any time you saw him have the gun out with these workers, Smith, Silverstone?
Absolutely not.
Did you ever threaten anyone with the gun?
Absolutely not.
I was like, I asked, you don't know anything at all about what.
So don't, if you can't ask, don't ask.
Well, I was saying, do you know anything what was in the protective order, what they allegation? You've seen it today, you know allegation.
No, other than what's in the email where Sean sent to us. Now, if there was allegations that he said to the police, I don't know what he said to them.
So how's this impacting your children today as far as going outside, or they have, be older now?
They're older, yeah. They don't go out in the backyard. I'll take them to the park if they need to go outside.
Do you help them go in the back now?
Well, I mean, not really, not if it's wet.
Do you have any concerns of safety?
Safety as far as like someone coming to our home.
From the water?
Well, I don't want the water to come into our home anymore. You know, I feel like that's going to be an issue because we're going to be dealing with it for years to come.
So are you comfortable letting your kids go out there when it's not raining and things like that?
Mhm.
So you are still enjoying your house somewhat?
Inside the house, yes.
5 years later, the day you bought the house, now dead, you're all over again. You know, anything you could have done different, solve this problem.
Different. I need more time to think about that because there's so many steps. It's really kind of catapulted into so many different issues and people involved. It's been overwhelming. So
What about harassing? Did you, your husband, you both make lots of phone calls?
we had to. We made phone calls. We sent emails and text messages and work orders. I mean, that's just a form of communication to let them know things are going on. Okay.
Mr. Pai? Mr. McLeod, you'll help with exhibits if there are exhibits that'll be going to Ms. Ibezim. Thank you.
Everything that your husband went over earlier. I've got to use some of my time. I would like you to confirm a few things for us.
I'll do my best.
Between the time that you first identified this home as a home that you'd like to buy, signed a contract, and you eventually closed, that was a month or so's period of time?
Yes. You mean from the time the earnest money and then go into sign like it's official? Okay.
And during that time, you came to the home and toured it, every room of the home. That's probably the beginning of the process.
Right.
And confirmed that was a home you wanted to buy.
At that time, yeah.
And then there was a pre-closing walkthrough.
It was.
Builder's representative. Was
Yes,
that punch list on some nail pops or things like that?
it was. Mhm.
And those were taken care of. And during that period of time, you had an opportunity to look at the backyard.
May I speak on that, or is this just yes or no questions?
So you do your best to answer upfront with a yes or no, but you always get to explain. So
Okay.
it could be maybe, it could be, I don't know, but it's yes or no. I did have the opportunity, but I was sick at the time. So whatever your answer is, but please
Right.
feel free to
So
explain.
I'm going to say yes, we looked in the backyard. We didn't spend a lot of time, and the issue we're having now, there's hay down. So you don't see that initially when you're looking out there. So
Well, let's make it clear. During this period of time and your various trips to the home, you did not see anything indicating water intrusion in the home.
at the time, no.
And you did not see anything on the patio area that concerns you about water accumulation.
At the time, I don't think I did, no.
If you had, you would have brought it to the attention of the building.
Absolutely, yes. Mhm.
So whatever the design of the drainage system or the construction of the building was up until that time, there was no indication of a water problem.
No indication of a water problem. Yeah,
That you saw,
that I saw, yes, yeah,
or that your husband saw.
right.
Okay, so you closed the deal. You knew this was a planned development with the homeowners association. Right,
Did I know it was a plan? So after we bought our home, I'm gonna say no, just because these new terms were coming to us as far as being a part of a HOA. So I think I learned that either during closing or right after closing, after going through everything. Did I answer your question?
well, let me see. Are you saying that you bought a home and did not know that you were going to be a member of a homeowners association that had certain rules and regulations?
Right, because in New York, they don't have a lot of HOAs. So when I came down here, this is like a new term for us is HOAs. Everybody owned their home and took care of their own property in New York, so.
We can show you the deed, but you now know that the deed in writing says you're subject to the.
I know now, yes, I do know now.
You have learned that probably a painful detail, that there are subdivision covenants about rules, and one of those is the creation of a homeowners association.
Yes, after reading through all that paperwork, I had to study and highlight and educate myself more on what we were getting into.
And I know that's a good thing to do. There was nothing that kept you from doing that in advance, was there?
But there was no indication that I was looking for it either.
Now, we've talked about the builder's warranty.
Yes,
You were given a builder's warranty at the closing, correct?
the 210 warranty, yes.
And that came with a pamphlet and you read some other papers.
Yes, it was like in a folder, yeah.
And you understood that that was an incentive by the builder to give to the purchaser, saying you have the protection of this warranty post-closing.
Yes,
Okay.
but there's an explanation after that. After going through it, then you kind of know what it covers and not covered, so yes.
And you eventually filed a claim on the warranty.
Yes, we did. You have a copy of it, I'm sure.
Yes, ma'am, and it's probably in evidence, but we don't need to take the time
Mhm.
to deal with that. One of the issues that you brought to the attention of the warranty company was the water problem, right?
Okay, yes.
And the response of the warranty company was to say the builders agreed to correct certain problems,
Right,
but certain problems are not covered by the warranty.
right. And it was considered unwarrantable, that situation, yeah.
Now, it did not surprise you, did it, that if the builder were not responsible for the problem you were complaining about, that wouldn't be subject to the warranty, would it? It wasn't, if it wasn't part of the construction of the house, he would not be responsible for it, would be warranted.
Say that one more time. Can you repeat your question?
Pretty different.
Okay, thank you.
You understood that the common areas were owned by and were the responsibility of the homeowners association.
Yes, I do now, because there's a difference between common and then limited common, so yeah.
So a builder's warranty would not warrant issues on property not owned and sold by the builder, such as the common areas. That would not be warrantable with it. The builder's warranty wouldn't warrant something about the common areas that it hadn't been owned.
But then why would Ian say, go ahead and put in a warranty claim? I was instructed to do that.
And part of your warranty claim was upheld. Builder agreed to do the work and did do the work.
He didn't do it. It wasn't, I'm not going to say correct because not all of it was done, what was told was going to be done.
At any rate, and we can, I'd be glad to show you the paper if you like. One of the findings by the warranty company was they saw no evidence of pool water, standing water. You remember that?
No, do you have a copy for me?
I'll be glad to.
Thank you. I want to refresh my memory before I just speak on it.
Yes, ma'am. That's defendants 22 and 23.
So 22 I have is in evidence. I don't have 23 as being in evidence yet.
I was thinking of something else.
Okay. It doesn't mean you can't share it with her if 23 is what you need. 22? All right.
Thank you. What is this I'm looking at? Oops, sorry.
I believe it's on page 2. And at one point it says, no evidence of standing water, pool water, something like that.
So are you looking at the same sheet I'm looking at, sir? I'm looking at page 2. Sure, no problem. I'm sorry.
Okay, right here.
Okay.
No evidence that water is ponding at the rear of the house. That's what I was trying to mistake.
No evidence that water is ponding at the rear of the house on this day, and this is March 2nd, but did it rain recently that day or?
You're not allowed to ask me questions. You realize part of the finding of the warranty company, they saw no evidence of water, right?
That's what it says here.
Okay. And you thought there was evidence of water, whatever the word is.
It says here, so no evidence that water is ponding at the rear of the house. And then you just said, I thought that there was.
Did you not believe that you had evidence contradicting that finding?
Oh, yes, I did have evidence. Yeah. Okay, just want to make sure.
Good basis to appeal, wouldn't it?
Is that the same thing as arbitration?
Are you not able to answer my question?
Okay, so ask me the question again then.
First page, please.
Okay.
Does it not say that you can file an appeal and then go through the arbitration process?
What part? Because you just said, look at this, because this has many things here. So if you point it out to me, then I can look at it faster. So it's. Okay. Mhm.
And I don't want to hover over you.
No, it's okay.
Please note, if you disagree with these determinations in this letter, you must notify us in the next 30 days of your disagreement. Your next step in the warranty process is to proceed with arbitration.
Okay.
Right, so
I thought
you were-
I thought I asked you
were
that.
advised generally of the process to challenge the arbitration award that you disagree with.
I'm sorry, say that one more time. What was your question?
You were advised in a letter from the warranty company, generally of the process to challenge the award that you disagreed with. Notifying them within 30 days, proceeding with arbitration. They told you if you would contact them, they'd send you the forms.
I mean, if it says it there, then yes, but I don't think that's the end to it all, but I'm gonna say yes for now.
And you decided not to appeal, I use that word, not to challenge arbitration. Okay.
Wait, did I answer the question?
Which question?
Oh, I thought you were saying a question. I'm sorry.
Question was, you decided not to challenge arbitration.
Okay, yes.
Now, the documents before us, we can look at them again.
Okay,
You and your husband decided you wanted to have a fence, correct?
correct.
And you knew that to do that, you had to ask permission.
Yes,
Because among other things, the property on which the fence would be constructed actually belonged to the HOA.
the property under the, oh, well, yes, yes. Mhm.
And you applied for the fence and were granted permission to build the fence.
We were.
And I think you said they had a fence builder that they recommended.
Yeah, Pennington Fence Company was recommended.
Up until that time, there had been no evidence of water intrusion in the house that you knew of. had there? Or up until.
Oh, when I applied for the fence.
Up until the time you constructed the fence,
Mm-hmm.
there had been no evidence of water intrusion into your home.
No, because we're moving into the summer, I believe, when,
You're in every room of your home every day, don't you, ma'am?
well, yes.
Okay.
Are you okay? Are you
So what's
okay?
the summer have to do with whether you saw any water intrusion?
That's not what I said. I was trying to remind myself that it was the summer of that year when the water intrusion happened.
I mean, up until the time you constructed the fence, there was no evidence that you knew of water intrusion into your home.
So the fence went up in that summer. Okay. Not that I guess I'm gonna say no right now. No.
All right, so we've gone from closing in March, maybe contract in February, so February into the summer, no evidence of water intrusion, and you build a fence. And part of the reason you want.
Can I stop you for 1 second? I'm thinking about pest ban. When did pest ban come?
He can't answer that for you.
Okay. Okay, continue, sir. Go ahead. I don't think it's here. Oh, here it is right here. So August 2018, I just need to remind myself because when you ask me a question about a specific date, I want to make sure I'm on the right timeline.
After the fence was constructed, that's when you began to experience water issues.
After the fence was constructed, after pest ban came, after pest ban came, that's a couple of days, that's when we noticed it, so.
And when did that company come in relation?
That same summer, yes.
But you don't recall if pest ban, and you've explained, pest ban comes, remove the baseboards, oh, there's evidence of water intrusion. You don't recall if pest ban came before or after the fence went up?
They
They
probably came after. I don't have everything laid out, like that timeline. That would have been great to have in front of me, so, yeah.
Well, this is your case, man. You do what you need to do to state your case. Okay. Fence constructed, cat ban, or whatever the name of it was, comes out, removes some, and were they connected with some extermination? Yeah. Did you have?
We didn't have it. They were just, I think they're for preventative issues. Yeah.
And they find some moisture behind some board.
They were spraying, their chemicals, whatever.
You okay? It's okay. Mr. Pye, keep going.
I'm going. Now, I don't know that we need to go through a lot of these letters, they're in the record. Your husband often communicated with the both of you, sometimes using your email.
Yes,
Because you worked at night and he was not working.
yes,
And when he felt like he was frustrated with not getting responses, he took to communicating directly with the homeowner association president, John Smith, right?
Sean gave us his number to text him, yes.
You knew that there was a procedure. The homeowner association has responsibility for 150 units or something like that.
Right,
They had hired a management company. And there was a procedure in the portal. If you had a complaint or request, put it in the portal. It goes to the appropriate people and so forth. And the communication directly with the homeowner association president was not consistent with that general procedure for requesting help.
so may I speak on that?
Well, you are aware that communication directly with the president is not consistent with the general procedure.
I found out that Sean was the president September of that year. I didn't know who he was until September. So all this time we communicated through the portal and with Mike Tolley.
Before you ask your next question, is Ibezim, I don't know, you're shorter than your husband, so you stay right where you are. I'm gonna have you angle the monitor a little bit. We're
Okay.
only capturing like your ear. But if you turn I don't know how long the cord is, so I don't want you to snap anything, but you're doing a great job with the microphone. If you could get into your speaking position and see if by rotating the monitor, I guess the left side towards the edge.
Like this?
No,
the
the
other
other way. I just don't know how long the cord is. And then now pull there. Excellent.
go.
Now you
Okay,
can
all
use
right.
the microphone in the very effective way it works,
Okay, all right.
and people can see you.
I
Thank
was
you.
trying so people can hear me. Okay.
Thank you.
And so the communications from Mr. Smith, please don't contact me directly. We're requesting that you use the procedure.
He didn't say that, but he said, don't contact him again. Yeah.
Can you imagine what it would be like for a volunteer HOA officer to get 150 emails a day from everybody in the
I can't think about it because in that moment I hate to say that, think about everybody else. I was thinking about our situation. Okay.
Well, you can at least understand a little bit that Mr. Smith was perhaps a little overwhelmed with communication too.
No, because he has a property manager that helps him with that and an HOA board.
Which you were not communicating with.
Say that again.
Anyway,
I asked a question and you moved on. No problem.
all right. Now, your husband described the room that looks out on the patio as the living room.
Yes, yes. Well, the dining room area, then living room, yes.
And he said you don't use it anymore except for the dog.
The dogs, they took over the first floor, yes.
Okay, well, I've had dogs. Is there any furniture in the room?
There's furniture, there's the couch and the dining room table.
Okay. Television?
On the wall, yes.
Okay. But the dogs have taken over.
Yeah, and we want them to be active and run around. They run around the island, so yeah.
Okay. Now, you have identified a check and invoice to Delta Carpet in the amount of $2,112.52.
Yes,
Which
I just saw that.
replaced the carpet with,
Oh, it's not here. Yes. Mhm. Yes,
And when was that? What year?
2020.
2020.
Mhm.
So you had been there for over 2 years.
2 years, yeah,
Okay, and you've since been there 3 more years.
yes.
Okay, but you have not replaced the carpet well, excuse me, you've not replaced the laminate flooring, done any other out-of-pocket repairs.
Was I supposed to replace the laminate flooring?
Let me put it this way.
Okay,
Is the amount of $2,112.52, is that the total amount of out-of-pocket expenses you have incurred in connection with your effort to quote, repair or correct the water issue in the house?
and inside the house, also paint. We bought paint to touch up the bottom right above the baseboards.
You know how much the paint costs?
Not off the top of my head, I don't know. I'm sure I can go online and find out.
If you don't know, we don't know. So all we know is we are sitting in this 4th day of trial is that you spent $2,112.52 3 years ago to replace the carpet with laminate floors. And that the room still remains furnished, but is occupied by the dogs.
It's occupied by the dogs and the wall is still discolored. You forgot to mention that.
Okay. Well, we don't have any photographs of what that room looks like today, do we?
Are you asking me, do I or do we as a
In
unit?
evidence, do we have?
Okay, in evidence, I do not think so. Currently, no.
First, I will show you 27 and ask you if this appears to be a letter from the warranty company with a cover sheet to you dated May 13, 2018. Recognize that letter?
Can I have an opportunity just to review it real quick?
Yes.
So I reread this. This is from the man who came out to our home.
Yes, ma'am. Offer defendants 27.
Mr. Stewart, any objection to defendants 27?
No, Your Honor.
Ms. Wilson? It's admitted.
All right, Mr. Professor, let me just ask you a little bit. We can publish.
Yeah, if we could get it on the screen, that would help. I think you can go pop. What was there?
There's a cover sheet, and then there's the actual letter on page 2.
You want me to read now? Mrs. Ibezim, a defect inspection was performed at your home on September 23rd, 2018, in response to your September 11th, 2018 complaint. In terms of the grading, the issues seem to be primarily concerned with a fence you had installed after closing on the house. The defect inspection did find issues, and the builder addressed those warrantable issues. Now you have resubmitted with water intrusion issue on May 10th, 2019. This issue is no longer warrantable since your home is more than 1 year old. The past complaint you filed has expired based on section, what is that, 6? Of the limited warranty agreement, given that it has been about 7 months since your builder worked on your home. If you disagree with our assessment, your next step is to, in the process, is to proceed with arbitration. Sincerely, Brian.
So you apparently resubmitted the water issue to the warranty company.
That's what it says in the second paragraph.
Is that your recollection?
I'm looking at this, yes.
Okay, and once again, it was denied because the house is more than 1 year old. You waited more than a year to submit the issue for warranty. Isn't that right?
When I answer, can I speak on that?
Well, answer the question and you can explain your answer.
Sure.
You waited more than a year to submit the water issue to the arbitration company or resubmit it to the arbitration company.
Right. So in between that, there's a lot of events that have taken place as far as speaking to the HOA president, as far as us waiting to telling us to wait until the warranty expires. So that does kind of play into that as well.
All right. Now, you say the HOA asked you to wait,
The HOA president, Sean Smith.
not anyone with the building.
I haven't, no, I don't think Ian said to wait he said to go back to them.
So you waited and did not prosecute your rights under the warranty agreement. And then you sued the homeowners association in Gwinnett County.
Then you said I serve? Repeat your question, I'm sorry.
You waited, the homeowners association president, Mr. Smith.
Yes,
Advised you not to pursue your rights under the builder warranty to let it time pass, which you did. And then you sued the homeowner association in Gwinnett County.
that's the first time, yes.
And then the suit was withdrawn, and now you filed this suit, not against the homeowner association, but against the builder.
Yes, that's why we're here.
Okay, yes, ma'am. Thank you. No more questions at this time, Your Honor. Thank you.
Ms. Wilson, do you have questions for Ms. Ibezims?
I do, Your Honor. Good afternoon, Ms. Ibezims.
Hi,
I just want to make sure I understood you correctly on a few points.
okay.
You testified earlier that you're claiming a total of $2,112.32 in monetary expenses as a result of this water runoff issue, right?
You said that, say that question one more time, I'm claiming.
You testified earlier that you're claiming a total of $2,112.32 in monetary expenses as a result of
What we paid out of pocket, that's what you're saying? Okay, yes. Mhm.
That's correct?
That's correct.
And you only had to have baseboards replaced once, correct?
The time, yeah, that one time we replaced the baseboards that are still discolored above it, yes.
But my question was, you've only had them replaced once.
We had them replaced once, yes.
And you testified previously that you guys have only repainted twice, correct?
Did I testify that?
Yes, you testified to that.
So twice is meaning in two, because it's been more than twice, because I know when my mother-in-law came, we were painting the whole house just to like touch it up. So it's been more than twice.
So it's your testimony today that you have painted more than twice.
Yes, it's been a few times.
When was the last time you painted?
I don't always paint. My husband usually paints. I'll help out with touch-ups if the walls get scuffed up.
But you've only replaced the flooring once, correct?
Correct, yes.
And when you did that, you replaced the carpet with luxury vinyl tile.
Yes.
If you could, for me to finish.
Oh, I'm sorry, it wasn't intentional. Mm-hmm.
Thanks. I just want to make sure that everybody's able to understand.
Okay.
And other than those things that I just listed, you testified that there wasn't anything else that you had to have replaced or had to have fixed inside the residence, correct?
You said, did you just say that I testified? Or are you asking me a question?
Yes, I'm saying, isn't it correct that you testified that there wasn't anything else that you had to have replaced or had to have fixed inside the residence?
When you say
Connection
that,
with the water intrusion, or like maybe they had a broken window in the.
Yes, all of this is in connection with the water intrusion.
right, so that area still needs to be attended to, but I have not done anything further, no.
And you and your husband, you only had to pay for the flooring, not the baseboards being replaced, correct?
No, that was delivered to us, no.
So when you say no, you're saying that I am correct, you did not have to pay for that baseboard.
You're correct with that, yes.
You do need to let her finish, though. You know your answer, but you can't buzz in early. Make sure she's done with her question before you answer.
Okay, I think I'm just gonna count to 10 in my head, so if I take too long, no, seriously, because I'm not doing it on purpose, but go ahead.
Count to 3.
Okay,
Not 10.
okay.
It's okay. I know it feels conversational, but just for the sake of the record and
Okay.
I'll also do my best to try to not talk over you.
Okay, thank you.
And you testified that you started noticing this water runoff issue shortly after you moved in, correct?
Correct.
And you observed that it was the grade of the land that prevented the water from properly running off your property, correct?
Correct.
So from the time that you moved in on March 9th, 2018, up to that point when you first noticed the water intrusion issue, no changes had been made to the dirt or the area outside your residence, right?
May I talk and ask a question to that? Because
You can talk, again, you could say, I don't understand your question.
I don't understand. Can you rephrase it, please?
Sure.
Oh, thank you.
You guys moved in to your home on March 9th, 2018.
Yes,
You testified that you started noticing the water runoff issue shortly after you moved in.
yes,
So between the time that you guys moved in on March 9th of 2018 and when you first noticed the water intrusion issue, no changes had been made to the dirt or the area behind your residence, right?
no, that's not correct.
So you've never testified that from the time you moved in on March 9th, 2018, up to the point when you first noticed the water intrusion issue, no changes had been made to the dirt or area behind your residence.
By us, but things are moving constantly. So those are changes to me with the erosion. Things are constantly moving. So that's a change to me.
But in terms of a landscaper or
Okay,
developer,
so that's probably what I needed to hear. No, no.
But nature changing things because it rains. And so now
Right.
there's dirt over here instead of there.
Right,
That-
yes, okay, yes.
And I think it's clear that what we're talking about here is not necessarily nature, but actions that people took in relation to that area behind your house, right?
Referring, yes, and referring to the slope and grading, this is what I'm referring to right now.
And you testified earlier today that this is a very important issue for your family, correct?
Correct.
But aside from calling Water's Edge Group and getting other people to act, you and your husband have not done anything to mitigate this issue, right?
Not correct.
So you have done something to mitigate this issue.
We called, I'm about to say Westchester County, Gwinnett County. We called Gwinnett County for somebody, 2 people came out from Gwinnett County. It was like a mid-level, and then that person's supervisor came out, trying to get more insight to what else can be done or what's causing the problem.
And my question acknowledged that you might have called other people or
To survey.
said you were trying to get other people to act to solve the issue. I'm talking about whether you and your husband took actions to mitigate this issue yourselves.
What we did when it rained, and so I have a question. I can ask you a question. We did things. I was going to ask her, is this before or after the fence
Just
in general?
generally.
So what I was going to say is that when it does rain and when we had to remove all the hay from our backyard area, just because it was when it rained and it got underneath the fence, it would get clogged. So we would have to push it from underneath under the gap. So to me, that's doing something to try to let the water, flow freely. So, yeah.
And when was that?
It's ongoing. It's from the beginning when we started to up to this day. And we have sandbags out there to protect our HVAC. So to me, those are actions. Hopefully that answers your question or?
Yes.
Okay.
So when you say the beginning, you're talking about 2018.
I am referring to 2018, yes.
And I heard you testify earlier that you didn't want to continue to talk to Mr. Silverstone about the issue because your words, out of respect, you don't speak to men like that. Is that correct?
I did say that. That is correct. May I speak on that? Just because?
Well,
okay, you're not finished. Go ahead.
Follow-up question. Were you saying that as women, we have to choose between respecting men and for ourselves and our families?
That's not what I said.
But you just agreed that you said, out of respect, you don't speak to men like that in regards to
the house.
Mr. Silverstone to help you with issues going on at your property.
So when I said that, when I'm talking about the time I was in my garage and Sean came up, it was just more appropriate that my husband spoke to him. So we're all in the know.
And I'm gonna go back to what we were talking about, how you were saying you had done some things to mitigate this.
Okay.
Now, let me object. Mitigation is not an issue in this case. This is a nuisance case. Mitigate, my clients have no duty to mitigate. Even though they've done things he's testified to, it's improper to go into mitigation.
They're claiming damages, mitigation of, or evidence of whether they took any action to mitigate those damages should be admissible. It goes to.
So in a negligence case, that might be, or in many tort cases, but do you have a case as opposed to just standing up and saying it, Mr. Stewart?
The code section itself says there's no duty to mitigate until.
All right, so what would that code section be?
Would be 51, the same code section says you have to mitigate in the negligence case. It's 2 sentences.
Okay, but that doesn't give me a number, does it?
I don't have it off the top of my head. 51-3-1 perhaps, off the top of my head, maybe.
Let's see.
I think it's on the question charge on.
That's not where it is, but I'm not disagreeing with you, but before I preclude an area of inquiry, I would like a little more legal basis than you said so.
Well, you keep talking on it, I'll Google it and see if I can find it for you.
No one else do that. Jurors, you may not Google. He's not a juror, so it's okay to Google. Don't suggest that, Mr. Stewart. Yikes. Shame on you.
Bad example, I apologize.
Yeah. But you say, I'll look it up on LexisNexis, to which I have a paid subscription. And then, all right. So why don't you state your question again, and we'll explore it a little bit, but I may foreclose that. I'm not disagreeing with Mr. Stewart. I'm just looking for legal support for his claim. He seems pretty certain about it.
I don't think it's necessary for me to restate it before moving on to, I guess, where I was going with that.
Okay.
Or prior testimony.
I found it, Your Honor.
Okay. I'm listening.
OCJ 51-12-11. I was off a little bit. I'll read it to you. When a person is injured by negligence of another, he may mitigate his damage as far as is perceptible by the use of ordinary care and diligence. However, this duty to mitigate does not apply in cases of positive and continuous torts. This is a positive and continuous tort of negligence, and therefore it has no duty to mitigate.
And while it may be a continuing tort, we're talking about things that happened in the past right now. So I think whether they did things to mitigate the issue themselves is relevant.
I'm not ignoring you. I'm just looking at something linked to 51-12-11.
There's a 1903 case. Your Honor, that-
Yeah, I don't want your 1903 case. Thank you.
Still good law.
Okay.
Still one of my cases.
Yeah. Defense counsel, Mr. Pye. Okay, I think that I agree with Mr. Stewart, but I think you've moved on. Just don't frame your question in terms of mitigation. If you're asking Ms. Ibezim about something she's already testified to, you're free to do that. But framing it in terms of you needed to, or you did this to mitigate, I think the M word was the tripwire for Mr. Stewart. Correctly so.
And yeah, to clarify.
Hold on one second. Mr. Kyle.
Your Honor, would you take a look at 230 Georgia Appeals 872 West versus CSX Transport? And I guess she will proceed.
Right. I'm going to direct you to proceed with some non-mitigation questions, and then we may circle back.
Your Honor, to save time, we will waive our objection. So you can go ahead and ask every question once about mitigation. Make it move along faster, that'd be fine.
Well, thank you, Mr. Stewart. So that doesn't give you carte blanche to ask for hearsay, but you can ask about mitigation. I'm still going to read this case.
Yeah, I promise I'll still play by the rules.
Okay.
All right. So I think it's been fully fleshed out that you previously testified that. All right, and you remember being deposed in this case, correct?
Tell me what depose means.
Given a deposition.
Yes,
And you remember giving deposition testimony in March of 2022?
it happened last year. Yes,
And you remember it was at your lawyer's office?
it was.
Your lawyer, Mr. Stewart, was there. Mr. Dorsey was there. Sean Smith, Mike Tolley, they were all there, correct?
Tell me who Mr. Dorsey is. Okay, yes, that young man was there. Yes.
And when you gave that deposition, do you remember the court reporter speaking to you and being sworn in to tell the truth, the whole truth, and nothing but the truth?
That usually is the procedure. Yes.
Have you been in a lot of depositions?
That was actually my first one, but I seen it on TV.
Judge, I'm approaching to get the sealed deposition transcript of Ms. Ibezims. Permission to break the seal.
Permission granted.
So we're all on the same page. It is sealed. Ms. Ibezims, I'm going to hand this to you. That is your original deposition. I'm going to direct you to page 21. Line 8. Let me know when you're there. So I'm going to read aloud, and I want you to follow along in your head and read along with me.
You said you're gonna read? You said you're gonna read? Okay,
I'm going to read it, but I want you to read along with me.
okay.
The question was, since you started noticing the water, aside from calling Water's Edge and trying to get other people to act, have you or your husband done anything to try to mitigate the water or reroute the water or do anything like that? Your answer, no, because I don't think we knew where to begin first. So we wasn't going to do anything, and someone says, why did you do that? So we brought it to the attention of the builder and our HOA. And we were just doing a lot of online research to see what could be done to improve it. But that's about it. We never physically did anything. Did I read that correctly?
You did. I'm wondering if I knew what mitigate meant back then. And I'm not trying to be funny, but words are thrown at you, so, okay.
But it's fair to say, conversationally, if you have a question about something that's being asked, like you have today, you would ask for clarification about that question before answering it, right?
If you think you're answering it okay, you won't. But looking back on it, you're thinking, well, in what terms do you mean? What do we do to anything? Because that's normal. If your backyard is junky or messed up or sloshy, you may do something to do it. But I think maybe we understood as paying somebody to alter the landscape or to add something or take something away. I'm thinking this is how I understood it at that time.
So you do not think it's fair to say that if you answered the question, that wouldn't demonstrate that you understood the question? Line 15, you clearly answer no. And then on line 20, you clearly say, but we never physically did anything.
To the effect of hiring somebody to alter and et cetera, what I just said.
We can read the question again, but the question says, have you or your husband done anything to try to mitigate the water or reroute the water or do anything like that? Am I reading the question correctly?
You are reading it correctly, but okay.
So was your testimony true in March of 2022, or is it true today?
Say that again, because if I say no, then it means I lied, and I'm not lying to that effect as far as hiring somebody to come and do anything, so.
The question was your testimony true in March of 2022?
That was true, yes.
And just a few more questions, which I think we will agree on.
Are we referring back to this or should I put it up?
No, you can put that down.
Okay.
So about the fence, you don't dispute that you applied for the fence in May of 2018.
I do not know.
And you ultimately ended up having the fence built back there, correct?
Correct.
And Pennington Fence Company built the fence, right?
Correct.
And you've been in here this week, you've been sitting there in the back with your kids, right?
Yes.
So you heard your husband testify that since you guys put the cameras up, you haven't locked the fence, right?
I heard part of it. I had to leave at one point.
Do you have any reason to disagree with his testimony that since you put the cameras up, you have never locked the fence?
Correct. If that's what he said, then yes.
Correct, that you don't have any reason to disagree with that?
I don't have a reason to disagree with him, no.
Thank you, Mr. Beslin. Those are all the questions I have.
Thank you.
Mr. Stewart, any redirect?
2 minutes, Your Honor.
You did well last time, so I'm encouraged by hearing that.
I'm running.
I'm like dazed.
You get to read where from your. You still have this right here, right?
The deposition.
Where the warranty people came back and said, you filled, and they said no. Is that the one right there?
It's a letter. Sorry, there's a letter to me and my husband by.
What's the date of that letter?
So is this it? This is the warranty. No, this is not. I think there was another one. There was another.
Well,
Yeah,
this-
yeah, that's it. Yeah.
Let me just fast, just wait, my 2 minutes.
Okay.
running out. May 13th, 2019, you got this letter,
Yes.
and it says your time's expired, it was denied, right?
Yes.
Okay. And we read earlier, your May 18th, 2019 letter, which was 3 days before that.
Okay.
And you're asking, you didn't apply for that thing again? Read again, the last sentence of what Mr. Silverstone wrote you 3 days before that. Read that one.
So the sentence says, other than that, there is nothing we can do. If you still disagree, QBW has an arbitration process that can follow. Best regards.
Did you do exactly what he asked you to do 3 days later, Mr. Silverstone, as an effort to try to resolve this problem? Applying for this warranty?
Oh, you mean put in a claim through the warranty?
Right.
Yes.
QBW stands.
Yes. Yes.
Another question.
Mr. Pai, anything else for Ms. Ibezims?
No, Your Honor.
Jurors, any questions?
I can't look at the jury.
Any more? No, we're quick now.
Everyone's catching that good bug. Almost everyone.
There's so many questions.
So gentle reminder, please write questions only on one side of the card. Hey, counsel. See you back there.
Do I have to stay here? No.
You can't go to that one restaurant.
Just running. Wash my hand. I think somebody was six, but- Yeah, that was-
So did you ever play Bobby Joe? Not the reverse Smith? I played that.
No, I don't have no signs.
Haven't played it in a long time. Yes, I have. I do like it.
I like it a lot.
Yeah, it's really nice. Yeah. Oh, yeah. I especially like the rough numbers. Where you're laying, you're in the fairway.
You read my mind.
Oh, yeah, that's the best. My wife swears my mind.
That is
First time I
great.
tried one there for milk
Oh my
candy,
God.
but they had just to try it. Yeah, vitamin D. It was fun, but I wouldn't do it every single time.
Yeah.
So I'm like,
It's
oh, really?
liquids and all that.
I wasn't, I've been looking again, what's in there. That track man.
Elderberry in it.
No, not
We got a nurse.
no, like digestive issues, just like it gives me a stomach ache. Like turmeric, yeah.
Anti-inflammatory.
I cook a good bit with turmeric, so I think I'm doing
You gotta get to your house and
well without bragging. I cook.
I mean, when the baby's like 6 months old.
Pictures before we have to talk to you. So that was Christmas dinner. Everything's homemade. That's a beef wellington. That's It's called a beef wellington. It looks pretty amazing. It looks like a piece of artwork. It's like the creme de la creme when it comes to.
I feel like
Band trip.
My phone is
Ouch. The fact that you're even comparing mine.
No, not slightly.
Immensely. So, but you guys. Yeah, the lattice. Yep. So I took puff pastry, which puff pastry sucks to make from scratch, but yeah, I had something left over. So what you do is
That's what I take back there. That's got everything.
this is actually perfect. So
This is like you used to eat in a restaurant.
That's what I take back there.
Because
It's got-
seriously,
it's got-
amazing. So you effectively take a piece of pastry dough like this, and you cut
It's
slits.
got, it's got air conditioning.
This,
It's
and then you cut it like that, and you go
It's a liquid.
over and over and over again, and then you stretch it out. And you get that.
In this stuff here.
You gotta get you some.
Yeah, that's all.
Lotion and.
That's what I got.
It's gonna be sore.
That's so already.
I went
after
through that.
very hard
Just
and let him figure it. Whoop you in the morning.
something with allergies.
We haven't even talked about croissants.
Yeah.
Those croissants.
When I first came
Turned out
in
to
here,
be
this place
this
had
big.
my eyes just running.
Are you
running.
saying, are you?
Like I
72
was
hours.
allergic or something.
These croissants.
What you putting on the cheese?
Oh yeah, Lonnie was asking about the mac and cheese. My mac and cheese. So that is 4 different kinds of cheese. Whole ton of cream, spices. Yada, yada. It's just cheese and cream and herbs. Heavy cream.
You can load that up into your Chevelle and drive it to a congregation.
Well, Chevelle's not, well, the Chevelle is running, the Chevelle is not driving. I destroyed my last transmission. 850 horsepower.
They might ask me, I might get in trouble.
Yeah, homemade waffle fries and the best green beans you'll ever
So you
try.
might have to tap.
Oh, and homemade Spanish. Spanakopita is,
But no.
do you know what a baklava is? So it's like that, but with spinach and feta.
Yeah,
and
100
garlic.
milligrams.
It's layered over.
Golden seal, hard time.
Yeah, yeah.
Purified seal.
Okay.
Yeah. Have you ever eaten this Mary in the diner? So,
It jumps on the meat.
I forget what it's a similar name. Quite a bit.
Now, what you call it, what you, whole thing stopped selling it because it has that silver in it. They said something about that silver.
Golly, what, they own one other place. Oh,
The
the
fish,
fish.
yeah.
Yeah.
It's not Alpharetta, it's Canton.
I think so. It's just down.
It's like
It's
Santa's
up on the
Plains.
free flight bicycle.
It's on a random, I used to call it Blackwell Road because the way I would get to it when I lived in East Cobb was, I think the road was called Blackwell, but it was the old dollar movie theater. It was right next to it. At least when I first started driving, the second time that I moved to Georgia, I started driving and I mean, that's where all the high schoolers went. You could go to the movies for $1 and make out with your girlfriend for 3 hours. Drive it.
Yeah, I've been at all of their locations.
So that's the breakdown of alcohol, the percentages.
We used to laugh because we're
It's
like,
got
it's all about the
willow
great
something,
coffee.
that willow bark and
Yeah,
that.
yeah.
That's what it's like.
Yeah, Turkey County was
600 grams.
kind of low key and they.
So I didn't sleep. I ain't go to bed about one, so I had to go do some plumbing. I was sorry at my buddy's house because the sheetrock guy got to come by. I was like,
Was
12:30.
You know, the old bars that people like buy and try and put in a house or in the restaurant with all the woodwork.
yeah, I need some
And
sleep.
it was amazing.
It's got ginger root in it too.
Like the set and cheers.
100 grams of
Silver bar.
But it was on just one wall.
Right.
But yeah, it was all. One of my favorite places to go now is, I go there every Friday.
Delicious. I know that is. Delicious. I know that is. SALICIA.
It's great food and their, it's like cheers.
Okay.
Except for it's not like a, in the middle, it is a shoe bar. And me and one of my cousins, I worked with him at 2 different companies. We try to go there every Friday.
Man, see, what's on the order?
All right.
All right, Ms. Ibezims, roughly when was it that you or your husband contacted Gwinnett County? Describe that as a step you took after you threw up your hands with the HOA and the builder, et cetera.
If I had to, we have an email. Actually, we have an email from Gwinnett County. So to get you an exact date, I can get that to you if it's allowed. But I want to say within a year.
But
Yeah.
did that get us to 2020?
No, not 2020. Nobody was coming nowhere in 2020.
2019.
2019. It had to be. Yeah. But I have an exact email if that's needed.
Okay, and did Gwinnett County issue any report or document that they provided you?
In the email, I think we have 2 emails because the mid-level guy came out and then his supervisor came out and they both spoke to my husband. I was privy to the conversation that they had, but I don't know if they produced a report because I think they probably said something to the effect that it was.
So I don't want you to know what they said.
I apologize.
Don't get
Sorry.
into what they said.
Okay, no problem.
Just,
I don't have an official report. I just have a couple of emails related to what they saw when they were out there. Okay. So.
When you did your walkthrough, and you may have done more than one, but the walkthrough of the home before you bought it, did you check to make sure that the things that were on the punch list had been taken care of?
So this would have been the walkthrough prior to closing. We did, I I can't, I mean, I'm sure there's a copy of the punch list, but the water thing was not a part of that punch list. So we're talking about cosmetic things that we took care of.
When is it that you learned that you were buying a house that was in an HOA that would require you to pay monthly assessments?
So at the closing, they tell you what you're paying for. They kind of break it down. So the purchase of our house was like 219, but then we saw this other figure. It's really 238 because this, that, and the other, and then the initiation to the HOA. And that was like the first time that I'm hearing. I was like, oh, okay, HOA. Not thinking about it. Moving in, they gave us a packet that now came to the house. Excuse me, he gave us the packet with everything that came with, you know, it gave us like a lunch bag and stuff. And then the HOA information was in there, how to set up your cable, HOA, who to pay dues to. So we had to pay a couple of months of dues. That's when like I first knew that an HOA was going to be a part of that situation, moving into the townhome. Did that answer that?
Was it ever raining when you visited the house prior to closing?
No, I've visited the house twice. That was to say, hey, we want to take a look at this home. We put earnest money down, and the second time was the walkthrough before closing. So it was only twice. Can I expand on that? It was a brand new dwelling, so it was just clean and well built at the time when we eyeball it. So there was nothing else to visit except to go back through the walkthrough to make sure the things that we saw cosmetically needed to be taken care of.
You talked about sandbags going into your backyard. When did those go out there?
I'm gonna stick to the years because I can't tell you an exact date, but 2018, just because when we started noticing the erosion of that area, we put it around there just thinking that you see this on TV when water is coming towards a place or a structure, we wanted to block that.
So we saw photographs from the El Nino report. Those photographs would have been taken in May or June of 2019.
Okay.
No sandbags in those pictures. Would you have removed the sandbags before El Nino came in?
We also don't have a picture of the entire backyard. So we had sandbags first over by the patio. And then we moved the sandbags over by the right corner behind the HVAC and on the other side of it where the wires are at.
Right.
Does that make sense?
It does. And we saw lots of pictures of the wires and the HVAC, no sandbags.
I just said the sandbags were by the patio door, by the slab that you can sit down and have a little bistro table on. The sandbags were around that first because water comes onto the patio first. Then we moved those sandbags because we first used it. If we're talking about 2018,
When did you move the sandbags to the area around the wires to the HVAC?
I don't have an exact date, but I'm going to say later on that year.
Still 2018?
2018, maybe going to 2019. Yeah. I don't have an exact date for that.
Was it rainy season, whatever that might mean to you, when the fence went up?
So if the fence went up in July 2018, so then my next question would be, can someone tell me when rainy season is?
So no one can tell you that.
Okay,
just
okay,
whenever
no
you
problem.
think rainy season.
I don't have an opinion on that.
Okay.
Yeah, I don't know what rainy season is.
What we know is you moved in March and the fence went up in July. So if someone thinks rainy season is between March and July, there would have been some rainy season before the fence went up.
My thought is it rains all the time in Georgia. So that's my thought. So I don't have an answer to that.
Right.
Midnight in Georgia.
Did Mr. Smith, the president of the HOA, ever advise you or your husband to wait to do something until the warranty expired?
Yeah, those were his exact words, to wait until the warranty. We got you. Don't worry about it. We'll take care of everything. I don't know. That would be a question for Sean Smith, but I guess wait to help us in that effect, because he said, once you're still under warranty, we can't really touch back there.
Okay.
So that's verbatim.
Do you know if the area behind the sheetrock is still damp now that the baseboards are back in?
I would have to take the baseboards off and put my hand in that same space when Trevor took it off to test it. I don't want to open up a problem Because if I take the baseboards off, I'm gonna have to put them back on. And if there's spores or anything in there because it's been wet before, that's gonna cause a problem for us. We forget it, I'm not gonna talk about hearsay or before, but yeah, but it can cause a problem if you open it up and can't dry it out or whatever, so.
So at one point, the water intrusion problem was sufficient that the carpet got damp.
Right.
Like when the toy went back there.
Yes.
Now you've got this laminate flooring.
Right.
Even easier to tell if it's wet. Does your laminate floor get wet?
I know that the wall I know there've been droplets on the wall because there's moisture in our home. So I know that much. And the paint continues to disappear above the baseboard.
So I'll take that as a no. The floor doesn't get wet.
It has moisture, not on the floor, but above the baseboard in that area.
Okay. How many hours of your personal and professional time would you estimate that you have spent dealing with the water intrusion issue?
You mean like with emails and text messages and, oh my goodness, like years. So, but in hours, you're talking about if we started in 2018 up until this day, that's a lot of hours and minutes and stress, like just talking about this, and even it's up my home and I appreciate the time of that. It's just been a lot of time talking about this. And I just really want a solution to figure out what's the next step.
Mr. Stewart, do you have any questions for Ms. Ibezim?
No, Your Honor.
Mr. Pye?
No, Your Honor.
Ms. Wilson?
No, Your Honor.
All right, thank you, ma'am, for your testimony.
Thank you.
Mr. Stewart, next witness.
Your Honor, I apologize. It wasn't before noon like I thought it was going to be, but plans for rest.
All right, ladies and gentlemen, we need to take our afternoon break now because when one party rests, it's a legally significant point where now the lawyers have to argue about some things. And they do that outside your presence. So I'll try to keep our break to 10-ish minutes. It may run a little longer because I need to hear everyone out and work through that. Don't talk about the case. You've actually only heard one side of the case. You may have received far more than 1/3 of the evidence because, as you've seen, lawyers from all three groups have been asking questions, but we're not necessarily done with evidence. I will turn when we return from the break, if we're going to keep going, to ask Mr. McLeod to call his first witness. It may well be someone you've already heard from and they'll ask different questions, but the evidence isn't closed yet. So please don't start your deliberations. Thank you.
All right, adjourned.
All right, you all can be seated. Mr. McLeod, plaintiffs have rested. Do you have any motions we need to work through?
Yes, Your Honor. I think at this time we'd like to make a motion for direct verdict on the continuing nuisance claim against my clients.
Okay.
First, with respect to defendant WEG Mill Creek LLC, there's no evidence that they had any control or did anything on the property that could even much less continue the nuisance, cause the nuisance. They did nothing other than take title to a property and deed it to the plaintiffs. With respect to defendant Water's Edge, let me pull my little notes up.
They'll be little if they're on the screen of your phone.
They are very little. Where did it go? Okay, with respect to defendant Water's Edge Group, the requirements for liability under continuing nuisance, Georgia recognizes a distinction, as the court knows, between creating a nuisance and maintaining a nuisance. Person may be charged as a continuing wrongdoer only if he has a legal right, and is under a legal duty to terminate the cause of the injury. That's the Bodine versus Gill case, 216, Georgia 467. Importantly, that's a Supreme Court case, not according to Gill's case. There's other sites, Mott versus ExxonMobil Corporation, that's a federal court case. And then Hoffman versus, in that case, cites the Hoffman versus Atlanta Gas Light Company, 206 Georgia App 727. In this case, at bar, the plaintiffs can point to nothing in the record to support the allegation that the defendants maintained the nuisance or exercised a degree of control that would create a legal duty to terminate the cause of the injury. The defendants never had any property interest in common areas that are at issue in the case at bar. They did sell the residence that they had a title to in 2018, and William had not had any further legal duty to acquire any of the common area property, not that they had any to begin with, Your Honor. So that's the basis for our motion. I know there's, Mr. Stewart cited the Green versus Eastland case. I would just point out that it is a court of appeal case. And I think the Supreme Court case, it doesn't even mention the facts of the case here. I think they're distinguishable because in that case, both of the defendants actually held title to the property that they owned. In our case, we've never had any degree of control.
Right, as I understood Green, and then interestingly, you guys are referring me to cases for one point, and I find them valid on a different point. West versus CSX, similar to Green, so further support for the notion that Mr. Stewart has advanced that you don't have to be the owner to be liable, but in both Green and West, the tortfeasor, the nuisance creator, at one point owned the land, nuisance was created, they sold it, and someone else owned it, and here comes the plaintiff suing the guy who doesn't even own the land anymore. It would be like suing Portrait Homes, which could have happened. And under Green and West, Portrait Homes could be liable for the bad grading that happened. So I follow that you don't, they stand more for the point that the fact that you were the owner at the time of the nuisance creation, and maybe it was a continuing nuisance, but you sold it, doesn't sever your liability for that continuing nuisance. You can still be on the hook. But that doesn't describe your clients because they never owned the relevant portions of land. So it seems like the analysis is there evidence, however slight, that your clients controlled the land or had sufficient legal connection to it such that they contributed to the nuisance?
Yes, Your Honor, and this is a really finer point of nuisance law, which was argued at summary judgment. I'm not sure if it's come to this court's attention. But the case is Davis versus Beard. And in that case, it stands for the proposition that if there was no original nuisance, there can be no continuing nuisance. And it's an interesting case, and I'll try to summarize it, but long story short, and I can get you the site for it, but this one landowner owned a piece of property, and he owned a piece of highland and a piece of lowland. And he did something on the highland that changed the water flow to the lowland. He subsequently sold both pieces of property, the highland and the lowland, and the new lowland owner sued the new highland owner. And the court said, ultimately, well, you can't have a continuing nuisance if there is no original nuisance. There was no original nuisance on the original property because he owned the whole property. You have to create a nuisance on the land of another. And so the court found that because there was no original nuisance, there can be no continuing nuisance. It's an interesting analysis to our case, just because we never own the common areas that are at issue. It seems like in the analysis that we did something perhaps on the land we owned, it caused a nuisance on the HOA, if anything, HOA's property, not our property.
I don't think there's any evidence that work done on the pad, the square that constitutes what the plaintiffs now own, that your client, one of your clients own, is the source of the nuisance. It's the, if you will, it's the victim of the nuisance. The nuisance is the water flow off the swale into their yard, never your client's land. I don't know that that's dispositive though. So let me hear from Mr. Stewart on.
May I supplement the motion or wait for Mr. Stewart?
No, you should supplement so that Mr. Stewart and I both know what overall the argument is.
Well, Your Honor just mentioned, the first thing I was thinking about, there has been no credible evidence identifying the defendants as the source of the nuisance and the damage. There's actually been a lot more evidence by the plaintiff that the HOA, as owner of the common areas and swale and so forth, was responsible. The point being that the plaintiff has not proven by preponderance of the evidence any damages specifically by the defendant home builder, who never had control over the common areas, never had control over the swale. There's been talk about water coming off the roof, but no identification that the roof was defectively constructed, anything of that kind. So we think the link between causation and damages to the defendants is missing. Now, going on to another point, obviously, if there's no such link, there could be no claim for punitive damages. But even if there were a link, there's been no evidence of the type of bad, malicious conduct required to award punitive damages. So we are moving for a directed verdict on punitive damages. Likewise, attorney's fees, no evidence of bad faith, stubborn litigiousness, unnecessary trouble and expense. And beyond that, Your Honor, the requirement for attorney's fees, Mr. Stewart has made these claims many times as I have. It is necessary for the witness, in this case, the attorney, to describe what he did. Well, Mr. Stewart did not do that. He does have what he calls a fee bill, which isn't actually a bill. It's just a listing of things that he did. And we think that is insufficient to describe what he did. But the magic words, necessary and reasonable, absolute requirement to prove attorney's fees. And we had no testimony that those fees, first of all, they're not actually fees. They're a calculation of his time, which would be fees if he weren't on a contingent basis. And so, but no testimony that at that time, those fees were reasonable and necessary. And finally, Your Honor, there being a contingent fee basis, I believe that the proper method to prove fees under the statute would be to prove that a contingent fee is a reasonable and necessary financial arrangement between attorney and client. That was not said. He simply said he offered three options. They chose the one that did not require any out-of-pocket expenses, at least at this time, and that's what they did. So on the substance of the claim, we moved for directed verdict, as well as everything falling out of that substance, damages, punitive damages, attorneys.
Got it. Thank you. Mr. Stewart, I'll slide on over so I can see you.
Thank you, I appreciate it. I'll go in order they did a little bit.
Sure. Yeah, let's do that. So I think the big one, obviously, we don't get to attorney's fees and punitive damages if the substantive claim, the nuisance claim, doesn't persist. So address this claim that there is no evidence that links. And I want you to help me navigate both defendants. I think your argument is easier for Water's Edge, boots on the ground, and shovels on the ground or backhoes, whatever they were doing. I'm less clear, and I frankly don't recall the evidence because it would have been just a few words from Mr. Silverstone and then your opening, which isn't evidence, as to what WEG Mill had to do with anything other than, I guess, they may have been the actual title holder. So walk me through those things.
Thank you, Your Honor. I did submit last night, request charge 18 and 19 to the portal or to the email to your office, whatever. In charge 18, cites McClellan Cox versus Roberts, 1990 case, I give a cite. Quote, in general, the owner of the property from which the nuisance emanates is the proper defendant in the action for damages flowing from the creation or maintenance of the nuisance. See generally OCGA section 41-1-5, end of quotation. They're the owners. They built the entire building 13. They owned it. They controlled it. Mr. Silverstone was the CEO who came to closing, and they own it. When they did the work that happened to obtain the CO.
I'm remembering things differently, and so you can help me get reoriented. I thought that I'm just gonna call it Water's Edge. It may have been WEG Mill, but you understand what I mean by this. That Water's Edge purchased basically two rectangles. One was gonna become building 31 and one was gonna become building 30, but they bought those rectangles. All of the hills and mounds and other common areas. I don't think they were common at the time because they weren't, I don't know if they were part of the condominium, but this is where you can help me with the timeline. It's in evidence, I just don't remember. Are you saying that Water's Edge at some point owned more than just those two rectangles?
No,
Okay.
according to their testimony. Water's Edge owned the pad raise, they call it, for 13, 30, and 31. In 2017, December and January 2018, they prepared it, and testimony was, Ms. Silverstone, they had to get the CO before they could sell it, the owners, whatever, and they had a duty to finish the swell. They must connect it to the drainage system, and they worked in the swell for 10 years later to clear it out and make it better. They had control over the swell.
Okay, so they didn't own it. And so we agree on that. And that, to me, that's not controversial. Your argument is, here is the control connection, is that they, we'll call it Water's Edge, were affirmatively acting and moving around in the common area to create those connections to get the CO. They couldn't just put up a building and not worry about how it connects, whether it's literally pipes going in or the water runoff. We need to make sure our drains and those patio slabs and everything else, the water is properly directed into what may have been a pre-existing swale, but there was some testimony from Mr. Silverstone. It was admittedly vague because, as he said, I wasn't the guy out there with the backhoes. You'd need to talk to Trevor. Of course, he said that. I don't know if he said that to you or to Mr. McLeod. You chose not to call Trevor. So we don't know much more about it, but I do think there has been a little bit of testimony about how there may have been some work done in connection with the swell.
I think there's much more than that. Mr. Silverstone talked about he didn't remember the 10-to-1, but he said we had the duty to slope it away from the buildings. It must go that direction. We had to put the slope in, we had to make the swell right, and we had to connect that to the drop inlet. That was all our duty. Everything that caused the problem, they had control over. Now the issue, question charge number 19, ownership of land by the torque fee is not an element, but control is. The essential element of nuisance control is over the cause of the harm. The torque fees must be either a cause or concurrent cause, so it's why you have more than one, of the creation, continuation, or maintenance of the nuisance. And that's a or.
I don't disagree with you. I wanted you to highlight, and you've done it. I don't know if the jury would remember it as being quite as compelling as you've put it, but I think there is that toehold you have through Mr. Silverstone's testimony that Water's Edge had to do some work. Couldn't tell you exactly what it was because he wasn't there and you didn't call the guy who was there to direct it, but they had to do some work to effectively connect 30, I don't really care so much about 31 because that's not what we're arguing about, 30 to the overall drainage system. And again, I don't mean physically pipes going in. That may have solved things if they had installed a pipe instead of using the swale, but it was making sure with the degrees of descent, et cetera, that 30's water flow met all the code requirements. And that necessarily meant they were in control of the space that has yielded the nuisance. So tell
just
me
continue.
why WEG Mill is on the hook for that as opposed to Water's Edge? Because my understanding is it would have been Water's Edge that would have done that work.
Because they were the owners, like this charge again. In general, the owner of the property from
But
which
the
the
owner-
nuisance emanates is the property defendant. And they actually own the buildings. They were building it so they could sell the building 30 away. So the owners were the ones who hired their joint buddies to do the work out there. So the owner and the worker and builder, just like in Green, the case, the builder and the developer were both liable, even though the developer had gone away, just like the owner did here.
But with Green, there was no, we don't own this land. Neither defendant ever owned the common area. Neither one ever owned it. Water's Edge was working on it, maintained it, caused it, whatever verbs you want to use. What did WEG Mill do? And your answer was they were the owner. They were not the owner of the land that is causing the nuisance. And I'm asking you, what did WEG Mill do to cause or maintain or exacerbate or continue the nuisance that is that water flow?
Well, they own the building there and the patio slabs, all that. They had the duty as the owners before they sold that to anyone, as the owners to fix that. Whether they actually own that land, the owners had a duty, or they couldn't get the CO as the owners to sell the property. It's not required that they actually themselves got to dig it, but what they had their company do is fix it so they can work it and help the owner to sell it. It doesn't require they actually go in it. They couldn't have done it without controlling. Mr. Silverstone's CO, he controlled both companies. And that CO WEG, he directed on their behalf, help us sell these lots by sending out Water's Edge to fix this work. The owner of WEG directed them to do that, and that was control over the property. They don't have to own anything. Like I say, ownership.
I know,
land is not a
but
tortfeasor.
when I asked you, how is WEG Mill connected to this in any way because they didn't do any work, your answer was, well, they owned it. But the it that they owned was not the part of the land where the nuisance is. So they never, unlike Green, unlike West, they never owned the land where the nuisance was, and then they sold it and they're saying, how can we be liable? We don't even own that land anymore. They didn't ever own the source of the nuisance.
But that's what it says. They don't have to own it. They have to control it. And they
And how did WEG Mill control it?
because WEG Mill went to Water's Edge, said, look, we can't close this house until you go up there. Water's Edge, go up there and finish the work so we can sell this unit. As owners of this land that we own here, we can't sell our land until you do this drainage work for us. They directed it.
How would it be different if the company that did the work in the swale and made sure drainage was okay was Fred's Grading, no connection to Mr. Silverstone or WEG Mill. They hired Fred's Grading to do that work. And Fred's Grading comes in here and says, we had the backhoes, we had the little bobcats, and we're the ones who did the swale and tried to make it 1 inch for every 10 feet or whatever it is. And we received no direction from WEG Mill other than we're hiring you to make sure that we can get a certificate of occupancy.
The test is going to be, did they have any control of it at all? They definitely be sued. That's why it says the tort fee must be either the cause or concurrent cause. And you see in these lawsuits, oftentimes subcontractors, owners, developers are all parties to the lawsuit. And then some will come in and say, look, we got a contract that says we had no control over the soil at all, and they get out for that. But that's what you got here. They were involved. They got them to do the work. They could not have sold those properties unless they had Water's Edge to do the work.
Okay.
And then punitive damage. This is a classic case for punitive damages. And I'll give you the sites. Tyler versus Lincoln. That's a Georgia Supreme Court case. Also possibly on condominium versus that's a.
So sites to me are numbers and letters, not.
Okay, do you have my question charge number 11 I'm citing from?
Okay.
This is Lincoln, Tyler Lincoln, Ponce-de-Leon, condominiums, DeGarmo. DeGarmo's 1977 case.
What's the site?
Oh, I'm sorry. I'll give you the best one, I guess. 238 Georgia, 188 for Ponce Leon, 1977.
All right.
Lincoln.
And before you go any further, all I'm looking for is where do you think there is at least some evidence so that the jury could consider? I know it's a higher evidentiary burden for them to decide to award it, but for a directed verdict, it's not a higher evidentiary burden.
I'll read this charge, Your Honor, and this is.
So I don't want you to read anything. I want you to listen to my question. Then you can do that. Where is the evidence in the record that shows willful misconduct or some lack of care that raises this presumption of conscious indifference to the consequences?
Both those cases, Tomarov cases, they were given notice, you caused this problem, fix it. They don't fix it, that is conscious indifference to consequences. And that's the quote I was going to read to you.
Okay, no, I don't disagree with you. I just wanted you to point me on the record to what you think the evidence is. And it's sort of res ipsa loquitur because we've got evidence here, hey, there's a problem, you need to fix it. And one pushback was what you have to do is remove the fence.
And both those cases address the issue of attorney's fees and punitive damages.
Okay, let's talk about the attorney's fees. Are you traveling under bad faith, stubbornly litigious?
Bad faith only, because there's three elements of the 13-611. Bad faith, stubborn litigious, they can put up a defense and you can get it kicked out. Bad faith, you don't have to prove whether they did anything wrong or not, just they acted in bad faith. They can't challenge it like the other two requires. And so that's why you'll see that my charges go to bad faith on those two statutes, and it's identical as this case. Ponce Leon is 97, it's been cited 100 times by the Court of Appeals, Supreme Court. That's a 3 or 4 page opinion. In that case, you had the condominium association downhill and the builder upstairs up the hill, and they had 3 experts that all said it's impossible, we could not have done it. And the plaintiff
Not have done what?
caused the water flooding.
Okay.
And the plaintiff, the doctor in this case, he went to trial with no experts at all and showed the before and after pictures. And they did a site visit, and that's all they did. The 3 experts said it couldn't happen. And the court awarded general damages, special damages, punitive damages, attorney's fees. And then the judge gave a permanent injunction afterwards. The Supreme Court upheld all 5 of them, saying, if it's before and after damages, is all you got to prove it. They got notice, they didn't fix it, even though they said they didn't cause a problem.
That's the bad faith.
That's consequences, which is bad faith.
Okay, got it. Thank you.
Thank you, Your Honor.
Mr. McLeod, and then Mr. Pye. What do you want to say in response to the exchange Mr. Stewart and I just had?
I guess with respect to the continuing innocence issue, I would like to, what I heard Mr. Stewart argue basically reduces the requirement just to some minor toehold of control or.
Well, I used the word toehold. He didn't, but again, the standard right now, this is a motion for directed verdict. And so is there any evidence that reasonable jurors could rely on? It's a very tough standard for you, as it should, not you personally, but for a movement in this situation. And so I wanted Mr. Stewart to share with me what he thought that evidence would be. It's not me finding, boy, there's going to be a huge judgment for plaintiffs here. It's just, do we keep moving on with the case? And ultimately, does this get to the jury? And his presentation of, look, there was evidence through Mr. Silverstone's testimony that Water's Edge did engage in work in the common area. And now we have, whether it's a continuing nuisance or that was the start of the nuisance, that really could have been a nuisance before the building went up. Water was flowing in nature. So query if that's a nuisance. But
Well, Your Honor, the land had been graded.
Understood?
And developed. So it was not an original land.
No. But it was original in the sense that there were things growing. There were no buildings there. No one would have said there's a nuisance right now because there's water coming off the graded swale into what will soon become 3078 or whatever the unit is. You see what I'm saying?
Well, I do, but I would argue that if the nuisance could have already been there, because the swale, you heard Dr. Spot say that there was a design defect, right? So the nuisance could have existed.
Okay. And then it continues and the builders come and they maintain it.
Well, the builders were not required, they never had a requirement to maintain that property. That's the whole issue.
No, they maintain the nuisance. Not that they maintain the building.
But we never had a legal right or duty to terminate the cause of the nuisance because we didn't create it. And that's the issue. That's the issue. I don't think there's any evidence there that we created it. The evidence is that it was there.
Well, except how was it a nuisance before the building went up? There may have been a flow of water like that. It probably was a radically different flow because it has to have been, and Mr. Silverstone testified to that, the dirt's being moved around some because even the pads, they were dirt pads. So there had to be stuff done to make sure they're level and things were moved around. And again, we could have gotten a whole lot more testimony through Mr. Schonkweiler, not your job. That was Mr. Stewart's. He didn't call him, but there wasn't zero testimony about the fact that earth was moved in connection with being able to pour the concrete pads and build these things. And there was testimony that what was built had to be integrated into the water runoff system. And so there was at time, I find from the evidence presented, dominion exercised over that common area by your, I get it now, clients. Like WEG Mill didn't do anything, but as the owner, they were directing Water's Edge to do it. So no, it was never owned by. And when you say, did they have a legal duty? I don't know about legal duty, but that doesn't mean that they weren't out there doing work, the end result of which was either the continuance of the nuisance or the start of one. But maybe what I'm missing is I'm not understanding your view that the nuisance was already there, because of course a nuisance is something that causes harm to another, and no one was being harmed when Geosam owned it all. That's like your guy who owned High and Low.
Correct.
But there's no harm. I mean, this is all my stuff. Then your client bought it. I guess in theory, they could have brought a nuisance claim if there was a nuisance at the time, but no one knows. There's no evidence in the record about that.
Respectfully disagree. The court is under were we under a legal duty to terminate the cause of the nuisance? I mean, I never think we had a legal right to maintain the common areas, but I certainly don't think after we were done, I don't think we had any legal duty to terminate.
But isn't that an argument that, boy, our responsibility, your client's responsibility for this might be a day, 1%, or at some point it was brought to Mr. Silverstone's attention, and he did engage, or Water's Edge did engage with the Ibezims, but there's also a whole lot of evidence that HOA owned it and was responsible for it. There's this confusion about the warranty for that 1-year window, further confusion about, well, wait a minute, warranty may only be what's inside the 4 walls, and the water is outside the 4 walls unless it's intruding. And so then the warranty is to make sure there's no more intrusion. But then that would mean let's address the raging waters that are coming down, which is the nuisance. So they're interconnected. I don't know that you can safely build this protective shield around your client saying, well, you're trying, but I don't know that legally it is enough to say there's zero liability for the nuisance.
I'm talking about the continuing part of it.
Mm-hmm.
I just don't think that what we did rose to the level of degree of control such that we had a legal duty to terminate the cause of the nuisance. There's also plenty of evidence in the record that when the plaintiffs built that fence and were assigned basically the drainage swale as part of their limited common element, this is under the recorded covenants, that it was their responsibility to maintain that property, which would include terminating the nuisance that was existing on the property.
I agree. I think it's a powerful argument that your client's any potential liability would have ended when that fence went up, because then there's either an intervening cause or who knows what. But again, my inquiry is there any evidence? I don't know how compelling it is, but I don't see a complete absence of evidence. And I think I want to read the Ponce de Leon case, 238, Georgia 188. I suspect it stands for exactly the principles that Mr. Stewart has propounded, but I think that would address the attorney's fees. Now we know it's only under bad faith, not stubborn litigiousness or whatever the third one is, and the punitive damages. And again, that just means that that would get to the jury. It doesn't mean that I'm finding that they're particularly strong or weak claims. Mr. Stewart, is there anything for the record you want to add in response to Mr. McLeod's point, which is really where I struggle on this, which is that Water's Edge collectively, they didn't create the nuisance, they didn't cause the nuisance, and they really never had an obligation to abate it in any way.
So I think the facts show just the opposite, just like the Green case everywhere else. They buy land, even though they had readies already, but they built the buildings that took away the impervious surface, increased the volume of water that went to the swell, and they created the swell. There's no evidence prior to their work that there was a nuisance. Like you're saying, it's not a nuisance cause hurt, inconvenience, or damage. There's no way being hurt, inconvenience, or damage. That's 41.11, what the definition of a nuisance is.
When you say, though, they created the swale, they didn't create the swale. That there's been uncontroverted testimony that was already there. Where it's a little murky, could have been made less murky, had Mr. Schunkweiler been called to testify, is that they had to have done something to the swale, whether they put pine straw down or this or that. There were at least some modifications to the swale. But as I understand the testimony, and that's all we can work off of here, the basic contours of the water discharge system were already in place thanks to Portrait Homes and the grading that was done. And yes, that was 10 years earlier, and so it would have changed a little bit. But unless you can direct me to it, I don't recall testimony that from level ground, the swale was created by Water's Edge.
Right. The testimony was that they had dirt out there. There was not an ounces of concrete been poured or anything, and they had the swell from the plans where it's supposed to be. 10 years, we assume that swell was there. We don't know if it was or not because 10 years went by, but it's not undisputed.
Well, we don't have to assume, because my recollection is that Mr. Silverstone said, no, look, a lot of the elements of the water drainage system, the dirt elements, were already there, as in, here's the swale. Was it sufficient? He said, no, we may have had to do some grading to get that. And he didn't want to get pinned down to, is it an inch every 8 feet or whatnot? That's fair. But the swale writ large was there. What I took the testimony was that Water's Edge certainly had to do refinements to make the interconnections that you've been describing.
Yeah,
and that may be enough.
And he talked about the 1 to 10 swell away, and then the swell itself, they had to slope it, get the right direction. And they built these buildings that added tremendous increase the volume of water going to the swell. And there was no person being harmed. The first time there was a nuisance was when they built those buildings and sold the unit. You know, we keep going this warranty. That's a contract. My claim is under, like Ponce Leon and Tyler, is a nuisance for the water coming onto my property. So that really has no bearing at all. So when they did that, they created a swell. And then after people complained, they knew about it, they maintained it, and it continued for 5 years under them. And
so tell me I agree with you on the warranty. I only brought it up because I think it adds to some of the legal confusion for the jurors. But what do you mean when you say they, and I assume you meant Water's Edge, maintained it for 5 years? How possibly is it Water's Edge maintaining anything after HOA says it's our common area and we're responsible?
Because when they sold that land and they said, okay, we're not responsible anymore, as Green says, no, you're still responsible as long as the nuisance continues. It's a continuing tort. It goes on. And right now, today, if they change their heart after this lawsuit's over, in fact, I'm going to ask the court, I'm going to ask for a permanent injunction like I always do in these cases, and they'll be ordered, and they have authority to go on that land and fix it now. Okay. And the HOA does as well, have authority to fix the problem after it's already been created.
I understand your point better. It's not the way I took it, because you used the verb maintain, is that you're saying there's evidence that Water's Edge is out there every year messing around with the swale. And that's not the evidence. They haven't touched it since maybe that check dam was put in, and then they've said, hands off, it's not ours, it's the HOA's issue. Your point is simply the nuisance has been maintained, and that's the continuing nature and the liability you're going to argue to the jury.
Right, and it says created, maintained, or continued it. All three of those.
Understood.
Tied in here.
Okay. I just, when you said maintained, it made it to me sound like you were saying, Water's Edge has been out there doing this, that, the other thing.
Maintain, the nuisance continued, it's being maintained, the nuisance continued. They didn't go out and do more work because they never got rid of it. But you might want to look at Tyler as well. It's kind of a companion case, and that is 272 Georgia 118. Those two
A
cases,
companion to the Ponce de Leon,
that's correct.
272 Georgia
272 Georgia 118.
118. Thank you. Okay. All right. Mr. Dorsey, I was not in any way excluding your legal team. You don't have a dog in this fight. This is a directed motion as to plaintiff's case, and there's not a plaintiff's case against you or your clients. If you agree, you don't have to add anything, but I don't want to keep you mute.
No, Your Honor, I mean, I would join in the defendant's motion in efforts to wrap up the trial, but other than that, we don't have to go on the time.
Okay.
I do believe Mr. Kyle has something to address, though, get the appropriate time.
All right, Mr. Kyle, now would be the time because I'm going to give you all about 5 minutes and I'm going to do a little bit of quick reading and we'll get the jury in here.
Your Honor, I only rise to suggest that maybe a motion for directed verdict would be in line for backyard realty at this time.
But that would be a directed verdict as to the Water's Edge folks.
Perhaps it would be, and I can concede that it may be appropriate at a later time at the end of their case. But your anticipated ruling that the fault shall be apportioned. To that extent, perhaps now would be a time procedurally to make a motion for directed verdict since the fault is being considered.
Okay.
I don't know if that's proper or not. I've never handled this before in 54 years, practicing law.
Right. I don't know the answer. I'm happy to entertain things at unorthodox times if it doesn't prejudice any of the sides. But we've got jurors here. And so what we'll do is talk about that after they go for the day. You won't have waived anything. I think it's probably technically premature, but you're right. Given the funky posture of this case, it probably wouldn't prejudice the defendants if we worked through the argument you want to make, but we'll just do that after I send the jurors home. So take 5 minutes, come on back and we'll get going.
Yeah.
Your Honor, do you anticipate us continuing with witnesses this afternoon?
I do.
Okay. That's one.
10-4. What you don't know.
No, I'm cool. I'm going outside with the juice.
Okay, so there.
Judge,
Yeah.
because here comes your wife.
Oh, what's going on? You gonna make him go down to, well, they're off today, a day of rest. Are you team A or team B?
Come on, team.
All teams. Yeah, you look a little shorter. It must be wearing on you.
You know, I'm gonna call you. You know, you're calling my cricket. That's all going to she couldn't go because I was
What's up?
Return this call, period number 1 on file number 2. I do not handle these kinds of cases. Number 3, you should call around our referral back and get another referral to a lawyer who handles these cases. Period.
Let me know when you're ready, Mr. Casanas. You good? All right. We are back. We're about to bring the jurors back in. Before me is the motion for directed verdict from the defendants, the Water's Edge defendants, which I have considered. I have reviewed both cases that Mr. Stewart shared with me, Tyler versus Lincoln, 272 Georgia 118, as well as Ponce de Leon condominiums versus complicated last name at 238 Georgia 188. And I do find they stand for the proposition working backwards. Punitive damages, we have sufficient evidence for that to go to the jury, basically along the lack of care that evinces conscious indifference. I think that also the question of attorney's fees would go to the jury because bad faith is implicit in intentional torts, like a nuisance. That's black letter law. And then we get to the threshold question, which is how is it that the water's edge defendants are even tied into a nuisance that seems to flow primarily from a swale? And I am persuaded by Mr. Stewart's argument that it's not just the swale, but the runoff that was created by building 30, that combining with the swale that resulted in the nuisance. So maybe there was a nuisance before, although no one could sue themselves for the nuisance. So that's really the wrong question to ask. I think there's evidence that would allow Mr. Stewart to argue that Water's Edge created the nuisance, but definitely that they maintained it, not meaning they came back each year to not take care of the swale, but in building and selling, it's in building on 30 and 31, and the work that they did in connection with the common area, they're sufficiently connected to the nuisance that the case can go to the jury. So I know you take exception to that, Mr. McLeod and Mr. Pye, that goes without saying. Mr. Stewart, is there anything else you want to get on the record in connection with the motion for directed verdict?
No, Your Honor.
Mr. McLeod?
There you are.
Okay. Then is your first witness ready to go?
There you go.
All right, let's bring the jurors in.
On a good mood. Sound like in a good mood.
All right, so adjourned.
You all can be seated. Welcome back, ladies and gentlemen. Deputy Gordon, any security threat we need to be aware of now that we've doubled the presence of deputies in the courtroom? Just growing my entourage. I like that. Good. When you left us, the plaintiffs had rested. We had to do not just a little arguing, but a lot of arguing. But we've worked through that now. And I'm turning to Mr. McLeod to begin the presentation of the defendants, that would be the Water's Edge defendants case.
Thank you, Your Honor. Your Honor, for our first witness, we'd like to call Trevor Schonkweiler.
All right, Mr. Schonkweiler, come on up, please.
It's well affirmed that the testimony you will give will be the truth, the whole truth.
I do.
Go ahead and have a seat. It's clear that the record.
I'm sorry.
State and spell your name for the record.
Trevor Schonkweiler, TREVOR SHONKWILER.
Morning, Mr. Shuffler. Good afternoon.
Good afternoon.
Have you ever testified in court before?
No, I have not.
During 2018, what was your connection with Waters Edge Group?
I was the president of the company.
And during 2018, what was your connection with WEG and Mill Creek LLC?
I was a managing member.
And during 2018, what was the business, 2017 and 2018, the time period relevant to this lawsuit, what was the business of Waters Edge Group?
We were building residential homes.
And have you been in that business, had Waters Edge Group been in business for a while?
Yes, sir. Way over 15 years at that time.
For approximately 15 years?
Mhm.
How many homes has Waters Edge, or how many homes did Waters Edge build during that period?
Between 800 and 1,000.
So you're an experienced building company.
Yes, sir.
Who was your partner in Waters Edge Group?
Ian Silverstone.
And what percentage of the company did each of you own?
We each own 50% of each company.
Did you and Mr. Silverstone have any agreement on dividing responsibilities of the building activities of Waters Edge Group?
We did.
Tell me about that.
I was in charge of the field operations. Ian was in charge of the back office contracts, any of the admin stuff. Ian was taking care of it. Majority of the field work was done by me.
Does that mean you were a construction manager?
Yes, I was more or less a construction manager over 5 to 7 project managers.
Do you have a builder's license?
I do.
Does Ian have a builder's license?
He does not.
So are you qualified to answer questions that call for your opinion on general construction matters?
I am.
And specifically in this case, with respect to the plaintiff's residence, are you qualified to, I guess, give opinions on their residence?
I am.
And you're better qualified to answer those construction questions on the residence than Mr. Silverstone, correct?
Yes.
And are you familiar with the condominium community that the plaintiff's residence is located in, Mill Creek Lakes?
I am.
When did you first learn about that community?
Probably 2017-ish, 2016-ish. Sam, a sales rep by the name of Nat Ackerman, had reached out to us and said, hey, we have this deal that we'd like you to look at. And we'd have done several other deals with them. So we went and took a look at it.
And instead of talking to me, if you want to talk to the jury,
okay,
that's fine. They might appreciate that.
I'm sorry.
So can you elaborate a little bit more on how the deal was presented?
Yes. So Nat called us and said, hey, I have pad ready lots, which a pad ready lot to a builder means that all the infrastructure is done. The drainage is done, sewers are done, water's done, electric's in. We are literally going to the county municipality and we're pulling a permit and we are up and building. So for a builder, that was very attractive because developments take a really long time to do and it holds a lot of builders' cash up. So for someone to be able to come in and say, I have quote pad ready lots, that's something that's very beneficial. So we went into a LOI, a letter of intent, and I personally went to Gwinnett County to make sure that, hey, you have got all of your requirements to start these houses and there's no conditional stuff that could hold us up, and there was not. So we went under contract and started to build homes in Mill Creek Lakes.
You say there was nothing to hold you up. Does that mean that approvals have been granted or given?
All the final plats, as far as, so a final plat represents that all of the grading and infrastructure of the community has been completed by Gwinnett County and that it is ready for a builder to build on. And that was 100% done and the final plats were stamped and signed. And you can't get a building permit without a final plat. They won't allow you to start to build.
And then did one of your entities purchase lots in the Mill Creek Lakes?
I did.
Okay. Was any Waters Edge Group entity, whether it be Waters Edge Group Inc. or WEG Mill Creek, did either of those two defendant entities develop any part of the subdivision?
No.
And when you are responding to a question that uses the word develop. What do you mean by that?
We never brought a tractor or a development crew out there to take care of utilities or site work or anything. We literally brought crews for erection of, so in the building sense, you have horizontal and vertical. A development is the horizontal work. You're doing infrastructure under the ground and utility work. And then a builder does horizontal work. We did horizontal work only on that project.
Vertical?
I'm sorry, vertical work only on that project. We did not do any horizontal work.
So obviously then you're the construction manager. You're familiar with the actual building of building 30 where the plant's residence.
I am.
Okay. And you supervise that construction?
I manage it on a weekly basis, yes.
Let me ask you this. Did you inspect the building 30 property before you purchased and began construction on this lot?
We walked all the lots.
Tell the jury about that.
So typically before you purchase a lot or do what they call a takedown, which you're acquiring the land, the builder goes and walks the lots to make sure there's no red flags, to make sure that a big red flag for a community like that would be a sewer pipe's broke, and so, hey, we need you to scope the sewer to make sure there's no rocks in it or debris in it that could clog. And then we have to deal with a backup in the house afterwards. Or if there is a grading concern or something, because we've bought something that's pad ready, should be minor vegetation on it. A tractor takes 2 or 3 inches off of it and we set a 2x10 form on it to start the foundation. There's no heavy equipment tractors coming out there to do anything.
Well, I'm confused because it sounds like you just contradicted yourself.
I did not.
You still need a tractor to take 2 or 3 inches off it. That's
You have to take.
not a heavy tractor? Because you said
No,
don't
it's
bring
not.
tractors.
Well,
out,
no,
you bring a tractor.
you have a Bobcat, to do as a foundation. So you can't have organic material in a foundation. But organic material would be grass or straw, which is part of erosion control for any municipality in the metro area. So you have to take that organic material off to have a suitable structure. So it's not like you're driving monster equipment to flip dirt, which means you're taking a big mass of dirt here and putting it over here. We're not doing that. We're just moving organic material that you can't have that. Gwinnett County, it's just not a building practice. You can't do it.
Let's back up just a second. Before
Sure.
we get to the moving of that organic material. What was the condition of the building 30 pad when you purchased the property?
What was the condition of the pad? It had vegetation on it.
What type of vegetation?
It's usually ryegrass and some straw. So ryegrass is a type of grass that grows very quickly. It has a germination period of 5 to 10 days. And as long as it's not 100 million degrees outside in Georgia, it lasts pretty well. And it's a good construction erosion control measurement.
What was the condition of the grading of the building 30 pad when you took ownership?
My recollection, it was pad ready. We were ready to go. There was no delay in our schedules or had to wait for anything. GeoSam had it ready for us.
Did you have any understanding whether GeoSam had done any work prior to your purchase of the property?
I did not. That was in the back part of the phase. So we started in the front with our model home and then worked ourselves around. So if GeoSam had additional work or something to do back there, I wasn't paying attention to it.
When you inspected the property, did you notice if there was a drainage system?
Yes, there was a swell in the back of the property with a catch inlet, a catch basin. So a catch basin it usually sticks out of the ground a couple feet and water goes down to that direction. It goes into it and then it's dispersed into a detention facility.
Can you tell the jury your recollection of how that drainage system was oriented or designed?
Sure. So typically on a drainage system or how things are engineered is you may have 2 or 3 catch inlets, but it's engineered that if there's one catch inlet, it's supposed to take that amount of roof water from the residents and it can go into that swell and it can go to that directional point and then it's dispersed into the detention. What you don't want is a bunch of runoff that just goes into the streets and then it can go into the rivers and streams and it creates flash flooding. And that's what detentions do in large subdivisions is you have to contain your site water.
So when Waters Edge Group purchased building 30, did that purchase also include the common area drainage swale?
It did not.
And why was that?
We didn't want any issues. There was no need for us to have any of that. It was taken care of by the developer and there was no need for us to control any of that. It was already established.
What was your understanding at the time regarding who would own or who owned the common areas and what would happen to them?
So at the time, in the beginning, the common areas were owned by GeoSam, and then GeoSam transferred those over to the HOA at appropriate time. From my understanding, GeoSam had some arrangement with the HOA as far as who had the declarant rights. I don't know when it got changed or anything else because Ian handled that stuff. I was just handled more of the.
Was that an important part of your, or was that a consideration when you made the decision to purchase the property?
Absolutely. We didn't want to, it was literally a set it and go. We didn't have to deal with any of that. We didn't have to set up an HOA. We agreed upon everything. I think if I had to recall, the one big issue we had was we had some people that wanted to be investors and we had rental tickets that I don't know if it was Sean or who was in the HOA that Ian worked that out where we had a certain amount of coupons because the percentages went up and I don't remember what those percentages were.
When Water's Edge Group purchased, and we're just going to refer to Building 30. Just to keep this simple.
Okay.
We're talking about the property. I'm talking about Building 30 there. I'm sure we all know what we're talking about. Did that purchase include any agreement or any obligation or duty to maintain any of the common areas of the community at all?
No, sir.
Did you have any agreement with the association or Tally Management Company to maintain any of the common areas?
We had one instance that we agreed upon. We got permission because our construction trailer is typically set on one of our building pads. And we had to move the construction trailer into a common area that the HOA owned, which was a good ways. It was 100, 200 yards away from this site. And they agreed to allow us to put it on the site, on their common ground, as long as when we got done with it, that we agreed to landscape it at our expense. And so it was a win-win situation because they didn't want to pay to landscape it and we needed a home for the construction trailer for the project manager. So that was the only thing that we ever were involved in.
And just to be clear, was that agreement or construction trailer located anywhere near Building 30?
No, sir, it was not.
And did you have any agreement to maintain any of the area around Building 30?
No, sir, I did not.
And did Water's Edge Group actually build Building 30?
Yes, sir, we did.
Can you tell the jury what the time frame of that was, if you recall?
I would say, listening, I think it was like 2017 was when we finished it and we CO'd it. And then there was like 5 or 6 homes in there and typically we closed 1 home a week. Is how we would manage the project manager.
Did you have any issues during the building process?
No, sir.
Okay. Were the residences, or the entire building or each of the individual residences, were they inspected during the building process?
Yes, the Gwinnett County goes out and does a series of inspections. The inspections start out with a foundation, through mechanical roughs, through mechanical trims, and then there's a final inspection.
How many total inspections of the property do you think there are?
I say 12 to 15 is a typical number. If I think 2, 3, 6, like 10. Sorry, 10.
And are those inspections done for the entire building or are they done for each individual unit?
They're done for each individual unit.
So over the course of your construction process, there were 6 units, correct?
Yes, sir.
And if there were 10 or 12 inspections, there were a lot of inspections done.
There was a lot of inspections done. Yes.
Are you familiar with the term certificate of occupancy?
Yes, sir.
Okay, tell the jury what you understand the certificate of occupancy.
So the certificate of occupancy, they do 2 things at a CO inspection because typically all the mechanical have been done by other inspectors. So inspector comes out for a CO, they do 2 things. They do life safety inspection, which once they want to make sure if there's a guardrail going up a stair, or if you have more than 3 steps going outside your house, that there's a guardrail on that. So they want to make sure that the life safety is taken care of. And the second thing they do is they want to make sure that there's positive drainage away from the house. And the landscaping, that there's rested vegetation, that you can't just have a raw lot out there. So that's the typical only 2 things that are taken care of on a final inspection.
Okay, and so that final inspection is done to obtain what you call it a CO, that stands
Or a final inspection, yeah, CO.
CO stands for
Certificate of occupancy. Yes, sir.
So if there were 6 separate units in that building, correct?
Yes, sir.
Were they all completed at the same or different times?
They were completed at different times. There might have been 2 at the same time, but they were not all completed at the same time, no.
From the time of the first unit being completed to the time of the 6th unit being completed, how long was it during the construction?
CO, how long was this, did it take to get the CO?
Well, I'm saying, yes, from completion of the first unit that you sold to completion.
6 weeks.
6 weeks?
We do 1 a week.
So all of those 6 units were essentially completed in a 6-week period.
Yes, sir.
And could you estimate the timeframe, the month and year of when that 6-week period was when the completion of the construction?
I want to say it was in October, but I don't recall the exact date.
The year?
Oh, 2017 or 26, yes, 2017. 2017 or 16 or 17. I'm sorry. I don't, it's.
Whatever it was in the fall of it.
Yes.
So you had 6, did you obtain certificate of occupancies on all 6 of those units?
Yes, we did.
And so were all of those units inspected for grading at the time?
All those units had final inspections and CO inspections.
Did they pass all of those inspections?
Every single one did.
Did you have any concern about the grading at the time you sold any of those units?
No, sir, I did not.
And were the plaintiffs allowed to inspect the exterior and interior of the residence before they purchased the property?
Absolutely. Every homeowner has an orientation and has a right to walk the house.
Would you just briefly tell the jury how that orientation process works?
Yeah, so in the initial, when they go through the sales process, they're met by one of our agents, and the agents explain what's going to happen, how the lending part works, and then that they have an orientation with the builder or the project manager. The time that it walks, the time it closes is 1 week. We get 1 week to fix any issues that there are. And if they want a private home inspector, we're more than happy to have one. We want to make sure there's code related items. As far as cosmetic items, that's why we do an orientation, and we'll take care of all that. So if they have an orientation on a Monday, the following Monday it closes. We ask them to come in the day before to make sure that that walk list is 100% done. They sign off on that walk list, and we go to a closing. The only way we would never close a house unless the walk list was 100% complete. The only exception to that was if a cabinet door was scratched. I can't get a cabinet door right away. You know, there's an order process. To my knowledge, their walk list was 100% complete when we closed their home. There was no issues at that time, as Mrs. Ibezims said.
Okay, how long after the closing of the purchase of the plaintiff's residence was it before you, Mrs. Ibezims, expressed any concerns to you personally about any grading or drainage issues?
It was at least 5 or 6 months, maybe 7 months. So the house had been around a long time. It went through a whole construction process. There was no leaks in the house. And then it went to, they owned it for, 5 to 7 months. And then I was contacted. I think Ashley, our assistant, told us about it. And then we have construction meetings every Tuesday. And it was brought up in a construction meeting that there was a concern.
And what did you understand that concern to be?
The first thing was that there was yellowing turning on the board on a piece of trim. And I just said that's kind of odd. I asked Chris if he had looked at it yet. He said he was going to go over there and look at it. And he did. After that, Chris had taken some pictures and came back to me and said, hey, there's a void on the left-hand side of the house and we have these other issues. I said, okay. Chris said that the bigger issue was that we couldn't get the trades back over there. And I asked why. And Mr. Ibezims had been very aggressive with it. And one of the contractors I called, and he said he wasn't going out there unless I went out there with him. I said, okay, well, let's plan on getting everybody together at once and we'll knock out everything we got to get done and we'll take care of it. So we set up a time that was convenient for everybody. Mrs. Ibezims and Mr. Ibezims were both there, as they said. And we went and got everything taken care of. We did find a void on the left-hand side of the houses where the two, in every house, in every townhome, it's not flat, as everybody knows in Georgia. There's going to be a step down in the building. So where the step down was at, there was a void there that was not covered. We brought in hydraulic cement. Hydraulic cement is a waterproofing agent that seals voids. Mr. Bism was right behind us. We showed him the void. We showed him a picture of the void. We showed him a picture after we fixed the void. And then we went in, we replaced the baseboard that was there. And to my recollection, the painter was there also. We took care of the painting. And then there was some other, the electrician was there, and there was one other trade partner there. I don't remember who it was. And we were finished. We walked out. Mr. and Mrs. Ibezims looked at everything, and there was nothing said about, you didn't finish this right, you didn't fix this, wait, come back. Said, if you got anything else, let us know. And we left. And so the next thing I did when I was with Mr. Ibizim, I showed him his fence. And I said, you have an issue with your fence. It's touching the ground. And if there's an elevator like this and water comes up, it's going to rise and it's going to come back. And you need to cut this fence at least 4 inches. There was little gaps in the fence. Most of the fence was touching the ground. He said, well, this is how they put it on there. I said, you have to cut this fence. You have to be able to allow debris or anything else to get through this fence, or you're going to continue just to have this issues. Also, this is not your property. This is HOA property. Your property stops at the patios. From the patio on is easement. It's HOA property. That's not yours. So he said he'd contact his fence company. We said, okay. I then reached out to Mike Tolley via cell phone and said, hey man, did you guys approve a fence on this, in this easement, in this HOA property? He says, I don't know. I didn't handle that, but I'll let you know. I said, okay. But I said, there's issues. You got a fence touching the ground. It needs to be cut. We didn't install the fence, and someone needs to come back and take care of raising this fence.
Let's just stop there for just a second. So was that the first time when you received the complaint or the notification of this issue? You ever had, prior to that, did you have any notice?
No, sir. And this is the first time I've ever met them.
Do you recall what time frame this was?
It was summertime. So it was June through August. I don't know the exact date, but it was, at that time, it was summertime.
So the gap that you talked about, that was the first.
The void.
So let's go back to the day you actually went out there to examine the property. Did you go into the house and inspect where the water damage?
I did. I was there.
Okay, you did.
I did. Yes.
Just listen to my question.
Yes, sir.
And then just answer the question and we'll keep going. So tell me what you observed inside the residence describe the water damage.
It was very minimal. The carpet was not wet to the touch. There was not any, so it's MDF wood. So if MDF gets wet, it swells. It's not like MDF is really great in houses. It trims very nicely, it paints very nicely, but if it gets wet, it swells. So I was very surprised, like, man, it doesn't really look that well. So
Trevor, but when you say MDF, are you talking about the baseboard?
yes, MDF is a material for trim. You have solid wood, and then you have it's a press board, but it's used a lot in new construction homes.
Did you remove the baseboard at that time?
I did remove the baseboard at that time. We had, as they said, we had another one brought in, wanted to inspect it. There was a minor moisture on the bottom, and we acknowledged that it was from this void. And the only reason it found that void was because the water rose up because the fence was on the ground. And you could see evident, and I even showed Mr. Ibizim, the evident water line that had been shown on the fence. But we did address the thing and we took care of it. And like I said, the carpet wasn't wet. If the carpet was wet, we would have had a carpet cleaner come out there, would have took care of it. There was nothing like that.
Where was the location of the hole that you had to repair?
If you're looking at the back of their house, it was the left-hand side. If you're at the front of the house, it'd have been the right rear.
So was it near the AC unit?
It was.
Okay. And so how did you fix that hole?
We used hydraulic cement, as that was talked about.
And I'm not a construction person. I know the jury's not.
So we used hydraulic cement. As I said, hydraulic cement is a water-based concrete waterproofer. And stuff dries in less than 3 minutes and it puts on, and this stuff it's a waterproofer. It will not absorb water. So that void, which was probably a 2.5 inch by 3 inch void, where the step down was at, was permanently sealed.
So, and tell the jury why that gap existed.
So you have a step down so you have firewalls. So you have to have a 1 hour firewall on each townhome to create a 2 hour firewall. That's fire code in the state of Georgia. So you have one firewall here and you had one firewall here. Well, when the concrete guy formed it, that void, it's called stucco, and he never stuccoed that part of it to cover the firewall void. So it was just honestly missed, and we took full responsibility taking care of it.
Okay, and then as part of the purchase, the plants were given a limited warranty, correct?
Yes, sir.
Okay. Were the plaintiffs charged anything for the repairs that you made?
Not $1.
With respect to the baseboards that were repaired, tell the jury which baseboards you repaired and why.
The back baseboard we repaired, there was, again, it was very minor. It wasn't soaking wet. It wasn't swollen. But again, there was this yellow tint on it, which I still can't figure out why it did that. But anyways, we wanted to remove it, put a brand new piece in it and paint it to where there was no question, like, well, it might come back. So we put a new piece in it just to alleviate any concern.
Did you replace all of the baseboards in that room?
I don't believe we did. I think we just replaced there was a miter joint and we took it right at the miter joint, which was from if you're looking at the back, if you're looking to the house to the right side to wherever it was underneath the windows, and we just took that section out. We didn't replace everything.
With respect to the carpet, what was the condition of the carpet?
The carpet was still in good condition. There was nothing wrong with the carpet at all.
Were there any smells?
Not that I recall. No. Like I said, it wasn't wet to the touch. If it would have been wet to the touch, we would have had a carpet cleaner come in there and totally take care of it. And there was none.
With respect to your conversations with the plaintiffs about the fence, who exactly were those conversations? Were they with Mr. Ibezims?
Actually, so in the beginning, they were with Mr. Ibezims. And then when we went back in, Miss Ibezims was inside in her dining room table. And I summarized everything again with her there. This is what I've seen. This is what we need to take care of. And there'll be a follow-up email that documents this, because this is an issue. You know, this fence being this low to the ground or touching the ground, it's going to happen again. So you guys need to resolve this, but we'll send a formal email out, which was done.
Did you contact the association about the fence?
I called Mike Tolley about the fence. Yes.
Tell me, did you speak to Mike Tolley about it?
I did talk to Mike Tolley about it.
Tell me what you told Mike about.
So I told Mike, hey, I just met with the Ibezims. I first asked them if they got an unauthorized permit, because at first Mr. Ibezims did vent to me that it was taking a while to get this fence and they needed this fence for personal reasons. So Mike said he didn't know if they got the fence or not. I said, well, the fence is installed, 1, and 2, it's touching the ground and it's creating issues. So that needs to be addressed. Someone needs to cut the fence, or, I don't know. So, but the fence right now is going to create damage to this home, and minor water got in. We've taken care of it. But if a heavy rain comes again, it's going to rise again, because everything is made to slope from the house away. It has to have positive slope. And this fence is not allowing that.
Did the plaintiffs make a claim under the limited builder's warranty?
They did.
Okay. And was Water's Edge Group advised that the plaintiffs had made this claim by the warranty company?
We were.
What, if anything, did Water's Edge Group do in response to that claim?
I'm sorry, repeat the question.
What, if anything, did Water's Edge have to do in response to that warranty claim? Were there any issues that you had to correct?
We had already corrected those issues from that claim. So no, there was nothing that I recall afterwards. They had said that the fence was the issue.
After you learned about the water issue, did you do anything to inspect the grading behind Plants Road?
I did. About a week to 10 days afterwards, I had our landscaper come back out there with me. And I think Mr. Ibezims was there with his phone. And we have what's called a transit. Transit is a measuring device that you have it on a tripod and you look through the scope and you have this stick and you measure what's going on. And we measured. And so if let's just use a number 90.
Let's back for a second.
Yes, sir.
I want you to do as carefully as you can, like orient yourself to where you were on the property.
Okay.
And what you did to measure.
So we started so I know that there was runoff from the patio running to the edge of the patio. There's a 2-inch slope on it. That's just a common thing. And there was never water standing on the patio. So it wasn't like the patio was running back towards the house. So we set a transit up by his fence where I can run it to the center of the swell. And I said, I want to show you that there's positive slope here. I had a pad. We shot the top of the patio, and let's just say it said 94. So the next number has to be lower or higher. So the number had to be 95 because you're going down in numbers to make it have fall. Every single number went down there. There was nothing ever negative, even besides the AC, we shot it and it had positive fall. There was nothing that was running back towards the house. And I'm pretty sure he was there with me.
How long did it take you to do that?
20 minutes, not that long.
So the plans filed a warranty claim. Waters Edge went out there and corrected some defects that were noticed in the warranty claim. Is that correct?
Yes, sir.
Okay. Were there some items in the plaintiff's warranty claim that Waters Edge or that were determined that were not to be Waters Edge responsibility?
There was.
And all of those were. Any of them that related to the grading?
That the fence was in the drainages, or the fence hadn't had proper clearance underneath it.
That was your understanding what the warranty company determined?
Yes, sir.
Okay, so after the warranty claim was filed, after Waters Edge went out there and corrected all of the warrantable items that were determined, when was the next time the Waters Edge Group received a complaint about water from players? To your knowledge?
To my knowledge, after that, it was being handled by Ian and QVW. So we deemed that construction deemed that we fully took care of what we were supposed to do in that home. That if they didn't raise this fence to have proper clearance, this was going to be a common thing that was going to continue to happen.
So as far as you knew, the issue had been resolved?
Yes, sir. We cleared it out of our system as far as construction.
So with respect to the third party defendant, let's shift gears for just a second. Does Waters Edge Group believe that they caused on the issues related to the water and grading?
Yes.
Can you give some examples of why you believe that?
For several reasons. I'll start with the first and most obvious reason. They put a fence in their drainage easement. And there's obvious pictures. I don't know how many pictures we've seen of there's water that rose at least 3 or 4 inches on that fence. So they properly did. The second thing is the swell. If it's improperly taken care of, it's fully their responsibility. We were builders erecting townhomes, single family, or call them single condominium homes. We had nothing to do with the development, nothing to do with any of that. And the pads were pad ready. And in a townhome pad, there's different pads. I can't remember the size, but 24 by 40, 24 by 50. That's the pad size. That's all we can use. You can't go outside that. That's drainage. That's common ground. That's, utility easements. We built in that pad. And after that, it sloped off and it goes to the stormwater.
Let's go back and talk about the removal of the organic material from the pads after you purchased the property. tell the jury exactly and as precisely as you can what the scope of your work was on the building pad first, and then second in the common area swale.
They're kind of the same. There's rusted vegetation there that we have to remove. It's a very minor amount. And it's hauled off. It's thrown in a dumpster. It's not stayed on site. We don't bury it. It's hauled off. The drainage swell is the same way. You know, you're buying a brand new home. You're not going to want to see weeds and bushes and, you know, growing up overgrowth. It's very lightly cleaned off and nice looking pine straws installed.
Did you do anything to change the grade on the building pad?
No, sir.
Did Water's Edge Group do anything to change the grade on the common area drainage swale?
No, sir.
Do you recall if there was a drainage manhole in the property?
I do.
Okay. Where was that drainage manhole located?
In between buildings 30 and 31, closer to 30 than it was 31.
So if we're standing at the back of the plaintiff's residence and looking out, which direction is?
To the left.
To the left.
Yes, sir.
And then where is the swale located?
It's in between their the center of the swell is in between their patio and then the hill bank that was behind it.
And why was there a swale necessary behind the plaintiff's residence?
The swell is necessary so when developments happen, again, they have this pad, engineers calculate what this swell is supposed to be to take the roof water off of the houses. It goes into the swell and then it goes into the drainage system or into the manhole cover.
And tell the jury as specifically as you can what Water's Edge did with respect to grading away from the building to align that grading with the swell.
We have positive slope to the swell. So, you know, when you're setting a house, you have a 2x10. So you're 9.5 inches above the grade that it's going to go to. So we had our thing is we have to have positive slope from the house, from the edge of the patio to go to the swell. And to this day, I know it's still there.
So, and that's something, is that something that would have been measured or inspected at the time of the certificate of occupancy?
Absolutely.
Would you have been able to obtain a certificate of occupancy if the proper grade is not been made?
No.
And you obtained certificate of occupancies for all 6 divisions?
Yes, sir.
And the measuring is done by Water's Edge and you say, look, we measured it, or the measuring is done by inspectors and they say, we've measured, we'll sign off on this.
If there's a doubt in the inspector's mind that the minimum grade's not had, they will tell you to get a transit out and you will have to shoot it in front of them. This was not the case in any of those units.
So to be clear, there was never a doubt in any of the inspectors' minds whether the grading was adequate on those units?
No, I was never told of any issues at all. It's the CO, the project manager, every Tuesday's meeting, they talk about COs because we have to get those to closing attorneys because they have to full title and they want to make sure it's all right. And there was no issues on that building. It went very smoothly. Inspector came out, CO was brought in, CO was processed. Certificate of occupancy.
When you inspected the property prior to beginning construction, did you walk the swale?
I walked the pads and I could see the swell, yes.
And tell the jury what your opinion was regarding the alignment and grading on the swale.
They had positive slope. It had everything it needed. It wasn't backfalling. It fell away from the building. It was not obstructed. There was no issues. And if there would have been issues, I would have brought them up to GeoSam because we had no money for any type of grading. It had to have been done by the development or the person selling the lots.
How are you able to tell by looking at the swale that it has what I'll call the capacity for the runoff? I hear you about positive flow, right? It's flowing in the direction we want. But you then put a giant box with a sloped roof off of which flows lots of water that didn't necessarily flow into that swale. It just fell on the vegetated pads before. So what's the math or the eyeballing you do or someone did to say, not only does the swale slope positively towards that drain, but it's big enough to hold what we'll be pushing into it from our building?
Oh, we can answer that. So that's part of the final plat process. That's when the inspectors with the developer walk out there and they have to shoot those pads, and then an engineer goes out there and shoots the grades and they verify that stuff. A builder doesn't verify that. They
Inherited the green light for that swale.
Yes, sir. The green light was done through a final plat process. And that's what Gwinnett County does through that. It's nothing that a builder is going to go back out and get a certified engineer to go, hey, is this right? That's the checks and balances. Is there's probably 5 or 6 stamps on final plats that says it went through these divisions and it was approved and signed off on.
What about if the swale's been sitting out there undeveloped for 10 years, and things have been growing on it and whatnot? I appreciate you said the Bobcat can remove that top layer of vegetation, but is there not some expiration of plat certifications? Or once there's the plat, 100 years later, you could go out because there had been a real long recession, and so no one built on it for 100 years. And then you roll up and say, Water's Edge is going to build a townhome here. That plat and all those certifications still apply?
I think that's at the county's discretion. That's not something that, like you said, 100 years. Yeah. I mean, the county's going to go out there and take a look at it because there's going to be infrastructure issues and stuff like that. But that's at the county's discretion.
You'd still have a plat.
Yes, sir.
And as far as you're concerned, that's the ticket that needs to be punched, or the ticket you need to be able to start building.
Correct.
But you also had to submit a plat for approval to actually construct the building, correct?
We have a survey that's done. It doesn't show slopes or volumes or stuff like that, but yes, you have to have a survey. And then the survey, then there's a foundation survey that which goes to the attorneys for recording.
I want to show you some pictures now, really quick, see if you can identify these pictures.
Sure.
Take just a second.
Mm-hmm.
You've seen these before?
Yes, sir.
Your Honor, I'd like to introduce defendant 38. 38, I'm sorry.
Yes, various photographs of drainage swale area. Any objection, Mr. It's a good late afternoon thing to see. Mr. Stewart, any objection to defendants 38?
Oh, yeah.
And Mr. Dorsey, Ms. Wilson, I don't know who's handling it. Okay, admitted, you may publish.
Thank you. Here we go. And Mr. Schallbar, to the best of your recollection, did you take these pictures?
I did.
Tell the jury what this is a photograph of.
It's a photograph of Mr. and Mrs. Ibezims' fence that's touching the ground. And it's in the drainage easement. You can see where it's swelled and the swell's going up and it's hitting, it's in the easement.
We see something here that wasn't present on earlier photos, meaning photos from 2019. If this photo contained a little bit more to the left, we'd see the concrete slab, the patio for the next unit up.
Yes, sir.
And historically, we got to hear a lot about this. This drainage pipe stopped about 2/3 of the way down that patio, but now there's this brown extension and it dives into the ground. Any idea what that is?
An idea is from hearing testimony, HOA came and put these drainage pipes in. Water's Edge Group never did any of that.
All right, none of that is remedial work that
No,
Water's
sir.
Edge.
We would have never
engaged.
done it.
And there's it looks like, is that a drain at the end of the thing?
Yes, at the back of it, there's a catch box there.
Did that exist when you guys were?
No, sir.
So I want to see if we can make this work because we paid a lot for these touch screens. Tap the screen with one finger. Now see in the lower left-hand corner, there's a circle with a pencil in it. It's blocked by the microphone, lower left-hand.
Oh.
Real good with you. Okay, just move the whole screen. A little bit out. Now do that tap again. There you go. Now circle with your finger what was being asked about.
Boom.
For the pastor.
Mhm, that's what he said. I saw that.
Right, we've amortized like $10 of the money we spent on that touch screen.
Mr. Schulbar, does this picture reflect your criticism of the fence? Or does it show what you were talking about, what you're concerned about?
Yes, absolutely it does. I mean, there's a lot of other pictures. Well, yes, this is one of many that you got a fence that's touching the ground, you have a fence that's in an easement that they took no regards to.
Let's keep going.
Do I need to exit you? Do I need to exit you out?
No, but you get to erase that circle. There is,
Do I hit the X button here and
no,
whatever?
don't do that.
Okay.
On the little panel on the left-hand side, there's an eraser button. If you click on that, yeah.
Oh, he said he wants to do it.
But I think we're at the same picture, Mr. McLeod.
Yeah, I'm trying to. Let's do this. I guess we're gonna do these one by one. That's that a picture of the drain we talked about.
Yes, sir.
Now we switch it over.
Another picture of the fence as well.
Mm-hmm.
You need to say yes or no.
Yes, sir. Sorry.
All right.
I listened enough to know that. My bad.
This is in the swamp.
Another picture.
Yes, sir.
This is in the swamp. Electric, never could.
This is another picture, right?
Yes, sir.
When were these pictures taken? You think that's the resurrection?
So the video I did was like 2020, but this isn't the video. So this had to be 2018-ish. I mean, yeah, 2018
This would have been after.
after it. So yes,
This would have been after the remedial work.
right. So 2019, because 2020 is when I took the video. So 2019.
And this is a picture of the swale, correct?
Correct.
And then what is this a picture of?
That's a picture of a non-maintained drop inlet, which is in between buildings 30 and 31.
Did 31 flow down into this as well? In other words, it was a V, or 31
Had
continued
another
on down the hill?
Yes, sir.
Okay. So if this didn't work, then some of 30's water could get to 31.
Yes, sir.
So this was as designed with the entire drainage inlet for those two buildings, for the water.
It was designed mainly for building 30. There was a minor, small common area in between the two buildings that water went into, but the other water for building 31 had another one downstream.
So as approved by Gwinnett County, this was where all the water was supposed to run to for building 30.
Yes.
And then it would go into that pipe and out to the community.
It would go somewhere to some detention. I don't know what detention it went to. I don't know if it went to a stream, a creek, or there was a detention pond on the left-hand side. So I don't know where it goes. But that is where the retention water is to be funneled to.
Okay, now I want to, the video you just referenced, I'll show that to you. I'd
Mhm.
like to admit, E41. Any objections?
What is D41?
4-1,
D41.
okay. How is it, how are the lawyers supposed to know how it's different from 40?
Let's see, 40 is the timeline. I believe.
Okay, your exhibit list just, it has 40 and 41 is the same thing.
Okay, you didn't get the updated.
Oh, okay, typical. So 41, any objection, Mr. Stewart?
Oh, yeah.
All right, Mr. Dorsey, 41 is admitted. You may publish. If it has audio, make sure you click the little box in the corner, sharing your screen.
But it's not being published yet.
I think you're going to talk about this now.
Let me ask this while you're working on that, Mr. McLeod, how much more?
This is it.
This is it? Okay, let's try to make it happen.
Let's start over.
After the pad, the one with LT, more LT. Look at the L pattern on the LT.
So, Mr. Chambal, you took that video, right?
Yes, sir, I did.
When did you take that video?
It was in 2020.
2020. What was the purpose for you going out there to take the video?
Ian and I had discussed after a heavy rain to go out there and take a look at what's going on. So I drove out there and wanted to see two things. One, if there was ponding or pooling of the water, and if just what the drainage easement, what the easement was doing as far as was pine straw washing all the way down it after a heavy rain, what was going on. And they had already, Tully had already done drainage, put some piping in and stuff. So I just drove over to see what was happening. And, besides the fence was still on the ground after several years, which again is the issue. I just sent a text to Ian about it, and then
What was the weather like that day?
it was very rainy. That's why we went out there.
And what was the condition of the drainage that day?
It was fine. I did not see any stoppage or issues besides if it's going to have a heavy rain. I didn't go inside of his fence. I don't want to, get shot or, because I'm inside someone's fence. I just want to see what's going on, but I'm sure the water was inside there too, because you can see in the picture, it's hitting the ground. So if heavy rain happens, it can't get out.
You didn't see a heavy flow of water through the swale.
No.
That's all I have, Your Honor.
Can you play it one more time? It looked like there was a lock on the gate. What, do you recall if there was a lock, or if we watched this?
There is.
Can you look to see if that's a lock? We just have had discussion about whether this was locked, so I'm curious.
Yes. And
I messed up my cross.
Oh, you will? All right, great. So never you mind. Hmm? Oh,
you want me to play it? Or?
well, you may be the technical operator for Mr. Dorsey, but I'm gonna let Mr. Dorsey, your cross isn't too long because we're hitting the 5 o'clock
I
hour.
understand, and if we need to break it up.
Okay. If you don't mind starting with the video part, because that may be where okay.
Mr. Shotwell, I'm just gonna ask you a couple of questions while we've got this video up on the screen. I'm gonna start while we get settled in. I just want to confirm that, in your opinion as a builder, that swell and that drainage system outside the fence is working as designed in that video and what you saw, correct?
In my opinion, yes.
Brendan, are you ready to look at the video? If you will, can you put it to 8 seconds, please?
Cool.
You're doing pretty bad on your baby. Let's see if
Why don't you ask some other questions while your tech analyst works through this?
I'll do that.
Here
Here we go.
Okay, stop at 8 seconds, please. Actually, yeah, let go. Right there. Mr. Shotwell, you were out there at the residence, correct? You
Yes, sir.
took this video.
Yes, sir.
This item right here on the side of the fence, is that a camera on the fence?
It is.
And when I say camera, I mean it's a home surveillance camera, right?
Yes, Mr. Ibezims met me out when I was walking back to my truck and was recording me and saying, "What are you doing?" And I didn't talk to him. I just got back in my truck.
Okay, and I apologize, I can tell you can't see. Right here, home surveillance camera. Fast forward to 10 seconds, please.
Sure the door is locked.
A little more? Yeah, go a little more. Right there. Ooh.
So it's about at 11 or 12. Right there. It's a lock. And it's locked.
Is that padlock on there when you were there that day?
It is.
And is that what I'm looking at, is indeed a padlock on this fence?
Yes, sir.
And we did see a camera on this fence previously?
Yes, sir.
Yeah, all right, I can proceed with a few more questions or we can break.
Do a few more questions.
Okay.
When I feel like you're at a natural breaking point, we'll stop because we have Mr. Stewart's cross-examination as well. We won't get through all that today.
Understood. I just want to clear up a few things discussed on direct. You testified earlier that you bought these lots from Geosync, correct?
Yes, sir.
And they were pad ready and the water the water drainage system had already been installed, correct?
Yes, sir.
Is it your understanding that Portrait Homes, the original developer, was who got the clearances, we'll call them, for the drainage system and utilities?
It is now, yes.
So anything to do with this swale or the drainage or anything like that, that goes back to Portrait Homes, correct?
From my understanding, yes.
And you testified earlier that y'all came in, you brought in some light equipment, that being a front end loader, correct?
A Bobcat, nothing monster heavy. You can pull it behind a 3/4 ton truck.
Okay.
Not bringing low boys in.
Exactly.
A low boy is a semi that has a big tractor on it that you're bringing a big industrial piece of equipment in. Nothing like that.
And in doing that, you scraped off the top layer of soil, and you said you did clean out the swale and just that undergrowth that you've grown up over the last.
That's correct.
So is it fair to say that by the time you left the project and you sold the property, that the swale, the drainage system, and the pads had all been cleaned out, so they were nice, pretty, and spick and span?
Yes.
You would agree with me that it was Water's Edge Group's responsibility to integrate the displaced water into that drainage system, correct? And we talked about the slope and just making sure that all the water went.
Positive flowed into the drainage system, yes.
And that applied to the driveway and just a little concrete pad as well.
Correct.
When someone would have gone to purchase one of these homes, if they walked out on the back patio, was it pretty evident at that time that that was a drainage swell that was down?
Yes, I mean, it drops off. I mean, you can see it in the pictures where it goes down.
So irrespective of rainfall, a purchaser, as they walk out onto that back patio, would have seen a massive hill from the other side, slope from their side, and a ditch. Let's call it a ditch.
I agree.
Okay. So they would have known that that's where the water's going,
I would think so, yes.
just like the ditch on the side of the road where we all know the water goes, right?
Mhm.
Is that a yes?
Yes,
And at that time, it was all clean, everything was doing what it was supposed to, right?
yes.
And then at some point, you got the call, there's some water coming into the house. You go out, and I don't want to rehash all of it, but you put in the hydraulic cement, you make your repairs, correct?
Yes.
And based on listening to your testimony, it sounds to me like it's your opinion that that is a separate and distinct item of damages and issues, as opposed to really what we're here about today, the water that's flooding the backyard. Is that fair?
Yes.
Would you agree with me that Waters Edge Group never had any contractual arrangement or agreement or relationship with the association?
No, we never had a relationship with the association.
And same question for Tolly Community Management. Do you agree with me that Waters Edge Group never had any contractual relationship with Tolly Community Management as it related to this problem?
We had no contractual obligation.
I think from hearing earlier, it's your opinion that that fence entrapping the water inside is the sole cause of all these issues, correct?
Yes, it did not allow positive drainage.
Nothing further this time, Your Honor.
All right, ladies and gentlemen, we're going to stop unless, Mr. Stewart, you tell me, you said 2 minutes in the past, but that may not be this witness.
It won't be more than 15, 20, but I must wait tomorrow because I know they're not.
We're going to. No. If you had said, no, it's 2 minutes, we'd do it. But anything more than that, we'll start fresh tomorrow morning. Ladies and gentlemen, it's Thursday. You should know that these lawyers aren't going anywhere. We're going to have what we call our charge conference tonight. So we don't make you sit around while we do that. We're going to talk about the law that the lawyers and I think apply to this case. That's meant to buy us about an hour tomorrow so that you're not waiting around while we do that. I don't know that you'll get the case tomorrow. It depends on how much more Mr. McLeod has. He'll rest. I have to have a few arguments after he rests, and then we'll see how much Mr. Dorsey and Mr. Kyle want to put up on behalf of their clients, if anything. They have a right to put up nothing and rely on what they got out through cross-examination. Even if that finishes around lunchtime, we still have to then have closing arguments, and these are talkative lawyers. Those will take a little while. So I don't know that you'll be presented the case before you're going to want to leave tomorrow. I'm going to talk with the lawyers tonight after we finish our charge conference, but I just want to manage your expectations a little bit. We'll see. We also don't have to stop right at 5 tomorrow. We once you get the case, you control the time frame, other than when it's quitting time, because the deputies need to get you out of the building at a certain time. But if you can arrange your schedule where you can stay a little bit later tomorrow night, that's time you can have. I don't bring you back on the weekends. No one's going to get hauled in here on a Saturday. But if we don't finish tomorrow, then it does mean coming back on Monday. If all that remains is deliberations, you may say, great, we'll be here on Monday, but we'll be here at 10 because I need to do X or Y in the morning. You very much control the clock once the deliberations begin. I just share that with you so you know what to expect when deliberations at last begin. And they may begin tomorrow at some point, but as I said, with closing arguments needing to fit in as well, I don't have a high degree of confidence that you'll begin your deliberations tomorrow. TBD. With that, any logistical questions? Hearing none. Remember, don't talk about the case. You have a card. Too soon for juror questions. Because we still have Mr. Stewart needing to do his thing. He may give you more things to write down. So hold on to your cards, put them in your notepads, go back there. We'll try to replenish the snacks if you haven't run us dry on that. And we'll see you tomorrow morning. 9 a.m. is when we would love to start, okay? Thank you so much.
My boss.
I'd say we need double snacks tomorrow.
They're focused on the snacks. I'm gonna have to send an email.
Can I get down, sir?
You may. Thank you. I didn't mean to leave you hanging there. So we're still on the record. Let me ask, I'll start with Mr. Stewart. I plan on shutting down the Zoom. There's actually a live feed as well. People are able to watch the trial on YouTube. I'm planning on shutting that down for the charge conference, not because there's anything confidential about the charge conference. We just don't need to keep that running. And I was planning on excusing Mr. Casañas because we could memorialize any objections later, but that's up to you all. The Zoom feed I will cut off, but you can decide whether you want the charge conference taken down or not. Do you have anything beyond those two? No more Zoom, no more Mr. Casañas, anything else?
No, just at the end, after we finish conference, then we could give our objections or whatever to the charge tomorrow, whenever it is.
Right, so you'll want to jot down what your objections are, and we'll start 8:45 tomorrow to get those on the record, but we can do the hashing through all that without keeping Mr. Casañas here. That's my suggestion. Sounds like you're all right with that. Okay, Mr. McLeod, all right with that?
That sounds great.
And Ms. Dorsey, okay, great.
Let me ask one more question. Tomorrow they'll call their witness and everything, and Tia will probably be here tomorrow, but she would not plan to go back to work on Monday if we go to Monday or not. Are they planning? I don't know, does she need to be off tomorrow? Are you gonna be here tomorrow? Okay, so if they're gonna call it.
So, and Ms. Ibezims is free to not be here any days either. She's testified. You just would need to let the other parties know if they were seeking to recall her. Yeah, but if she'll be here tomorrow, then all the folks who you have said will be here. Monday, if all it is deliberations, of course, everyone is welcome, but no one is required to be here other than at least one lawyer for each of the parties.
And
Okay.
right now, it's all right to have the clients go ahead and leave.
Of course, it's up to them whether they want to stay for the charge conference. You can tell them how boring it is and they can stay, or they can get out of here.
They can get me in there.
Mr. Stewart, is there anything else you want to get on the record before I have to go print out the charge anyway, so you're going to get a couple minutes, but anything you want to get on the record?
Oh, yeah.
Okay, Mr. McLeod, I got to interrupt you for a sec. Anything you want to get on the record before we break for a couple minutes, because I have to go print out the charge and get it to you. Okay, you'll have Mr. Schonkweiler here ready to go a little before 9 tomorrow? I saw the thumb up. All right. Mr. Dorsey, anything else before we let Mr. Casañas go? All right. Mr. Casañas, your predecessor had to get all this stuff on the record. Do you need to get them to answer any questions, or are you just able to say we're going off the record?
Order a transcript.
Okay, well, you should ask them now.
Order the transcript for anybody?
No.
Not for plaintiffs.
No. Mr. McLeod, transcript from today?
Not today. Thank you.
The record by 4 p.m.
Will you be back here tomorrow or another Veritex person? You, excellent. Continuity is a good thing. Hey, Sarge, you're covering now?
Yes, Your Honor.
Okay, I'm sorry we're going a little late. We'll be here for a little bit. It'll be pretty low key. Do you mind looking in the jury room to see how many snacks are left? I have to send an email to my staff. And I heard the jurors saying like, oh, snacks are low.
Okay. Bring some of them out here.
But if you want to pay for them, you're already eating all those butterscotch things.
I know.